Lord, may I have your lordship's kind leave, Lord?
Mentioning only on Thursdays and
Lord,
Mondays.
only one urgent matter, because your lordships may not be able to take up the matter. Lord,
Even then,
this
even
is relating to election
no,
of
Mr.
Alipur
Chakraborty,
Bar
only
Association, Lord.
Mondays and
We could get it
Thursdays.
assigned to Lord.
No, call on the list.
For judgment, item number 1.
Hence, both the issues of reference are answered in the positive as follows. A challenge to an improper rejection of nomination in connection with an election process under Rule 5(1) of the election rules in the present case is amenable to the challenge in a writ petition under Article 226. The objection raised by the writ petitioners respondents regarding the rejection of their nominations falls squarely within the parameters of Rule 5(1), and as such, the reasons therefore can be inquired into by the writ court. Since the limited charter of this court is to answer the 2 points of reference extracted from the points of difference between the 2 honorable judges of the concerned division bench, I would desist from commenting further on the ultimate outcome of the appeal and how far the division bench can interfere with the limited confines of an intra-court appeal. This court, it is to be remembered, is not sitting in appeal over the judgment of the learned single judge, but is merely designated to answer the limited points of reference. Hence, returning the findings on the points of reference as above, the matter is sent back to the Honorable Division Bench, taking up the appeal for taking a final call on the outcome of the appeal in the light of the answers to the reference as given above. Let the file be sent immediately to the concerned Division Bench for final hearing in the light of the above answers. Liberty is given to the parties to mention before the Division Bench.
I know, my lord, this is not the mentioning time.
Mr.
Only
They cannot
question
make
is only
I
question
cannot
is
make any
35. 35, my lord. Your
cannot
leave
make any
matter, my
exception.
lord.
No, Mr. Dey.
Demolition will be, my lord.
Mr. Des, I'm sorry, extremely
Yes,
sorry.
ma'am.
Let me
But
take
I
up matters if I can reach. Yes,
Yes.
call.
We mention item number 2 for filing written notes of
I am
today was
on behalf of the
File the
petitioner,
written
we are filing the written notes.
File
Today,
the-
at 8:07, we have received the there.
my mother was admitted in hospital.
Should I keep it? I'll keep it day after tomorrow. File a written notes then.
No, I have ready, my written
Then
notes
I'll
is
take,
ready.
take and close.
Only I could not, they deal with their, the citations. Only
If you want to deal, Mr. Dottu, you have to take your call. Either you deal with them, take some time, or we file it today.
then in tomorrow, tomorrow.
That is what I suggested.
My lord.
Let the matter stand adjourned till tomorrow to enable learned counsel for the petitioners to respond to the written notes of arguments for the ECL. কালকে একই heading এর same heading.
Sorry, the inconvenience caused because
Cause for my delay.
What inconvenience? No. This is the duty of the court, Mr. Dottu. Yes.
Top item, item 3.
পরেরটা ready রাখো. Yes. Yes, Mr. Gupta, quick.
My lord, your lordship may kindly look to the earlier 2 orders.
Right.
That was on 21st February and the second was on 28th.
Oh, West Bengal
It tells, my
certificate.
lord, that
And you also directed me
all
to
the
produce
things are
the
illegal.
advertisement copy of that. One more submission, Your Lordship. On it,
So you should please give a copy to them also.
yeah, not sure.
Otherwise, they won't be able to respond.
One more submission, humble submission.
Yes,
Your
yes,
Lordship.
Mr. Yusuf, yes.
My written instruction is that the petitioner qualified for the appear before the interview board, and he has been called for in the course of the time.
Thank you so much.
Yesterday I found in the website that
And Your Lordship, I am can Your Lordship allow me to place the
Yes.
report?
Which portion of this do you? Yes. What should I look into for the present purpose?
It was also asked for the
This is only for the
qualification.
qualification, right?
Lordship. Second page, Your Lordship. I need to qualified, Your Lordship.
Second page?
Qualified. Second page, Your Lordship.
Oh, right.
D. Qualification as per recruitment rules. And he found Your Lordship is suitable.
So it's or here also.
Lordship.
So he qualifies. Thank you so much, Mr. Yusuf.
May I place this report, Your Lordship?
I'll keep it on record and record that he has been called.
Yes,
And
Lordship.
I'll allow the petition
Right,
also.
right.
this we find recently from the website that they have shown
Send message.
page 44
Who
showing
chose
this-
the font?
yes.
Who chose the size of the font?
Yes.
No, I'll keep it on. Learned counsel for the respondents, comma, in his usual fairness, comma, hands up a copy of the concerned advertisement for recruitment of dental surgeons and submits that even in the opinion of the respondents, comma, the qualifications permit the petitioner to be called for the concerned interview for dental surgeons, comma, since the regulations permit registration as dental surgeon in West Bengal State Dental Council or the DCI comma, alternatively. Full stop. Learned counsel for the petitioner also hands over a copy of a printout from the website which indicates that his application has been successfully approved. Full stop. Appreciating the fair stand of the respondents, comma, WPA 772 of 2024 is disposed of by setting aside the refusal by the respondents to call the petitioner for interview as a dental surgeon. Full stop. Next para. No address to cause surgeon certificate. Thank you.
If your lordship may kindly give a period that within which they will call.
That was a limited scope. They will call with the others. I mean, now there is no bar. Why should they unnecessarily?
But if a time is not, my lord, then
No,
only
no, not in every matter, Mr. Gupta. Why should I make a?
It's not in because interview. If why I say, my lord, kindly have a look to the
Mr.
page,
Yusuf, please ensure that
No,
it's called
sure,
quick.
sure.
because the interview in
Call on the next matter.
others.
In written, written
Upgraded
instruction
matter,
has to be
item
followed.
4.
Yes, for who is appearing for the petitioner?
Petitioner.
Yes, Mr. Lady.
My lord, your lordship may be pleased to recall the last occasion.
My lord, I am praying a short passover, my lord. My lord, I am praying a short passover on behalf of Mr. Royan Banerjee, my lord.
No passover. Yes.
That matter,
Item 2, no passover. Sorry.
it is that matter, my lord. The work order was issued to the private respondent. After that, my lord, my financial bid was opened.
Yes. What is the instruction, Ms. Dhamali?
Yes, my lord, the instruction is not with me. It is Mr. Banerjee, my lord. For such reason, I am praying a short passover, my lord.
No question of short passover. That creates an uncertainty.
And my lord, they have also quoted the totally low rate. That is the second issue.
Yes, and secondly, yes, TDS was not included.
Yes, the absolutely low rate. And my lord, may I
I'm
just-
waiting, Ms. Dhamali, for Mr. Banerjee.
Yes, my lord, I am trying to, my lord.
You should also have instruction. Since you have instruction to ask for time, you should also have to have instruction regarding the main matter.
My lord, but
It was the only point on which it was.
yes, my lord, Mr. Banerjee is coming.
Fourth matter of the day, you are not there. What is your
Two
instruction?
allegations are there, my lord. First is that the financial bid was opened after, my lord, the work order was issued. We have checked up, my lord, from the records. It was much earlier, to the 17th of November 23. It was opened, and work order was in January. So that point is not incorrect from the records.
And what about
Second
TDS?
point is, my lord, regarding undercoating. On undercoating, my lord, there was a previous decision that the parties will include the GST and TDS element in the bid so that there is no negative impact on the bids.
Right.
Now, what the petitioner did, my lord, he included the TDS. He did not include the GST. The L1 bidder who is selected, he included, my lord.
Mr.
nothing.
Banerjee, then I'll have to file a short. I'll
Yes,
directly.
My lord,
because,
may I just-
because both of them have undercoated, my lord. Petitioner has not followed one requirement by including the TDS.
Gave TDS, another
But
gave
the
this.
other one was not included with the petitioner, and both of them they have a negative impact. And
Then
the
both
rates-
have to be rejected.
No, not
Why do you choose one of the?
they chose because the petitioner was previously not continuing this contract, the same contract. He had
Yes.
given us letters that he is not willing to continue at the previous rate, so he will discontinue. There was a pressure on us. We had to engage somebody. Now everybody participated, my lord. Since both of them, my lord, did not include, we have calculated, my lord, that even if the rates are included, my lord, the L1 becomes L1. Even then, petitioner's rate becomes much higher.
You have to explain
So
that.
I'll explain.
My lord,
Learned
may I
counsel.
just
No, I'll
explain?
direct affidavit.
What has started?
Kindly
Let
for
it
short period, my lord.
Short.
Till then, my lord, this.
No, he has
My
already
lord,
taken
my lord.
charge.
My lord, may I just show one
What
thing?
cannot stop?
My lord, only one thing, my lord. I'm not asking for that, my lord. What my learned friend has submitted, it is possibly not correct, subject to correction, my lord. The record clearly
We
shows.
cannot speak on the air, Mr. Lahiri.
No, it is
They are
document.
entitled to affidavits.
My lord,
No,
just
no,
document
uploaded
says.
Learned
uploaded
counsel for the
letter.
respondent submits that both the grounds taken by the petitioner cannot be accepted. Push up. Insofar as the first ground is concerned, comma, it is submitted that the work order was issued much after the financial bid opening. Push up. Secondly, comma, it is submitted that both the petitioner and the private respondent were deficient in their bids inasmuch as either the GST or the TDS was included by them respectively. Full stop. However, comma, even taking into account the said deficiencies, comma, the private respondent remains the L1 bidder. Full stop. Next para. That apart, comma, the respondent submits that the petitioner had expressed willingness to discontinue the work, for which there was pressure on the respondents to uh, uh, float a tender and to allot the work to someone else. Full stop, next para. Learned counsel for the petitioner controverts such contentions. Full stop, since factual allegations have been raised by the respondents, comma, the respondents are directed to file their affidavit in opposition within a fortnight from date. Full stop, reply if any shall be filed 3 days or 1 week.
1 week, let it be 1 week.
Uh,
Documents possible.
Reply if any shall be filed within 1 week thereafter. The matter shall be listed on April 2, 2024 under the heading upgraded matter.
Grateful to your lordship. Extremely great.
Item 5 and 6.
Yes.
For the petitioner, your lordship.
I'm
What is
led,
the? Yes.
led by Mr. Dheeraj Trivedi, Lordship. I'm praying for not today.
Refused. Refused. Yes. Yes, Mr. Addo, what is the matter?
Yes, your lordship has last passed an order to file a supplementary affidavit. I have prepared that I have served, but I could not get the reply as per your lordship's order. They have filed also a affidavit in opposition, but I still not get that. Your
Mr.
lordship.
Trivedi has not come to court. He has not come to court.
He is on his way.
On his way.
Yes, Lordship.
From where?
From his chamber.
So why are you asking for not today then?
No, there's a change in brief because now all the briefs are handed over to him as a DSD.
He was ASG. Oh,
Yes.
he ASG.
No, DSD.
PhD.
Because,
Acha, acha, very good.
Yes, Lordship.
Mr. Addo, then he will be handicapped. He's appearing for whom?
CBI.
CBI. CBI is also a party here.
No, your lordship.
What CBI?
Director of Census is the party, your lordship.
I am appearing on behalf of item number 6.
Oh, acha. Two matters are there.
My lord, item number 5, my lord, Miss Sushmita Chadha is appearing for the respondent number 7, my lord. I am praying for a very short pass.
Mr. Addo, I'll take this matter up tomorrow. I'll give them as last chance. the
Yes, your
respondent.
lordship. Deeply obliged.
Adjournment is sought on behalf of some of the respondents in both the matters. Full stop.
বলছি।
Accordingly, as a last chance to the respondents to appear and contest the matter, the same is adjourned for the day and shall next be listed tomorrow under the same heading. Supplementary affidavits filed in both the matters today be kept on. But this is your last chance, please inform.
Your lordship, the
Yes, Mr. Addo.
supplementary affidavit is did not file to me, your lordship. The opposition affidavit in opposition.
I don't understand, Mr. Addo. You have filed the supplementary.
Yes, your lordship. As per your lordship, I have filed that today and I
Yes.
have served them already, your lordship.
Yes, so what?
And in your lordship's order that they have some allegations on the.
But if they choose not to file any objection, then it's their choice.
Lordship, in item number 5, I'm appearing for the state, Lordship. May I file my affidavit in opposition?
After everything is over. Item number 5 WPA number ta diye affidavit in opposition filed by the state in item number such and such today be kept on record. Mr. Addo, what about reply?
My lord, may I file?
Yes, I have.
Bring a copy now.
Lordship.
Why?
They did not file a copy earlier to me.
Why?
Lordship, it's my fault.
একটা line add করে দাও. It is unfortunate that the state hands over a copy of the affidavit in opposition here and now to the learned advocate for the petitioner. Such practice should be deprecated and copies of affidavits in opposition should be served prior to the matter being taken up. Next para. In any event, comma, to grant an opportunity to the petitioner to use a reply thereto, comma, the matter be placed in the list under the same heading on March 12, 2024. 2024. So, আগে যেখানে বলেছি appear tomorrow, ওইটা কেটে দাও. It will appear on 12th March. Use your reply till then.
Yes, you deeply oblige, your lordship. I will.
কিন্তু ওইটা রেখে দেবে যে রেসপন্ডেন্টের লাস্ট চান্স.
No problem.
Call. Next.
7.
Lordship, I appear for the Union of India in this matter, Your Lordship. I'm sorry, there's a technical problem. I'm not being able to switch on my camera.
You are appearing for? Who are you and who are you appearing for?
Lordship, I'm Advocate Rashmi Bothra. I'm appearing for the Union of India, Your Lordship, in this matter.
Very well, very well, very well. Yes.
Short matter, my lord, tender.
Yes.
I participate. my selected as I am not selected. There's a cancellation. I don't get any information. This is by Southern Railway. I apply to another railway for participation. There I'm told that Southern Railway has banned me. I apply to them, then I get a letter indicating how I've been and why I've been banned. So no show cause, nothing, straight away banning.
What is the reason given?
That I have, when I participate, I've relied on a laboratory certificate that they have found out to be fake, and they've relied on an affidavit saying that if I give a fake certificate, then they'll be liable to be banned.
So you obviously dispute that it's a fake certificate.
Yes, and nothing given at all.
Yes, what do you say, Ms. Bothra? Without any show cause blacklisting, it's well settled.
Your Lordship, regarding this point, we have contacted the railway authorities. They are yet to give us their instructions, Your Lordship. So I'm seeking a short date, Your Lordship, to reply to this.
I'll give you some handle to give them instructions. I'll dispose of the matter and set aside the blacklisting. Learned counsel for the petitioner contends that the petitioner has been blacklisted from participation in future tenders of the railways without giving any prior show cause notice to the petitioner. First up, next para, it is argued that the process of blacklisting has serious civil consequences, affecting the business of the petitioner in future, and as such, it is well settled that a prior notice and an opportunity of representation stroke hearing ought to have been given to the petitioner. Push up next para. On query of court, learned counsel for the railways submits that appropriate instructions have not yet come from the respondents. Full stop. Since the matter is appearing in the list, it was for the railway authorities to give appropriate instructions.
Your Lordship, actually, I'm led by Mr. Bhudev Bhattacharya, Your Lordship.
To their counsel,
So,
since the matter since it is evident that no show cause notice was given to the petitioner, there is no utility in keeping the matter pending, directing affidavits unnecessarily. Full stop. Next para. Accordingly, WPA 24338 of 2023 is allowed, thereby setting aside the impugned decision to blacklist the petitioner. Full stop. Next para. It is, however, made clear that the respondents shall be entitled to reinitiate the process of blacklisting the petitioner if so required, which will be done only upon prior notice and opportunity of representation stroke hearing being given to the petitioner. Full stop. It is further clarified that the merits of the decision to blacklist or the contentions of either of the parties has not been gone into by this court. Full stop. Since affidavits are not invited, it is deemed that the allegations made in the writ petition are not admitted by the respondents. No address to cause.
Could I make one request? The way your Lordship is directed after giving me a hearing, your Lordship kindly also record in accordance with the guidelines of the railways, because there is a full guideline that pertains to banning. Just that, if
no, that will furnish you another cause of action, Mr. Banerjee. Why guide them?
Very well.
Their guidelines are there to guide them without the judge.
Very well.
Yes. Next.
Grateful.
8. I'm grateful to your Lordship.
That we intended to file, but that's not required because
keep it with you, bind
I'll
it,
keep it.
but in plaster of Paris because temporary bind.
Very
Yes.
My lord, I appear for the writ petition.
Yes, Mr. Chaudhary, what is the matter?
My lord,
You are for
I'm for this one.
my lord, my affidavit of service. My lord, small scale industry are run under the Pradhan Mantri Urban my lord, mission, not Abbas, that is employment generation scheme. Under having a bank loan was saddled with huge amount of electricity bills.
No, I'm sorry. You come under that subsidy scheme or something?
Yes.
Very well. Then
and thereafter we had approached this honorable court. Your lordship had passed an order directing the authorities to grant us the electricity connection. We had that connection. Thereafter, we had made an application for enhancement of that connection to a bulk industrial connection. Thereafter, my lord, the respondent authorities was saddling us with the bills of demand charges for 25,000 every month, on the quotient that there will be no disruption of electricity.
That's a contract demand charge.
Yes.
Right.
And thereafter, there was enormous amount of load sheddings that was continuing, disrupting the production. That is, the incense stick is being produced by the petitioners. Thereafter, my lord, we had written to the authorities in the month of July itself. The problem started in the month of June 2023. We had written to the authorities in the month of July 2023. Thereafter, no steps initiated. We could not have paid those amounts, my lord. It is 28,000, 30,000 per month. And thereafter, compoundedly, it accumulated into a huge amount. Thereafter, in the month of February this year, I had taken out a supplementary affidavit to bring on record. The authorities had disconnected the electricity supply.
File it.
My lord,
That's a billing dispute then.
there is a billing dispute, but
You know the
unfortunately, the connections had been
even then, Sir Chaudhary, we cannot go into the. I'll give you the liberty to approach the GRO.
My lord, we had made that application, my lord, page 71 of your lordship's brief.
To whom?
To the respondent authorities, including the GRO. My lord, 72, number 5.
So I'll direct the GRO to treat this as a complaint and immediately decide it.
My lord.
I'll do that.
Within a very short period, so that, my lord.
What should be a reasonable period?
1 month.
4 weeks, yes. And you have to be heard also. They also have.
Yes, yes.
So all the
The unfortunate part is, after entire, my lord, paying the entire huge amount of money, 6 lakhs and odd for the upgradation.
Mr. Chaudhary, the usual.
I understand.
The usual time limit is 6 weeks. But since you are an industry, I mean, you are a small industry.
Small industry.
You should be encouraged. I mean, for that
Yes,
reason,
yes, yes.
4 weeks.
Great.
So that is the logic. I'm being transparent on this. The petitioner has raised a billing dispute. Full learned counsel for the petitioner files a supplementary affidavit with leave of court and submits that during pendency of the dispute in the writ petition, the electricity connection of the petitioner has been severed. It is argued that the petitioner, being a small scale industry, suffered severely due to power cuts at the instance of the WBSEDCL. However, the bills raised were huge and disputed by the petitioner. The petitioner also wrote to the concerned authorities, including the regional grievance redressal officer, but to no effect. Next para, learned counsel for the WBSEDCL controverts the allegations and stands by the bills raised by the WBSEDCL. Next para, be that as it may, under the regulations of the West Bengal Electricity Regulatory Commission, the appropriate authority to decide billing disputes is the regional grievance redressal officer. Accordingly, WPA 25168 of 2023 is disposed of by directing 5.
Respondent number 5.
By directing the respondent number 5, that is the regional SE within bracket bracket closed, and regional grievance redressal officer, Murshidabad region of the West Bengal Electricity Regulatory Distribution Company Limited, to decide the petitioner's complaint as annexed at page 71 of the writ petition by treating the same to be a reference under the regulations and decide the issues involved in accordance with law upon hearing all concerned parties, including the petitioner and the WBSEDCL, at the earliest, positively within 4 weeks from date. No address to cause urgency.
Since the petitioner is a industrial unit, the representative of the petitioner may also be petitioner. There is only one petitioner who is an
petitioner. By hearing all interested, all concerned, including the petitioner, through its representative.
Grateful.
Grateful.
Affidavit of services also.
What are you? Next.
9.
Yes, Mr. Dotto, you are the petitioner? Yes.
I'm filing supplementary affidavit.
You are for the state?
But I am also paying for the state, along with Mr. Unujit Mukherjee.
Yes,
Now,
yes.
one MMR post was sanctioned by the government in respect of
Mr. Dotto, please take the microphone because he's appearing online,
Yes.
so he won't be able to.
Well, one MMR post was sanctioned by the government in respect of the Asuti police stations. Now, what happened? I made an application in January 2023. They did not take any action. I filed this instant writ petition.
You find an application for being appointed there?
Yes, yes. Well, therefore, they did not take any action. I filed a writ petition, these writ petitions. During the pendency of the writ petition, kindly take my supplementary affidavit.
You have given a copy to them,
Yes, I have given the copy.
Right. Yes.
Page 5.
Page 5. Page 5. Sorry. Yes, 5.
Now, the letter was issued by the deputy inspector to the district register to initiate the selection process for that post.
This is during pendency of the writ.
During pendency. Now, on the next page, page 6.
No, what was written here? Let me see. As a selection process, yes. Page
Page 6.
Right.
Well, on the basis of my application, I was called for hearing.
Right.
Well, the date was fixed of the hearing on 14 December 2023. I appear, I produced all relevant documents. Now, well, still no, they did not take any action, neither of this.
Yes, Mr. Mukherjee, why are you not taking any action?
My lord, what happened initially, this post was not sanctioned. Subsequently, when the post was sanctioned, we have called her for him for hearing. Now, what happened is your lordship's own order. Another writ petition was filed by the another person regarding this post. Your lordship said that your lordship, by your lordship's order, observed that, my lord, that person candidate has to be considered first. Thereafter, other process will be made. Now, my lord, in respect of that matter, we have already hearing was concluded. We have forwarded his candidature for approval. That has not yet been come. Now, by this time, my lord, regarding the present writ petitioner, we have already called for a hearing. Thereafter, my lord, we cannot pass the order in view of lordship's order because we will yet to receive the approval from the appropriate authority. If your lordship's own order, my lord.
Paragraph 9.
So communicate that to him. You should have communicated that. Communicated that.
We will.
See my order. Give a copy to him.
We will. My junior will hand over. My lord. I have a 2 copy.
To Mr. Datta also.
In respect of self-some post, my lord.
Yes. Give me half a minute, Mr. Mukherjee. I'll just go through it.
Ma'am.
Mr. Mukherjee, decide that and his application also consequentially.
Yes, sir, we have already.
I'll give you a limited time to do that.
Yes.
I'll give you 4 weeks to do that.
Can it be 6 weeks? Because election is coming, my lord. All the officers will be, my lord. They will be on duty, my lord.
Election will not be over by 6 weeks. Will it be?
No, my lord. Election to the It will take some time.
It will be more difficult.
Yes.
4 weeks will be easier. After 6 weeks,
4 weeks,
you will be also on the panel or whatever we do.
And only one thing, your lordship first time order that in the event no new appointment has already been made to the newly created post. No such
His representation has to be
only one thing,
decided first.
if the order was passed for initiate of selection, there is no bar to initiate the selection.
Anyway,
that has already been started.
Learned counsel for the petitioner argues that the petitioner applied for the post of MMR in a newly created police station.
Kalitola Asauti police station.
Where do I get that name?
Your lordship in my supplementary page 5.
Both are for the same post, same area, same police station.
আচ্ছা কি বললাম একটুখানি না in a newly created post under the Kalitala Asuti ASUTI police station area. First up, although the petitioner was given a hearing and produced all documents, no decision has been taken as yet by the respondents on the petitioner's said application for appointment as MMR. First up, next para, learned counsel for the respondents cites an order dated February 5, 2024, passed by this court in WPA 27415 of 2023. First up, on the application of the said petitioner, for appointment to the same post, it was directed by this court that Rule 9 of the Mohammedan marriage registration rules is to be complied with, and the respondents were to take a decision on the application stroke representation of the petitioner therein for transfer to the newly created post within a fortnight from that date. First up, it was further specified that in the event no new appointment has already been made to the newly created post, no such appointment shall be made prior to a decision being taken on the petitioner's application, as directed therein above. First up, next para. In view of such order, it is argued, since no decision has as yet been approved with regard to the writ petitioner therein, the present petitioner's application cannot be decided. Full stop, next para. There is point in the submission of the respondents. Full stop. However, comma, the petitioner cannot be made to wait indefinitely for that, full stop. Accordingly, WPA 25596 of 2023 is disposed of to take a final decision on the approval of the writ petitioner in WPA 27415 of 2023, namely Muhammad Habibullah Khan, pursuant to the order dated February 5, 2024, as expeditiously as possible, comma, positively within 4 weeks from date, full stop. Immediately upon a decision being taken on such approval, comma, the petitioner's application shall be consequentially taken up, and the outcome of the petitioner's application, comma, depending on the decision taken by the authorities on the application of the writ petitioner in WPA 27415 of 2023, comma, shall be communicated in writing to the petitioner, comma, preferably within a week thereafter. Full stop, no arrest to cause urgency requirements. He had
within
already there.
Yes.
That's why his was to be given preference.
Well, I
only thing is that 4 weeks, by these 4 weeks, my lord, election will already my lord commence, my lord.
but since I tell you, see,
So, what will be a reasonable period, Mr. Mukherjee? Tell me.
Kindly, my lord, keep it, my lord, 8 weeks, my lord. Because my lord, otherwise, again, we have to face contempt, my lord.
I'll make it 8 weeks. Because the election, they won't be able to work. They'll be deputed somewhere.
no, only one thing, my lord, since this order was passed for initiation or selection, Rule 9 deals with the transfer. There is no question of initiation or selection. The problem is
Mr.
that
Dotto, there is one post. If this person is transferred to that post, there is a question of further selection.
then the order shall not be part to initial selection.
এটা 4 weeks টা যেটা করেছে ওটা 8 weeks করে দাও আর within 1 week 8 weeks 4 weeks becomes 8 weeks, Mr. Mukherjee, but the communication remains 1 week thereafter.
Absolutely. Extremely grateful.
Filing could be kept on records and if it was
Supplementary affidavit.
my lord, I've given that.
আচ্ছা, supplementary affidavit and affidavit of service filed to be kept on record. Next. Grateful. Thank you.
10.
I'm for the petitioner.
What about service?
Yes, my lord. My lord, we have served again, and my lord, but it has returned. Service is not satisfactory, my lord. We have served through email as well in terms of my lord's direction.
Email, it has not bounced back.
No, it has not bounced back.
We'll move the matter. Let us see.
Yes, my lord. These are
Who could not be served? Which
private respondents.
Oh.
And my lord, in terms of my lord's direction, we have carried out amendment as well.
So to the new address also you served?
Yes, my lord.
What is the matter about? Tell
It's the direction on the district magistrate to dispose of my application under section 14 of the Surfacey Act, my lord.
Learned counsel for the petitioners stroke financial company submits that the application of the petitioners under section 14 of the Surfacey Act has been kept pending inordinately by the concerned district magistrate, the respondent number 2 herein. Push up. It transpires from the affidavit of service which is filed today and kept on record, comma, that sufficient attempts have been made by the petitioners to serve the private respondents, comma, both through both by registered post and via email. Push up. Although the registered post service appears to be unsatisfactory, comma, the email service effected by the petitioners has not bounced back, comma, thereby signifying presumption of good service. Full stop. Accordingly, the matter is taken up for hearing. Full stop. As the application of the petitioners have been kept pending beyond the statutory period, comma,
Since 22.
Since 22.
July 26, July 2022.
For as long as from July 26.
July 26,
2022, comma, WPA 26331 of 2023 is allowed, comma, thereby directing respondent number 2, the district magistrate Barashat, to dispose of the petitioner's application under section 14 of the Surfacey Act 2002 as expeditiously as possible, comma, positively within 4 weeks from the date of communication of this order to the respondent number 2 by acting on a server copy of this order. No orders to cause urgency.
Macho. May I take yours?
11.
For the respondent.
I'm petitioner in person.
Yes.
Miller,
Written notes you had filed probably.
May I file my
I
opposition?
filed a contempt application being CPAN 407 of 2024.
Maybe.
as the respondents have not complied with the directions of the order dated 31st
That will be taken up differently. But what about this matter?
Yeah,
Affidavit in
Milord,
opposition they have filed. Have you used a reply to that?
no, Milord, I received the copy only today itself.
It is very difficult to serve you, Milord. Yesterday
No,
we sent
Milord,
the email.
it was affirmed on
We sent the email
1st of March. That's what is written. And I've got two submissions to make in this regard.
Yes, Mr. Das.
Number one is
No, if you want to use a reply, I won't waste time here. I'll give you 1 week. Come back up.
small submissions.
No. Use a reply and I'll hear the matter. Dispose of the matter. Why small submission? Make big submissions, but after, if you want to use a reply,
Yeah, I will.
I think better use a reply. We don't know what have been stated here. So how long will you take to file a reply? This is the
2 days.
2 days. Very good. An affidavit in opposition.
A contempt application is filed because I filed this opposition late.
Contempt I'll deal with later when the contempt is taken up. The affidavit in opposition filed today be kept on record. Full stop. Since a copy of the same has only been handed over today to the petitioner appearing in person, comma, on the prayer of the petitioner, 2 days time is granted to the petitioner to file an affidavit in reply. Full stop. The matter shall be listed accordingly on March 7th, day after tomorrow.
8th we can.
8th Friday, I take up applications. Maybe your contempt application also.
Milord, I've got.
I'll keep it on Monday then.
I've got another case on 7th, Milord.
I'll keep it on Monday, Milord.
Very good. On March 11, 2024, under the same heading. Please come back with the reply and give an advance copy to them, obviously. Next.
12.
Well, I am for the petition
Yes,
led
please.
by Mr. Balram Pandit, who is virtually present.
My lord, I beg to appear for the petitioner.
Mr. Pandit, what about service file?
Service, my lord. I am filing service.
I am for respondent number 8.
Private respondent, Mr.
Private respondent number 8.
There are 3 private respondents.
How are they related?
They are the
Lordships, may I submit, my lord?
Representing the estate, I'll hear. Yes. Yes, Mr. Pandit, what is your case?
My lord, the case is about getting new.
Pandits on every side. Mr. Balaram Pandit, the other Mr. Pandit. Yes, Mr. Pandit. Continue.
Lordship, my case is the petitioner herein applied for getting new connection.
Please take your seat.
Electricity to her premises. The application was made before the distribution licensee. Respondent number 4.
So due to their resistance, it is not being given.
Till date, Lordship, it has been for a period of around.
Yes, Dr. Sare, what is their case?
They are asking for there was the respondent number 7 from respondent number 7, respondent number 8. That is my client. He purchased. Subsequently, respondent number 8 sold out this property to the petitioner. When the petitioner, the authority is now asking that owner had an outstanding, so near about 6 lakhs.
How are you? Why are you implemented?
I have no role here, my lord.
What is the why private respondents, Mr.
Lordships, here the respondent number 6 was the previous owner. He transferred the property to respondent number 7. He is his son.
Why have you implemented respondent number 7 to 8, 7 and 8?
Only to demonstrate before your lordship that how the property has devolved upon me, your lordships.
Sorry, let me hear Dr.
The
Shah.
property was transferred.
Got your point. So you are challenging that the CSC Limited is asking for WBSCDCL is asking for the outstanding dues. You say there is
outstanding dues. My lord, the thing is till date no formal demand has been made, your lordship. Only oral communication has been made and
Make the formal demand.
I'll direct them to immediately take a formal demand.
Already, but it is only
a formal. They should.
The thing is, am I liable to pay these outstanding dues?
After you get the formal demand, before that you don't know. So,
let's see.
Yes, Dr. Shara, but I'll put in something additional that in communication you also indicate, which is not there in the regulation, but to avoid cut short further litigation, you will indicate what is the nexus between this person. If purchase, then purchase, whatever portion is the nexus.
No nexus, my lord, no nexus.
Then I will not open up my mouth. Let the demand be come.
At the next stage, when
I will.
Learned counsel for the petitioner submits that the petitioner has purchased the property from respondent number 8, push up, in order to indicate the devolution of title, comma, the private respondents have been indicated, comma, who were erstwhile owners. Full stop. Next para. It is contended that when the petitioner applied for electricity connection, comma, such connection is not being given apparently on the ground that there were certain outstanding dues by the previous erstwhile owners. Which, however, comma, the WBACDCL is not indicating the exact quantum or the liability of the
already indicated the exact quantum.
or the liability of the petitioner in that regard. Full stop. Next para. Learned counsel for WBACDCL, however, submits that the quantum has already been indicated to the petitioner. Full stop. Be that as it may. Yes, Mr. Pandit, it has been indicated the quantum.
No formal demand has been made. Only 2 bills were provided to us after making application. When we reached the respondent number 4, we are given to understand that certain dues are there. So in that regard, 2 bills which are issued in the name of respondent number 6 and 7, those 2 bills were provided to us. Nothing more and nothing less, Your Lordship. Till date, no formal demand has been made.
Well, however, comma, it is settled as per the regulations of the WBERC that a nexus between the new applicant and the erstwhile defaulter have to be made out by this distribution licensee to claim outstanding dues from a new applicant. Full stop. In the present case, comma, since nothing of such sort has been indicated clearly, comma, direction of affidavits in the writ petition would only render the remedy illusory, comma, since as per Mohinder Singh Gill's case, comma, reasons cannot be subsequently furnished. Full stop. Accordingly, WPA 27498 of 2023 is disposed of by directing the WPA to clearly communicate in writing to the petitioner as to what is the nexus in the perception of the WPA between the petitioner and the outstanding dues left by the erstwhile consumers. Full stop. Such communication shall be made within a fortnight from date. Full stop. Next para, it is made clear that in the event the petitioner is aggrieved and has a dispute regarding such perceived nexus of the WBCL, comma, it will be open to the petitioner to prefer a further challenge against the said decision of the WBACDCL. Full stop. In the alternative, comma, if the petitioner is agreeable with the allegation of nexus, comma, the petitioner will be at liberty to comply with the formalities, in which case the WBACDCL shall give the electricity connection to the petitioner, preferably within a fortnight from such compliance. No rest to cause, sir.
Deeply already.
Grateful to Your Lordship.
Clarify that there is no nexus.
But that goes to show the nexus that the private respondent is suffering.
Since Mr. Chatterjee is affaring, definitely there is nexus. That's why he has been engaged. Someone of his. Yes. Next.
13.
Yes.
My
What is
for
the
CSC.
13, my lord, I am for the petitioner, my lord.
New hat. Yes, rural hat to urban hat now. Yes, what is your case?
My lord, this is my affidavit of service, my lord. My lord, challenging.
Private respondent is there.
My lord, private respondent.
Good service on private respondent.
Good service of the
Checked
private.
up. Due to their resistance.
My lord, no, not due to their resistance.
Then what?
Properly not there to their resistance, my lord. The fact of the case is, my lord, I am the purchaser in respect of the flat number 102, holding number 100, Ichapur Road, Howrah, 7111101, my lord. Now what happened is, my lord, subsequently, after purchasing the said property, my lord, by way of Bengali deed of sale dated December 15, 2021, my lord. So I have recorded my name with the Howrah Municipal Corporation in my assessment register, my lord. All the requisite documents, my lord, with me right now, with the petitioner, my lord.
Yes.
Subsequently, my lord, what happened, my lord? There was a existing meter of the private respondent in respect of the same premises, my lord. Premises flat number 102, my lord. Subsequently, my lord, petitioner got acquainted with the fact, my lord, that the private respondent number 5 and 6 transferred their name in respect of the said electricity connection to the private respondent number 7, my lord, which has been the respondent number 7 is a proprietorship firm, my lord, GR Trading, that has been operating by, my lord, private respondent number either 5 or 6, my lord. But the address in respect of the said premises, in respect of the new electricity connection of the private respondent number 7 has not been changed, my lord. That is till now 102, my lord, flat number 102.
They have only asked for a transfer of name.
My lord, they have not given any no objection.
What is yours?
My lord, now I have approached before
You have
the.
purchased from whom?
I have purchased from the private respondent number 5 and 6.
Acha.
That is, my lord, the Bengali deed of sale, my lord, is annexed as annexure number.
Would it make a difference if it was English deed of?
My lord,
Why are you harping on Bengali? I mean,
that is, my lord,
Bengali
Bengali
is our mother
Joy
tongue. So,
Kobala.
yes. No, could there be a difference if it was?
No, my lord, there.
If it was CSC, then this is CSC.
CSC.
It may make a difference. If it is WBSCTCL, no difference would be there.
No, my lord.
Anyway, that Bengali deed ultimately gave you title. Now you have applied for electricity connection.
My lord, I have applied for new electricity connection by way of representation dated September 16, 2020.
You have to make a formal application. What is your name, please?
My lord, my name is
Your name.
Ovilas Chatterjee, my lord.
Mr.
My name is Ovilas Chatterjee, my lord.
Ovilas Chatterjee. Mr. Chatterjee, you have to make a formal application.
My lord, I will make a formal application, my lord, if the CSC.
Have they refused specifically?
No, my lord, they have not refused specifically, but my lord, verbally they have said as there is a connection is already existing in respect of the premises number 102, we cannot give you the new connection, my lord.
What can be done, Dr.
Ma,
Sir?
transfer, your lordship knows, I drawing your lordship kind attention to regulation
No, but the
46.
yes, but difficulty here is 5 and 6 transferred.
But this is the situation where the
Transfer 5 and 6 transfer property in their favor.
Yes.
But the name was transferred in favor of 7, which is again run by 5 and 6.
Ma, I tell you, lordship. My here, your lordship knows the rule that as per the regulation 46, clause 7.2c, I have noted it to your lordship on the earlier occasion. In case of transfer, even if there either of the three things has to be given, either no objection certificate or succession certificate or the sale deed. If they produce the sale deed and if they comply the formalities relating to transfer, there is a specific form on that. We'll transfer in their name.
Dr. Sara, there is a different difficulty here. The difficulty which your Mr. Chatterjee has pointed out, transferred deed by 5 and 6, but names the name of the meter is standing in the name of third party, that is 7.
No.
That is what he's saying.
Deepak Malik and Falguni নামই তো আছে।
Deepak Falguni, they are probably the proprietors of Messrs. SR Trading.
Ma, we have issued one letter to them, but it was returned. But we have got the letter. Or
that we can take care of. Those things we can take
that
care
letter we have taken that on 12/12/2020. If there is a specific order by your lordship, by this honorable High Court.
Before doing that, I'll Mr. Chatterjee, have you annexed anything to show that this Falguni and Deepak,
Yes.
they are the proprietors of SR Trading?
That was,
Otherwise, how can we?
My page 50, if your lordship kindly draw your lordship attention to page 50. The meter is name of the Deepak Malik and Falguni.
That is, my lord, in annexure P2, page 50, my lord.
This is the same.
Meter was, my lord, in the name of private respondent number 5 and 6, my lord.
Whom they have entered into the
Page
agreement.
52.
My lord, kindly come to the page 52,
Yes.
my lord. Now, my lord, my specific allegation is that, my lord, there is another flat being flat number 104, my lord, from where they have been operating the business in the name under the name and style of respondent number 7, my lord. My lord, my humble submission, my lord, before your lordship, my lord, let the CSC be come to the said flat, my lord, do an inspection in regard to the my possession and title in respect of the property, my lord, in respect of the flat number 102, my lord, and then, my lord, they will provide me the new connection, my lord.
New connection হবে না, transfer করতে হবে তো।
My lord, under section 40, subject to correction, my lord, under section 43 of the Indian Electricity Act, my lord, new connection can be given, my lord, in respect of the even same premises, my lord.
Dr. Sahara, he has alleged in his letter to you that he is in flat number 102. Meter was for 102. It is being used by these people for 104 now, after transferring to him. Now, you will have to ascertain 2-3 things. One, he has to make an application, obviously. After that, in this case, I'll ask you to give him a hearing so that he can produce documents to substantiate that 102, that connection to 102 is not being used now in 102. If it is not being used in respect of 102, then you will just transfer the.
Yes,
you can transfer.
That we are ready and willing to do that, and we have issued a letter to them, and that was returned, not found. It has been returned on.
Oh,
that
you
basis.
said that ready and willing.
Yes, your lordship. This is the
So
letter.
keep it with you. I'll just. Learned counsel for the petitioner submits that the petitioner purchased a flat being flat number 102, comma, Howrah Municipal Corporation holding number 100, comma, Makordaho Road, comma, Police Station Batra, District Howrah. Full stop. Next para. Such purchase was made from respondent numbers 5 and 6, who were the erstwhile owners of the said flat. Full stop. Subsequently, the petitioner made a representation to the CSC Limited indicating that the meter standing in the name, previously standing in the name of respondent numbers 5 and 6, has since been transferred in the name of respondent number 7, comma, which is a concern run by the respondent numbers 5 and 6 themselves, comma, and is being utilized for catering to flat number 104, comma, which is a different flat. Who's up next para? Learned counsel for the petitioner, Mr. Chatterjee, submits that since the transfer of flat number 102 has been effected by respondent numbers 5 and 6, comma, its erstwhile owners in favor of the petitioner, and the meter stood originally to cater to flat number 102, comma, the same may be transferred in the name of the petitioner in view of the transfer of the flat. Puts up next para. Learned counsel for the CSC Limited submits that the CSC Limited is otherwise willing and agreeable to give such allow such transfer subject to compliance of formalities by the petitioner. Puts up, however, comma, when a communication was sought to be made to the petitioner to that effect, comma, the same returned as unserved. Full stop.
Found as not
As same returned with the endorsement not found. Full stop. Next para. In view of the allegations and in view of the averments of the parties, and keeping in mind that the respondents choose not to appear at the time of hearing despite service, which is evident from the affidavit of service kept on record today, comma, the matter is taken up for disposal ex parte. Full stop. Since the petitioner has purchased flat number 102 and submits to have the sale deed to that effect, comma, the petitioner is to be deemed to be in possession of the property, and in view of the transfer, the meter should be transferred in the name of the petitioner. Full stop. Next para. The only impediment here is that the meter might have been transferred in the meantime at the behest of the erstwhile owners in favor of respondent number 7, comma, but catering to a different flat. Full stop. Next para. In such scenario, comma, WPA 28750 of 2023 is disposed of by granting liberty to the petitioner to file a proper application in appropriate format for transfer of the name in respect of the electricity meter catering to flat number 102, which has been purchased by the petitioner. Full stop. Upon such an application being made, comma, the CSC Limited, comma, if satisfied that the transfer has actually been effected in favor of the petitioner, comma, process the said application, and upon compliance of formalities by the petitioner, comma, effect such transfer at the earliest, comma, preferably within a week from the date of such compliance of formalities by the petitioner. Push up. In the event any complication arises in the perception of the CSC Limited in view of the meter apparently now standing in the name of respondent number 7, comma, the CSC Limited shall give an opportunity of hearing to the petitioner in order to be satisfied that the meter was originally taken in respect of flat number 102 and that the said flat has actually been transferred properly in favor of the petitioner by the erstwhile owners. Full stop. Next para. If such conditions, such parameters are satisfied, comma, the CSC Limited shall still go ahead and upon compliance of formalities by the petitioner, comma, gives allow such transfer within a week from the compliance of the petitioner. No address to
formalities.
My lord, only
One thing, online application. Nowadays, the application not.
What is the appropriate format I have said,
Aye, aye.
whatever
my
is
lord, only one humble submission, my lord.
But let this letter be kept on record, subject to because in the order.
Acha, the communication handed over by learned counsel for the CSC Limited today be kept on record.
My lord, only one humble submission before your lordship, my lord. If your lordship, my lord, kindly direct the CSC to hold an inspection in respect of the premises, my lord, then my lord, I can satisfy, my lord.
I've cut for that. Instead of inspection, you produce the title deed, that will suffice.
Grateful, my lord.
They only have to satisfy themselves on the title deed.
Right.
And if the meter was given for 102.
Great.
Regulation 7.2C is very
7.2
much clear.
upwards.
Great.
You'll take care of your regulations, but give the terms. Yes. Next.
14.
Very good. My lord, 14, my lord, is a very, my lord, I have gone through.
Very
my lord,
formidable
a
opponent.
story of a very unfortunate lady.
Oh.
Now, my lord, after all, my lord, in view of this, my lord, the latest notification of the central government, I
Lord,
think, my lord, that problem is over.
Yes, but actually, my lord, after this notification, originally there was a provision that donor eggs can be used for surrogacy. That was amended, not amended, I will say. A particular form has been amended. The act or rules has not been amended, where the donor egg has been prohibited. That is in
If
26.
donor egg is prohibited, where shall you get the eggs?
That is in the subsequent amendment. In
Now, my lord, it
23.
is that.
Now, what is the current position?
Now, the
Current-
current
yes.
position is that has been revised back.
That divide. Thou shall kindly go through, my lord, the second page of the notification.
Well, this is the earlier amendment.
Mr. Pal, I'll go through the current
Yes,
one.
yes. My
I think
Only
that-
thing is that the petitioners.
Well, I talked to the my lord, the welfare.
You are the couple who want the child.
I talked to the my lord, the family health and welfare department. They said now everything is okay. Only thing that because of the pendency of this writ petition.
Oh. No, it was refused initially because
the my lord, that was the my lord,
donor
egg was
Though my registration was earlier. That amendment has no.
Maybe.
But the district medical board has to still certify them.
That has been certified twice.
Oh.
Thrice. Even the surrogate mother has been medically examined.
Very. A fair stand has been taken by the state in this matter. Full-stop. Learned counsel for the petitioner contends that due to an amendment in the surrogacy within bracket regulation bracket close rules, comma, the petitioners
2024.
yes rules to 2022, comma, the petitioners were not being permitted to use donor eggs for the purpose of going for surrogacy, intending to have a baby by such process. Full stop. Next para. However, learned counsel for the state hands over a notification dated February 21, 2024, vide GSR 119 within bracket capital E, as per which the latest amendment in the said 2022 rules provides that the couple undergoing surrogacy must have both gamete, GAMETE, from the intending couple. However, comma, in cases where the district medical board (CAPSE) certified that either husband or wife constituting the intending couple suffers from medical condition necessitating use of donor gamete, then surrogacy using donor gamete is allowed, subject to the condition that the child to be born through surrogacy must have at least one gamete from the intending couple. In the present case, comma, the petitioners have already been certified twice by the district medical board as per learned counsel for the petitioner. Hence, comma, there cannot be any further impediment in the petitioner couple going for surrogacy by with donor gamete.
One thing, my lord, that the embryo is lying with private respondent. They have communicated that they are closing that surrogacy clinic.
Private respondent. Who is the private respondent?
Indira IVF.
I have no idea.
That is respondent number.
What is the cause of action against them?
They are holding that embryo. They are the clinic who are treating it. Now, after this regulation,
So we don't know whether you have any dues to them. How can I direct a
they have
private?
given the letter that they are closing it. Everything is paid. They are holding it because of this regulation.
Oh, achha.
Now we are praying that this embryo may be transferred to respondent number 4.
Accordingly, it is further submitted by the petitioner that the embryo is now being held by respondent number 4, who supplemented counsel for the petitioner hands over a communication dated March
Respondent
4.
number 3, holding by respondent number 3, IVF, Indira IVF.
Sorry, held by respondent number 3, in a communication dated March 4, 2020. Learned counsel for the petitioner hands over a communication dated March 4, 2024, whereby it was indicated that the respondent number 3 had decided to surrender its registration for surrogacy clinic and had already initiated the documentation in that regard. Next para. In such view of the matter, comma, there cannot be any impediment in the respond number 3 handing over the embryo to the petitioners for the purpose of the petitioners undertaking due procedure for surrogacy. Full stop. Accordingly, WPA 508 of 2024 is disposed of by granting liberty to the petitioners. By directing the respond number 3 to hand over the embryo in question to the petitioners within a fortnight from the within a week from the date of communication of this order to the said respondent. Full stop. Upon so having been handed over, comma, the petitioners are permitted to go for surrogacy with a donor gamete in terms of the amended Rule 1 within bracket small d of the surrogacy within bracket regulation bracket close rules, comma, 2022 as amended till date. Full stop. No rest to cause urgency.
Another thing, madam.
I think, well, I suggest him, my lord, that I think, my lord, in this process, directly, my lord, hand over to the petitioner, my lord, it is not possible. It may be, my lord, the loss, my lord. My lord, or as per his instruction to another fertility center, there must be some process.
যেখানে বললাম handed over to, thank you, handed over to the petitioners, যেখানে বলেছি respondent 3 direct to hand over to the petitioners or to any other agency stroke institution fertility center stroke clinical facility as designated by the petitioners.
Get
the parties shall act on the server copy of this order without insisting upon prior production of certificate.
Kindly allow me that in case this embryo is lost or destroyed,
No, you are permitted. That I have clarified.
whether I can take another donor egg.
This is an additional direction. You have been permitted. I have given you leave to proceed with surrogacy with a donor gamete.
I'm grateful to you.
Thank you.
15.
Yes, what is that?
I'm for the petition.
Yes. Yes, please.
The evidence.
You are for the contesting respondents?
Yes, only. Only.
Very good.
My petitioner is now working under All India Institute of Hygiene and Public Health. And what happened? The petitioner was suspended. Since the petitioner was sick, I could not attend service for the month of June 23, July 23, and August 23.
I'm sorry, I could not get you. Could not?
Could not join because due to his illness, he could not perform his duty.
His service.
Yes.
Yes. Then?
Therefore, the 3 months salary was not given to him. 3 months salary for the month of June, July, and August 2003. And from the month of September, my lord, he could not join. He was suspended. Now he is under suspension. Yes. Now, whatever my petitioner took loan from the bank, by the respondent hearing, he paid the rent because the loan was credited from the account where the money is being credited, when salary is being credited. But since he could not got the salary for the 3 months, but thereby could not automatically the money which was being credited from the salary to the salary account could not be collected by the bank. That's why from the month of September, as and when he started getting the 50% of the suspension allowance, all the money is being debited from the account. Petitioner is not getting funding from the bank. Now petitioner become
getting salary now, a pension.
The pension. Now whatever amount is credited.
But what can the REIT code do?
That
is the terms of your loan.
Yes, but I am ready to. The terms is this: they are to direct only 16,500 as EMI. But they have all the money they are taking, leaving any funding. How the petitioner survive? The bank, yes, entitled. They are entitled. I am not disputing. Because of this, my lord, the petitioner now, with his mother is 80 years old, the wife is blind. But kindly see.
No, they are deducting what? Interest?
No, all the money. Whatever money is credited to the salary account, they are taking all the money.
That was the terms of the EMI?
No. Because they had to get only
Because you defaulted, I don't understand your case. You defaulted for some months.
Only 3 months. For which?
Only or not, and you defaulted for some months.
Some
3
months. Some months.
So that is the reason they are deducting extra money.
Extra money. All the money.
Was it within the terms of the EMI?
No.
Yes, Ms. Dahiri, what do you say?
Only let them take.
Lordship, is it the loan is in the nature of a personal loan.
the petitioner has two loans. One, he has a personal loan of 7 lakhs and odd,
Yes.
and one, he has an overdraft facility against his savings bank
Right.
account. Now, the salary last credited in his account was in November 2023. After that, there is no salary also. It is not the pension. There has been no credit of any pension. It is possibly a caveat actually, so that later on the bank doesn't proceed with the pension.
There has been no pension has
There
come
is
in.
no pension has come in. It is the salary, and the salary was adjusted against the overdraft facility, not even the account he has mentioned. So there was an overdraft facility of 71,000.
That limit was reduced.
Yes, the limit has been reduced, and against this specific account, which has been annexed here, the statement, there is an overdue of amount around 3 lakhs and 20,000 and odd. So, and the loan account is an NP account. It was NP in August 2023, Lordship. It is well within the terms of the sanction. The personal loan letter of arrangement is annexed, Lordship. It is the banker will always.
No pension has come in. What are you saying? Pension is coming. They deducted from the pension. You said pension is coming.
Suspension are not pension. Not
pension and suspension are
no suspension, not pension. Suspension.
What is suspension amount?
Suspension allowance, not suspension allowance. He has been
Lordship, the
suspended.
amount is considerable. We are deducting from that. There is not like
Whatever.
the
I have
amount.
full sympathy with you because you are not getting any money, but that was the terms of this is a financial contract between the bank and you.
I am not
How can the
disputing.
RIT court enter into it?
No, my lord, can say entire amount which is being credited, my lord. Now, question
will be credited. Your property next year property will be attached if you can't pay. That is the that is the fun of a loan.
Subject to lawsuit,
Unquote unquote.
Subject lawsuit consideration. But some money may be left because but they are entitled.
I cannot interdict the contract. The court does not have the power. If there was some power, 50-50 power also, I would have definitely exercised in a favor in the circumstances.
Okay,
I don't have any power
9
to
lakhs.
rewrite the contract between the parties.
No, but they have already. I have paid 9 lakhs.
You can approach the bank if they give you some installments or whatever.
Because
I'll give you that liberty with that expectation. No, I cannot go further.
He has some family.
26 is not.
80 years old.
Mother is 80 years. You are not 80 years.
No. Mother is 80 years. Wife is blind. My son is now. He has to prosecute.
He has a history of
Unfortunate.
defaults. I have the civil report also. Is a history of defaults.
No,
and he's also suspended because of attendance to his work.
Because he sustained injury while he was in work, my lord.
Counsel for the petitioner submits that the petitioner took a loan from the respondent number 1 bank. Subsequently, the petitioner made only 3 months default. In the meantime, the petitioner was suspended from his job and is now getting only
suspension allowance.
Suspension or subsistence?
No,
suspension allowance. It is contended that in view of the defaults made by the petitioner, the bank is deducting the entire amount of rupees 16,200.
Whatever money is credited to the bank account,
the bank is deducting the entire amount which is coming into his account in lieu of such defaults. Next para, the petitioner submits that his mother is about 80 years old and requires constant attendance and medical attention. The petitioner's wife is also visually impaired, and his son. What about son?
Now class 12, he's reading class 12.
His son is about to take the +2 examinations of the board. Hence, if the entire amount is deducted, the petitioner will be in doldrums. Next parallel, counsel for the respondent submits that the petitioner has a history of defaults, which is reflected in his CIBIL ratings. That apart, he was also suspended from his job. Next para, the petitioner, it is submitted by the respondents, has an overdraft facility as well as an account with the bank, from which the amounts are being deducted within full purview of the contract between the petitioner and the bank. Hence, there is no scope of any interference in the matter. Next para, upon a careful consideration of the submissions of parties and the materials annexed, I am of the opinion that that there is no scope of interference by the writ court, since the matter pertains to the contract between the bank and the petitioner, and The contract, comma, it is well settled, comma, cannot be rewritten by the court. Full stop. The writ jurisdiction can be invoked if there is any palpable arbitrariness, comma, unreasonableness, comma, malafidis, or patent illegality, particularly in the decision-making process of the bank. Full stop. Here, comma, the bank is acting as per its agreement with the petitioner and cannot be faulted as such. Full stop. Next para. Of course, comma, the petitioner has raised a humanitarian aspect of the matter inasmuch as if the entire amount is deducted from the petitioner's account whenever it comes in, comma, the petitioner's family, it may be petitioner family take anything. It may be difficult for the petitioner to survive with his family who are otherwise indigent. Full stop. Next para. Since there is no scope of interference by the writ court, comma, the discretion has to be left with the bank to consider sympathetically, comma, if the bank is so permitted under the extant regulations, comma, the petitioner's case. Full stop. Accordingly, WPA 665 of 2024 is disposed of without interfering with the impugned action of the bank, but granting liberty to the petitioner to approach the respondent number 1 bank for installments, stroke, some lenience in deduction of the amounts. Full stop. If so approached, comma, the bank shall consider the same sympathetically and decide such approach in accordance with law and the extant regulations. Orders to cause What about that?
Only where the overdraft facility, there's a personal loan also.
Third.
Yeah. One
Plus
no,
overdraft.
one personal loan, one overdraft facility, and the savings bank account.
যেখানে বলেছি মাধববাবু ওখানে and a personal loan.
I'm deeply obliged.
16.
Yes. What is the matter?
With case of alleged pilferage, my lord. He could not attend the hearing.
Right.
My lord, because on that day, my lord, the anticipatory bail application was sought to be. Yes. And kindly sees, my lord, one anomaly I wish to point out. Kindly compares page 52, which is the complaint, with page 58, the contract, the connected load. Right. They say it is only being run for electrical appliances for his residential establishment, page 52.
52, yes.
Yes.
Direct tapping from phasor neutral bus bar connected to load circuit via changeover switch.
It is, if it was allegedly being used for
run electrical appliances at his residential establishment.
For domestic purpose.
It was, it is a commercial connection otherwise.
No.
Industrial.
No, domestic connection. And now the contracted load, which is quite absurd, is page 58, the final assessment order.
Yes.
It is stated to be 21.9 kVA.
Yes.
But my residence with 4 air conditioners, it's 6.5. It should amount to about 20 ACs. A normal family has at most, this is a patient bypass who has undergone bypass surgery. He requires BiPAP and all those.
So for this equipment, maybe further load is there. Those equipment are heavy. They have heavy electrical load.
I understand, a nebulizer and a BiPAP, but I'm instructed that these are recent additions. He has been shifted temporarily. Because
but how can the writ court interfere here? You have a forum. I know it's prohibitive because of the 50%. But even then, we cannot just at our will. I mean, writ court cannot interfere like this.
But 22 kVA would be.
Has to be ascertained.
Amount is 16.45, which is quite, even half the amount is beyond his means.
No, obviously it is. I mean, but what
he
can
could
we
not attend the hearing.
Writ court cannot interfere here because it has to be ascertained. I mean, on facts. Then you are saying it's exorbitant. Definitely, I appreciate that.
They have to point out what appliances, how many ACs.
Need not a judicial authority, not a quasi-judicial exercise. That is the difficulty. Now, I understand the Act says that Act imposes certain liabilities which are civil in nature, civil consequences, because the money is involved. But the exercise is not even quasi-judicial. Absolutely fact-finding.
They arrive at a figure which prima facie
Let's go before the appellate authority.
May I submit? Kindly see when the order has been passed. Page 57.
they could not pay and my lord,
Kindly
that
see
is
the
why-
order. This is the nothing. This is a dilatory tactics to delay justice and to frustrate this final order of assessment.
If they
But there
could
is
not-
another history that there is another direct connection by his son, and on that basis he admitted and he has paid that amount. Kindly see page 57 on 2022. This order has been passed, and they have taken out this writ petition in 2024.
Because
Lordship,
they could
now
not-
at this stage they have to
not invoke the
and
remedy
no
of
objection.
statutory
Nothing has been on record.
There's a representation at page 63, which is on record.
That is post facto after the final assessment.
After?
Final assessment.
Yes.
After the final assessment.
2023, 27/6, 2023.
Well, he's my lord,
just for trying to
comorbidities
make
now,
out the
apart from a bypass surgery, I find but various neurological problems which have cropped up. He's in his late 70s, my lord, and
But the son is doing
there was-
this
there
on the
was-
basis of, on the pretext of power of attorney.
Why did you wait for 2 years? What were you doing during these 2 years? You
I
were in the
could
same
not, my
condition.
lord, I was shifted from there, and there's a solar connection, my lord, which was taken. Somehow, my lord, surviving.
No. Even your appeal is hopelessly time barred. 2 years.
Appeal, my lord, will not, because of the 50% thing.
What can the court do? I mean, we cannot adjudicate 21.4 kV or whatever that this is a heavy load. Can I say that?
Let my lord will kindly the delay
Wrong,
in filing the appeal.
Wrong instruction.
No, his instruction was something even.
Oh, even I cannot interfere here, sir. As the previous matter, what will they consider even after 2 years?
Everything stays and the orders are there.
It has been disconnected already.
Already disconnected in the 2022.
Oh, then
Yes, at that point of
Naturally,
time.
you
And
continue with the
nothing was
solar
done.
panel.
That is not enough. But I have been shifted from. Man, that is not enough for the BiPAP machine, and
But they are sitting tight over this matter for almost 2 years.
with 8 lakhs, one cannot sit anything. How but tight?
No, I won't.
Kindly, my lord,
The petitioner challenges final order of assessment made on the allegation that the petitioner was guilty of tampering of electricity meter, of unauthorized use of electricity. Push up next para. Learned counsel for the petitioner contends that the petitioner has given a representation to the distribution licensee indicating that the petitioner is suffering from a serious heart condition and has to be on medical equipment. Pushed up next para, it is submitted that the amount claimed was exorbitant. Pushed up, learned counsel submits that even as per the final order of assessment, comma, the alleged load used by the petitioner was 21.9 kVA, which is palpably exorbitant, comma, since a small family like that of the petitioner could not by any stretch of imagination use such heavy load for a domestic connection. Push up next para. It is further argued that the petitioner could not attend the hearing on the provisional order of assessment since the anticipatory bail was to be taken up on the same date. Pushed up next para. It is argued that the exorbitant amount claimed from the petitioner is entirely beyond the means of the petitioner and ought to be interdicted by this court. Push up next para. Learned counsel for the WBSCDCL says WBSCDCL submits that the petitioner has filed the writ petition as a dilatory tactics. Pushed up. The final order of assessment took place in the year 2022 when itself the disconnection of the electricity supply of the petitioner took place. Pushed up. For 2 long years, comma, it is argued, comma, the petitioner was sitting tight over the matter and has only come up with the present challenge now. Push up next para. If the petitioner was aggrieved, comma, the appropriate remedy before the petitioner lay before the appellate authority under section 127 of the Electricity Act 2003. Push up next para. It is further argued by the WBSCDCL that the petitioner's son was also guilty of overdrawing, comma, on which count the petitioner has paid the due charges. Push up next para. despite having sympathy for the current condition of the petitioner, comma, even the appeal which is provided under the statute comma, that is under section 127 of the 2003 Act, comma, is hopelessly time barred now. Full stop. The final order of assessment was passed in 2022, whereas the present writ petition has been filed only in 2024. Full stop. It is well settled that what the petitioner cannot get directly cannot be granted indirectly, comma, particularly by the writ court sitting in the writ jurisdiction which does not have the trappings of a civil court to ascertain factual allegations and counter allegations upon taking evidence. Full stop. It is, comma, now, comma, too late in the day for the petitioner to challenge the final order of assessment, having failed to avail the necessary provision of appeal or having preferred any other challenge within a reasonable time. Full stop. Thus, comma, the writ court cannot interfere with the final order of assessment made by the WBA-CDCL. In such view of the matter, comma, WPA 809 of 2024 is dismissed
will
from
not
contempt
shut all doors, there's a approach
without
made to the
without any orders to cause. Yes, Mr.
there's an approach made to the authority,
Full stop. It is made clear that nothing in this order shall prevent the petitioner from approaching the WBA-CDCL with seeking installments in paying off the dues. Full stop. If so approached, comma, the WBA-CDCL, comma, it is expected, comma, shall deal with the same sympathetically, keeping in view the current condition of the petitioner and his family, and decide on the said issue at the earliest.
Deeply.
17.
My lord, I'm for the petitioner, my lord.
Yeah,
My lord, in this case, my lord, the petitioner,
State your union.
my lord, in the year
Left,
2000
right, center, everything covered.
my lord, but it is very unfortunate case before your lordship, my lord.
What is the matter?
In the year 2001, the petitioner, my lord, was arrested on the allegation that he is
Two
a
petitioners. Which petitioner
my
was
lord,
arrested?
petitioner number 1 is the wife and petitioner number 2 is the husband. Husband is inside the jail, my lord.
And
He had-
wife was also arrested.
No. Wife, my lord, he is the, my lord, the resident of the area Chonditola, my lord. He is born, brought up, everything here, my lord. But subsequently, in the year 2001, my lord, he was arrested on the allegation that
2001.
2001,
Acha, then
my lord, on the allegation that he came in India with the Pakistani passport with valid visa.
Pakistani or Bangladeshi?
Pakistani, my
Right.
lord.
Yes.
And my lord, he approached before the authority for visa.
You must have overstayed beyond the visa
My
period.
lord, my lord, but this is the allegation, my lord. This is the allegation, my lord. And he was arrested in the year 2001, my lord. Where charges submitted. He was released on bail in the year 2001, my lord. Then, my lord, he was facing the trial, my lord. He never evaded or never misused the liberty, attended the learned court below, my lord. In the year 2019, 9th December 2019, the learned, my lord, the Chief Judicial Magistrate, Additional Chief Judicial Magistrate, Chandannagar, my lord, Chuchuram,
what happened?
my lord, was pleased to convict him under the Foreigners Act for 3 years. He suffered the conviction period, my lord, served the conviction period, completed in the month of October 2022, my lord.
Yes.
Since then, my lord, there is no progress, but he is inside the jail.
Still.
This is the case before your lordship.
No. After your period is over, you are to be released.
Yes, he is inside Damdam Correctional Jail right till now.
So what have you paid in the writ petition for release?
For release, my lord, extraordinary judicial, and my lord, I have annexed one judgment of the Honorable Apex Court presided over by Justice Chandrachud and Justice, my lord, Hima Kohli, my lord, and I have annexed the judgment, my lord, on the similar circumstances. This Honorable Apex Court was pleased to, my lord, last annexure, my lord, page number 39.
Without any annexures. 30 তোমার আমার কাছে 39 টা আছে বলো ঠিক আছে বলো কি what is the proposition in that in my petition I'm without that annexure. However, lordship kindly goes through.
Give a copy to him then. Why this
Lordship
annexure?
goes through. My learned friend also has that, but I don't have, lordship.
Judgment will are subject to lordship's consent. It has got no applicability in this case. That was altogether a different issue. But even if not subject to lordship's.
No, I'm not hurt you. I'm hearing him. No. But the difficulty is this was passed under Article 142. If I pass this order, and if it goes in challenge ultimately to the same bench of the Chief Justice of India and Justice Kohli, it will be set aside because we don't have this power.
Just I'm referring.
That is the
your
difficulty.
lordship, that's the view, my lord, taken by
You, I have the same view. Maybe Mr. Banerjee and Mr. Galib also have the same view. Views don't matter. The law matters. What can we do in this context? Can we override the law? They must have been in detention because they have overstayed their visa. For deportation, maybe they'll be saying that. I'll ask them.
What I want to submit.
Anyway, you're relying on this. You say that he may be released.
He was released.
He was released.
He was released. My lord, the paragraph, my lord, 41, my lord, paragraph 13.
He had 5 children who are living here and other things.
Yes, my lord. And my lord.
You have only your wife.
No.
So
I have also my
numbers
children, father, mother.
I also have 5 children.
5 children, my lord.
That's it.
My lord.
Very
my
well.
lord, page number 31, my lord.
5 children, 1 wife and 1 mother.
Mother, father.
One father, everything. So you're on
all
equal
relatives, my lord. My lord, page number 31, my lord. Page number 31, annexure P3, my lord.
What is your age now?
My lord, now my lord, 47, my lord.
This person was 62. In the reported
My lord, what
judgment,
the human being is, my lord, has been, my lord.
Human beings are treated differently on several parameters.
And my lord,
some human beings are behind the bars. Some human beings are outside the bar. Some human beings are favored. Some are not. Human beings are treated differently. That's a well-settled principle of society.
Another humble submission on sympathetical ground is that this petition number 2, my lord, has suffered, my lord, brain stroke inside the jail, my lord, and he is undergoing treatment also, my lord.
That is a high ground. Yes, what do you say?
Subject to lordship's.
Who should say? I mean,
no, I am the answering.
Yes, what is your?
May I respectfully submit, lordship.
Why is he still in jail after?
2 parts.
That is the main.
My lord, even my lord, after my lord, a sentence is over. Not for a second, my lord, a convict or internee can be kept in the jail, my lord. That is a settled proposition. If so done, it tantamounts to, my lord, violation of Article 21, illegal detention. But here, my lord, the case is something otherwise, lordship. May I respectfully submit, my lord? Straight away, my learned friend has already submitted that he is a convict under Section 14 of the Foreigners Act. My lord, may I respectfully invite your lordship to page 30 of the writ petition. That is a conviction order. 2 parts are involved in this. One is fact in issue and the fact in law. Both things, my lord, kindly seize. Question of fact, kindly seize page 30.
Deported, repatriated.
Lordship, after the sole accused person, namely so and so, found guilty as per section CRPC for the offence punishable under section 14 of the Foreigners Act 1946, and he is hereby sentenced to suffer imprisonment for 3 years. After completion of imprisonment, the convict to be deported, repatriated to his own country, Pakistan, through proper channel. The concerned police state are directed to deport the accused in coordination with Foreign Regional Registration Office, in short FRO, after completion of sentence without. This is the second part. My lord, after he has completed this sentence, my lord, we tried to comply with the second part of the, my lord, conviction order judgment. My lord, what was the outcome, my lord? May I respectfully, my lord, hand over, my lord, the copy of the, my lord, the instruction given to me by the, my lord, concerned authority. It says, my lord, that we approached the Foreign Affairs Department of the Pakistan, my lord, that please you accept your national. They said, no, he is not our national. So, my lord, this is one predicament, nationality crisis of the my lord, this petition.
Then he'll become stateless, Mr.
Lordship,
Kaidi.
no,
He's a
second,
human being.
Lordship. Now, secondly, my lord, he says that nobody is Lordship. Secondly, my lord,
Pakistan consulate has formally disowned him.
they are telling that the aforesaid convict returned from, we sent him to Tihar jail. In compliance with the learned convicting code, the correctional home authorities transferred the convict to the Tihar jail at New Delhi on 24th February 2020 for the facility for facilitating him getting the consular access and as well as nationality verification, so that he may be deported, repatriated to Pakistan as per existing laws of land. The aforesaid convict returned from Tihar jail on 28 February 2020. After his return, his statement was recorded in prisoner's petition. The convict Sheikh Muhammad Ikram so-and-so confirmed that he was provided with consular access, but the Pakistan embassy failed to recognize him as Pakistani national since he is a resident of village Suchia, PS Chonditola, district Hooghly. So, my lord, now, my lord, this gentleman, my lord, he went, my lord, for appeal. Lordship.
No, complete this sentence at least, yes.
He went for criminal appeal from this particular judgment of conviction. My lord, now the criminal appeal is pending, my lord.
That is immediate. But what is his
No,
what is his status now? He's not a citizen of India, not a citizen of Pakistan. They have disowned. Where is he now?
He is in correctional home, lordship.
Why?
Lordship, kindly be because his criminal proceeding is pending. He has preferred an appeal from this conviction, and my lord, next date, my lord.
No, does that permit you to keep him in custody?
As because my
after
lord,
conviction is
may
over.
I come, my lord? So, my lord, next date, may I just fact in issue? Next date is, my lord, 21st February 20.
Criminal appeal is different.
Now, my
but
lord,
his conviction sentence period is over.
May I, but lordship, may I relate to now the fact in law?
We'll come to you.
Issue
I'll
of
come
law.
back in 10.
Issue of law, lordship.
I'm good.
Lordship.
Yes.
So, Lordship, the conviction order, my lord, contains, my lord, two part. One is conviction, the second part is deportation. My lord, in this case, my lord, in this kind of cases, my lord, what the government does is that those, my lord, convicts, my lord, who are awaiting deportation, deportation cannot take place because of, my lord, the embassy of the other country who are refusing, my lord. So we are having a different cell, my lord, different section in the correctional law, where, my lord, we keep this kind of, my lord, people who are awaiting deportation.
How is it different from the other cells?
They get all
Bathroom is better.
different cells, different sections, different enclosures with all.
Prison cell is a prison cell, Mr. Kali.
So, Lordship, prison cell is a prison cell, Miller. So, Miller, this is a case of deportation, not he's undergoing conviction or undergoing the sentence. So, Miller, this is the part, Miller, factual aspect of the matter, Lordship. Deportation part is awaited. Pakistan embassy says that no, he is not a national. We brought him back, Milord, and we have kept him in that particular condition, awaiting deportation, and criminal appeal is pending, Milord. We are not concerned with that. May I, Milord, respectfully invite your Lordship to the Foreigners Act, Lordship, that he is convicted with. May I, Milord, hand over, Milord, a copy of this Foreigners Act, Lordship?
Conviction
Your
period
Lordship,
he has already served. Sentence he has served.
So, as on date, Milord, Section 14, my learned friend is also that he holds a Pakistani passport, meaning thereby that he is a Pakistani national. Otherwise, he would not have had held.
What alternative do you have in mind if Pakistan refuses to?
So, Milord, there is, Milord. Now, Milord, if as on date I release him, the same Milord provision will be invoked. That is Section 14. Because, Milord, if your Lordship, Milord, kindly, Milord, comes to the definition of foreigner in the Foreigners Act, Milord, kindly, Milord, refers to, Milord, Section, Milord, 2, Clause A. May I, Milord, respectfully invite your Lordship, Milord, to Section 2, Milord, Clause A.
Yes.
Foreigner means a person who is not a citizen of India. So, Milord, if I release him today, Lordship, kindly, Milord, understands his prescription also, he will be in the same, Milord, footing that he is not a citizen of India. Now, Milord, there is a provision, Milord. Milord, the scheme of Foreigners Act, Milord, so far my understanding goes subject to your Lordship's correction, Milord, that it speaks of, Milord, only two, Milord, remedies. One is either detention or confinement, or, Milord, on parole. Milord, may I, Milord, respectfully invite your Lordship, Milord, to Section 3, kindly seize, Milord.
Yes.
Clause G, Milord, subsection 2, Clause G, shall be arrested and detained or confined. If this particular clause is read with Section 4, Milord, kindly see Section 4 once. Any foreigner hereinafter referred to as an internee, in respect of whom there is in force any order made under Clause G of subsection 2 of subsection 3. May I pause for a moment? Kindly Clause G I have referred to.
G?
I have already referred to?
Yes, yes.
Yes. Any foreigner hereinafter referred to as an internee, in respect of whom there is in force any order made under Clause G of subsection 2 of subsection 3, directing that he be detained or confined, shall be detained or confined in such place or manner, and subject to such condition as to the maintenance, discipline, and punishment of offences, and so on. So this part is over for him now because Section 14 is over. Now kindly see, second. Any foreigner hereinafter referred to as a person on parole, in respect of whom there is in force an order under Clause E of subsection 2 of Section 3, requiring him to reside at a place set apart. So kindly seize, Milord, once, Section 3, subsection 2, Clause E. If he is on parole, what shall he do? Shall comply with such conditions as may be prescribed or specified. That is, requiring him to reside in a particular place, imposing any restrictions on his movements, requiring him to furnish me all these, Milord. Clauses 1 to Clauses 9 will be, Milord, will be applicable to him, Milord, if he is on parole, although being a foreigner. So as long as he is a foreigner. Milord, if there is, Milord, identity nationality crisis, Milord, this law I find has provided a solution. May, Milord, kindly, Milord, respectfully refer to, Milord, determination of nationality, Milord, kindly refers to Section 8. Determination of nationality. When a foreigner is recognized as a national by the law of more than one foreign country, Here it is not the case. Or where for any reason it is uncertain what nationality, if any, is to be ascribed to a foreigner, that foreigner is may be treated as a national of the country with which he appears to the prescribed authority to be most closely connected for the time being in interest or sympathy, or if he is of uncertain nationality of the country with which he was last so connected.
What is the provision for deportation?
Lordship, deportation, my lord. My lord, it comes, my lord, within the foreign order. Lordship, foreign order kindly refers to the Foreign Orders 1948. There is a portion in the Foreigners Act itself, Lordship. A part of the book deals with foreign orders.
Foreigners order.
Foreigners order, Lordship. Sorry.
1948.
Lordship.
Yes.
My lord, kindly sees, my lord, para 5. No, that is para. Foreign order is referred to as para. Lordship, para, isn't it? It refers as para.
I don't know. You teach me.
No, it says para 5.
Yes.
It is referred as para, not rule or nothing.
Right. Since it's an order.
Yes, it's an order. So it says para 5, kindly sees, my lord, power to grant permission to depart from India. That is depart. No foreigner shall leave India, my lord. This is the, my lord, part. No foreigner. And now he is having one trammel.
No, deportation I'm asking. You are deporting him. That's a positive act by you. Not he leaving the country.
In that event, my lord, we'll have to refer to, my lord, my lord, I think, my lord, para 5 of the foreigners order will be the answer, lordship. And if your lordship kindly goes, para 14 kindly sees of the foreigners order, lordship. This refers to expenses of deportation. Where an order is made in the case of any foreigner directing that he shall not remain in India, or where a foreigner is refused permission to enter India or has entered India without permission, the central government may, if it thinks fit, apply any money or property of the foreigner in payment of the whole or any part of expenses or incidental to the voyage from India. So this is with regard to expenses part. And my lord, may I, my lord, respectfully invite, my lord, I think para 5 will be the answer, my lord, that I was referring to. Power to grant, power to depart. Because as on date, whether we can allow him to depart.
It is the other way around, Mr. Gali. This says he won't be permitted to depart from India.
If you have anything to
depart from India, not from jail.
Yes. No, there is one also, my lord, kindly sees sub-para 2 clause B.
Yes.
The foreigner's presence is required in India to answer a criminal charge. So as on date, he is to answer the criminal charge.
No foreigner shall leave India otherwise than such and such. And 2 says leave shall be refused. Leave means leave to depart India.
So as on
from India.
So as
he's
on
not
date,
asking to depart from India. He's wanting to live in India.
live in India, lordship. So his nationality is in doubt.
Integrate into the culture of India.
So, if it is, my lord, if his nationality is in doubt, my lord. So, my lord, because
where do you put him?
Pakistan has said.
Pakistan said no. So
no.
What do you do now with?
So, not determination of nationality section 8 will come into play. Determination of nationality.
That has failed. Last, yes. Suppose you determine Pakistan is the last country with which he was associated. What do then?
So now, my lord,
Pakistan is not accepting.
now second part, he is facing a criminal prosecution under the Foreigners Act as on date.
No.
Appeal, lordship,
No,
appeal.
he is not
That
facing
is
a
in
criminal
progress.
prosecution. He has been convicted.
How
He has
can it be-
served his sentence. Mr. Ghalib, there's a sea change between the two. He is
Lordship.
not facing a prosecution. He has been prosecuted. He has been convicted. He has served his sentence.
Right.
So he'll live for the rest of his life behind bars.
No, certainly not.
Pakistan is not taking him. What can we do?
Now, my lord, now so far as citizen part, so my Foreigners Act says that a person is a foreigner who is not a citizen of India. And my lord, as on date, there is, my lord, a paragraph 3A has been newly added that persons belonging to minority communities in Bangladesh and Pakistan, namely so and so. No, it is not applicable to him also. He cannot take benefit. He cannot take benefit of para 3A also. So now, my lord, may I respectfully invite to Citizenship Act. How many types of citizenship are there, my lord? By birth, by
He is
descent?
not a citizen. He is not a citizen
No,
of
if
India.
in doubt, what we can do?
There is no doubt he is not a citizen of India.
No, certificate of, may I
As a very well, if in doubt, please that.
Section 13 of the Citizenship Act. It says, my lord, page 20, may I refer?
Just read the relevant portion.
Lordship. The certificate of citizenship in case of doubt. Section 13 of the Citizenship Act. The central government may, in such cases, as it thinks fit, certify that a person with respect to whose citizenship of India a doubt exists is a citizen of India, and a certificate issued under this section shall, unless it is proved that it was obtained by means of fraud, false representation, or concealment of a material fact, be conclusive evidence. So if his citizenship is in doubt, today he is
Mr.
placing...
Ghalib, after having faced a conviction under the Foreigners Act, under Section 14 of the Foreigners Act, can there be even any doubt that he is not a citizen of India?
As because Mirror
Section 13 does not apply at all.
has come up with various documents issued by government authorities.
He has served a sentence under conviction
So,
under
Milord,
the
as on
Foreigners
date,
Act.
Milord, this is the
Unless he wins in that appeal, he cannot open that chapter.
Certain.
If he wins in the appeal, then 13.
Lordship.
What happens to him now? He stays back in jail. That is what we are on, not on the outcome of the appeal.
So, Milord, there is a provision for parole, Milord, as we understand from the Foreigners Act, the scheme is there.
Parole is still conviction. Section 3 scenario. Section 3 merges in Section 14. Anyway, what do you say, Mr. Banerjee? You are the central government.
Well,
Yes, what is your stand in there?
Lord, here, Lord, the complications, Lord, has been created by the petition. Because, Lord, when he was arrested, at that point of time, he was claiming that he is a citizen of India. Claiming to be a citizen of India, he produced the driving license.
No double punishment, Mr. Banerjee. He has been convicted, he has served his sentence, forget that chapter. Now what happens to him?
That chapter has been closed. Conviction. Lord, that is our duty to write before the consulate that yes.
You try to deport, that attempt has failed, he was in Tihar, Pakistan refused. Now what do you do with this person?
Now, Milord, subject to Lordship's sanction. Milord, suppose he is released. He is released. That means he will be escort free. What will be his identity?
No, that we can put riders on him.
Number
He'll report to the police station and other
The
things.
year 2001, he was released on bail. At 19, he faced the trial. He never misused the liberty. I mean to something.
Number one. Number two, either he has to apply for a fresh that under the Citizenship Act. That he
is not a citizen under the law.
Admitted. For such reason, if he wants to retain himself in India, then Milord, he has to apply.
Under which provision he will apply?
That Citizenship Amendment Act.
How citizen?
That I am not the citizen. I am not the citizen. I want to be a citizen of India.
Till then, what happens?
Milord, if it is applied.
As of today, what happens to him? He remains behind bar. He will not be granted a citizenship by the present dispensation.
Then, Milord, if he is released, what will be a status on the day even? Because when he was in parole, he was in a particular, because Milord, there will be complications. Again, Section 14 will come.
So
Again,
better to keep him behind bar. That is the crux of the term.
No, Milord, he has to apply. He has not applied for the citizenship.
He will apply for what? Citizenship?
Exactly.
After getting convicted under the Foreigners Act.
Now, Milord.
Are you serious, Mr. Banerjee?
Because, Milord.
Are you serious? He will be given that citizenship.
Yes, no.
He suffers 3 years in jail, being convicted. He'll be given a citizenship now.
Then, my lord, why?
That will be magnanimity of the first order,
Now, my lord,
which is not expected of any government
admittedly.
in the world
Now, my lord,
regarding
according to the
foreigners.
Constitution of India, my lord, we cannot retain him scot-free.
So give him, hang him.
We cannot.
That will end the problem.
We cannot.
Hang him. Because let him not be in the land of the living then.
We have tried.
He's a person without being a person. He's a human without having any, being denuded of every human right conceivable. He's in jail without, even after the conviction period is over. Either you formulate something the union government or the state government cannot, because this is union list.
Yes.
You have to formulate some some methodology for these people. And they cannot be put in ghettos. Or you enact a law, let it be tested before the Supreme Court. Probably it will pass muster in the Supreme Court also, that till let them be hanged. Because they don't have the right to live. If they have a right to live, Mr. Banerjee, an essential corollary implicit in it is they have the right to live with dignity. That has been settled beyond repair, if I may use the expression. So either they live or they die.
Because, my lord, he cannot be scot-free. Because, my lord, if he commits something, then
more Indians commit something than foreigners in India. There are a select few foreigners who belong to the elite group of terrorists who are permitted to commit, and they have the most protection in India. See Kasab's case.
my lord,
Most protection in India. All human rights groups will come for those people, not for these non-elite people who fall underneath the public gaze. They will never be on the newspapers, Mr. Banerjee. These are common people who breathe on our necks, on our consciences. So we have to do something for these people. Very well, he can be put to terms. Can be put to terms like a bail order or a parole order. Yes. But he cannot be behind the bars forever.
but we are not trying to.
No, I'm not saying that you are at fault. I mean, this is a gap in the law, which is a fit case for the 226 court to interfere. That order record. The petitioner claims to be a resident of Chonditola, Hooghly, in West Bengal. Push up next para. However, the petitioner.
Petition number 2, my lord.
I'm sorry. Thank you. The petitioner number 2. The petitioner number 1 is his wife and is a co-applicant in view of the nature of the reliefs claimed. Push up next para. The petitioner number 2 had come with a Pakistani passport and a valid visa to India in the year 2001. Push up. Subsequently, the petitioner faced trial under the Foreigners Act and was ultimately convicted in the year 2019 for 3 years. Push up. Accordingly, the petitioner was incarcerated, which ended in the month of October 2022. Push up. However, although under normal circumstances, the petitioner ought to have been released from prison. All of you, please take your seats. Yes. Released from prison after exhausting his period of sentence, the petitioner has still been retained in imprisonment. First up, the petitioner seeks release from the prison and to live a life of dignity. First up, next para. It is contended by the petitioner through counsel that the petitioner has a family of several members, parents, a wife, and several children. First up, as such, the petitioner seeks to reintegrate into normal life and not spend the rest of his life behind bars. First up, next para. Learned counsel for the state places reliance on the conviction order of the petitioner. First up, the same envisaged that after the petitioner suffers imprisonment for 3 years and pay fine of rupees 10,000, in default simple imprisonment for 6 further months, the convict, that is the petitioner number 2, was to be deported / repatriated to his own country, Pakistan, through proper channel. Pushed up, next para. It is contended that the modality which has been adopted universally by the state and in India as well is that in such cases, pending deportation, comma, a person is kept in a different cell from an ordinary prisoner, but within the prison precincts. Full stop. In the case of the petitioner, comma, it is submitted, comma, the petitioner was transferred to the Tihar jail, comma, for the purpose of having easier access to the Pakistani consulate. Full stop. However, comma, it transpires that the Pakistani embassy has refused to recognize the Pakistani citizenship of the petitioner. Full stop. Thus, comma, it is submitted that the petitioner cannot be deported immediately, for which he has been retained in custody, but in a different cell. Full stop. Next para. Learned counsel for the state places reliance on Section 2 of the Foreigners Act 1946, which defines a foreigner to mean a person who is not a citizen of India. Push up, it is contended that since the petitioner is not a citizen of India, comma, he cannot be permitted to live a life akin to citizens of India, standing otherwise on similar footing. Push up, learned counsel places reliance on Section 3, subsection within bracket 2 of the 1946 Act, which provides that in particular and without prejudice to the generality of the foregoing powers as stipulated in Section 3 within bracket 1, comma, orders may be made under the section, comma, inter alia, comma, including the power to arrest and detain or keep confined such a person. Full stop. Next para. It is contended that there is provision for grant of parole to such persons as well. Full stop. Next para. However, comma, it is submitted that the petitioner, comma, unless deported or granted a citizenship, comma, does not have the right to live like other citizens of India. Full stop. In this context, comma, learned counsel for the state cites Section 13 of the Citizenship Act 1955, which provides that the central government may, in cases as it thinks fit, comma, certify that a person with respect to whose citizenship of India a doubt exists, comma, is a citizen of India, semicolon, and a certificate issued under the section shall, unless proved that it was obtained by means of fraud, comma, etc., be conclusive evidence that the said person was such a citizen on the date thereof, but without prejudice to any evidence that he was such a citizen at an earlier date. Push up. Next para. Learned counsel for the Union of India submits that there is no option but to deport the petitioner, comma, which cannot take place immediately due to the refusal of Pakistan to take in the petitioner. Full stop. Next para. It is highlighted by learned counsel for the Union that the petitioner had come in with a Pakistani visa, a Pakistani passport, and was granted a limited visa, upon overstaying which he was convicted under the Foreigners Act. Full stop. Hence, comma, the position remains that the petitioner is a foreigner and cannot get rights on parallel footing as citizens of India. Full stop. Next para. It is relevant to mention here that learned counsel for the petitioner has cites an unreported judgment dated April 29, 2022 of the Supreme Court of India in the case of Anna, A-N-A, Parveen and another versus Union of India and others. Full stop. In the said judgment, comma, the Supreme Court was considering the case of a Pakistani national who had come into India and married here and had 5 children. Full stop. Next para. The petitioner, comma, it was observed, comma, had 5 citizens who were Indian citizens who reside in Meerut, as does their mother. Full stop. It was observed that that 7 years had elapsed since the father of the petitioners had served out his sentence following the conviction under the Foreigners Act. Full stop. In the said backdrop, the Supreme Court was of the view that it would be appropriate if the Foreigners Division of the Union Ministry of Home Affairs takes a final decision on the representation of the said petitioner for a grant of a visa stroke long-term visa, having regard to all the facts and circumstances of the case and after assessing the inputs from the security angle. Pushed up, the petitioner therein was put to a personal bond of rupees 5,000 with two sureties of Indian citizen of like amount, and was directed to furnish his address of his place of permanent residence to the local police. Push up next para. Certain aspects of the matter are required to be considered. Push up. The petitioner, even after serving out his sentence, is still in prison. Full stop. Next para. Although it is contended by the state that the petitioner has been put in a different cell than other prisoners, after all, a prison cell is a prison cell, by whatever name called. Full stop. Next para. The detention in a cell, in the confines of a cell, is in outright contrast with human liberty granted to a citizen or a human being otherwise than if he is serving a sentence under due process of law. Full stop. Next para. In the present case, we are to look into the interplay between Articles 14 and 21 of the Constitution of India. Full stop. It is noteworthy that neither of the said articles are restricted to Indian citizens but are available to any person on the soil of India. Full stop. In fact, the right to equality before the law and equal protection before the law, as well as the right to live a life of dignity, does not flow from the Constitution but has merely been recognized by the Constitution. Push up. Such rights are implicit human rights which are inextricable from a life worth being called a human existence, and a person cannot be denuded under any circumstances from the said two rights. Full stop. Next para. Unlike Article 19, which has been given to citizens of India and is subject to reasonable restrictions of law framed by the Parliament, Articles 14 and 21 are unfettered in that sense and are available to any human being on the soil of India. Full stop. Next para. As such, the petitioner, having completed his sentence, cannot be retained in further custody, in any prison cell, of whatever color, texture or dimension. Full stop. Next para. The petitioner is entitled to live a life of dignity. So a person denuded of the right to live a life of dignity has a life worse than a human being and maybe a little better than an animal, which is not desired under the conspectus of any human civilization. Next para. In the present case, the reliance of the state on Section 13 of the Citizenship Act 1955 is misplaced, since the petitioner has already undergone a sentence being convicted under Section 14 of the Foreigners Act. Full stop. It is anybody's guess as to what would happen if the petitioner now seeks to apply for a citizenship, since his citizenship is no longer in doubt. Full stop. He came in as a Pakistani national and overstayed his visa, which has been vindicated by the court of law by convicting the petitioner. Full stop. Hence, under no stretch of imagination can the petitioner take advantage of the doubtfulness contemplated in Section 13 of the Citizenship Act to seek a fresh citizenship of India. Full stop. Next para. Insofar as Section 3 of the Foreigners Act is concerned, the said stage is over for the petitioner, since the said chapter has already merged into his conviction under Section 14 of the Foreigners Act 1946, which is a subsequent stage. Full stop. Although an appeal is apparently pending at the behest of the petitioner against the order of conviction, comma, the best outcome of the same would be that the conviction is set aside and it might be left open to the petitioner to দুবার ইচ্ছা করে reclaim his claim of Indian citizenship. Full stop. If such a state of affairs come to pass, comma, there would not be any further reason of giving any protection to the petitioner. Full stop. However, comma, till and if that happens, comma, the petitioner has been kept in custody, comma, being in a no man's land since Pakistan is refusing to take back the petitioner and disowning him, and the petitioner having been proved beyond reasonable doubt by his conviction, at least as of today, comma, to be a foreign national. Full stop. Next para. For such persons, comma, there is a glaring chink in the armor of the law of the state, comma, which is a precise scenario where the writ court ought to interfere to protect the fundamental rights ensured to the petitioner and recognized under Articles 14 and 21 of the Constitution of India. Push up. Next para. However, comma, this court is not unmindful of the fact that the central government is the ultimate authority, comma, being the executive, comma, whose powers ought not to be interfered with readily by the judiciary, comma, to decide as to the ultimate fate of the petitioner. If the central government takes resort to any law or regulation to consider a grant of extended visa or long-term visa to the petitioner, comma, it is for the central government to consider the same. Full stop. Also, comma, if the petitioner ultimately wins his appeal against the conviction, comma, the petitioner may have other avenues open to him. Full stop. However, comma, till then, comma, the court must come to his aid. Full stop. Next para. Keeping in view the safety considerations which may exist in the perception of the union government, comma, the petitioner is required to be set free, but under certain conditions. Full stop. Accordingly, WPA 1323 of 2024 is disposed of by directing
Petition number 2, my lord.
Pardon?
Petitioner number 2.
Yes. By directing the respondent number 8, that is the superintendent Damdam Correctional Home, to release the petitioner upon the petitioner furnishing.
Release the petitioner number 2.
I'm sorry. Release the petitioner number 2 upon the petitioner number 2 furnishing a bond of rupees 10,000 with 2 sureties of like amount each, comma, each of whom should be local, comma, residing within the territorial jurisdiction of the police station where the petitioner intends to go back, that is village Suchia, comma, post office Masat, MASAT, comma, PS Chonditola, comma, district Hooghly, comma, pin code 712701. Full stop. Next para. Such release of the petitioner shall, comma, of course, comma, be on condition that the petitioner personally meets the officer in charge, stroke inspector in charge of the local police station having territorial jurisdiction of the area of his permanent residence once every month. Full stop. Next para. In the event the petitioner is required to be present in connection with his appeal or before any law enforcement agency or other authority in due process of law, comma, the petitioner shall make himself available for any inquiry, stroke investigation, stroke appearance before such authority, also in due process of law. Full stop. Next para. The petitioner shall not ordinarily leave the territorial jurisdiction of the district of Hooghly except without specific leave being obtained from the uh, uh, criminal court having jurisdiction. Criminal court will be too vague. Which court should I put it? What will be the trial court there?
Jurisdictional magistrate.
Very well. Without taking
That bond part also mean can direct judicial magistrate to be
right, I'll
executed.
put that.
Bond part.
Without specific leave being obtained from the jurisdictional magistrate of the locality of his permanent residence. প্রথমে যেখানে ওই bond furnished যেখানে bond করেছি subject to the satisfaction ওই bondটা যেন criminal subject to the satisfaction of the magistrate having of the jurisdictional magistrate having territorial jurisdiction of the area of permanent residence of the petitioner. Full stop. Next para. It is made clear that nothing in this order shall create any special right or equity in favor of the petitioner, which the petitioner does not have in law and under the Constitution of India. Full stop. Moreover, comma, the petitioner will be at liberty to apply for extension of his visa before the appropriate authority and or for grant of long-term visa. Full stop. If such an application is made, comma, the concerned authorities shall decide the same in accordance with law. Full stop. Next para. Moreover, comma, the petitioner shall also be at liberty to proceed with his appeal against the conviction order. Full stop. The present order shall be subject to whatever subject to the outcome of such appeal and to any order which might be passed by the appellate court at the time of finally deciding the appeal of the petition. Full stop. No rest to cause urgency.
Lordship. I'm grateful, my lord.
Thanks, sir. Lordship. এই দুই আমাদের কি?
Okay. 18.
Yes, Shamth, what is the matter?
I am for the petition.
Right.
3 and 4.
Service was not.
Was all.
Was not the man.
You are for the main answering respondent?
Yes, ma'am.
Thank you. Yeah.
The petitioner took a loan from bank, my lord.
Yes.
The Bank of India. My lord, the allegation was he defaulted. My alleging default, bank had repossessed the vehicle of the petitioner and took into their custody. My lord, thereafter, my lord, petitioner approached for settlement. Settlement was done. Bank accepted entire money as per settlement, and thereafter, your lordship kindly come to page 21. The first letter written by the bank to the.
You paid the entire amount of one. Then?
My lord, the bank said their agency to release the vehicle,
right,
through whom it was seized.
Yes.
My lord, thereafter, my lord, agency took the parking charge. Your lordship kindly come to page 22.
All right.
Entire parking charge paid.
Yes.
Thereafter, no vehicle was not released. My lord, page 23, my lord, NSTP4, 22, my lord, again made a representation to the bank for release of the security interest. My lord, not released, my lord.
Till now not released?
No. My lord, thereafter, my lord,
complaint to ombudsman.
My lord, time to time, up to P6, I made successive representation for return of my vehicle.
Ultimately P7.
P7, my lord.
What has the ombudsman done?
Ombudsman, they are saying, your lordship kindly see, cooperate with the bank and judicial procedure we need against the agency.
What is that?
Page 27. Last sentence, my lord.
Oh, bank has written to the ombudsman.
Bank says, bank had seized the vehicle through the agency. Now the bank is expressing inability not to, my lord, by not releasing the vehicle, my lord. My lord,
no, what is this? It's your liability. Absolutely your liability. Whichever agency you engage, that's your headache.
Lord, your lordship will kindly turn to page 24. Lord, my learned senior friend has stated some facts.
Yes.
But he is also aware of other facts.
Right.
Lord, will kindly see. Lord, this is a letter which is written by the petitioner to the bank manager. Lord, kindly comes to second paragraph. Finally, bank has provided me a release order on 20th March 2021 and instructed Mr. Anindya Chakraborty in charge of city investigative and detective to provide the vehicle by taking his parking fees at time of delivery. So, my lord, we had given the release order to the respondent number 5. Now, my lord will kindly turn the next page. This is another representation on page 25. Lord will kindly see second paragraph. First paragraph itself, last lines. Your bank is unable to find Mr. Anindo Chakraborty, the seizing agent.
Where is that?
My lord, this is page 25, first
Yes.
paragraph,
First
third last
paragraph.
line. Your bank is unable.
Yes, yes.
Your bank is unable to find Mr. Anindo Chakraborty, the seizing agent, along with my vehicle WB051666. Your bank has communicated a GD against the issue in Dhola police station nearly 2 months back, which has no result till date. So, my lord, the petitioner is aware that a police complaint has been filed by the respondent number 3. Now, next, from reliable sources, I come to know that my vehicle is plying with different vehicle number WB23C9107 in bypass route so and so to Dankuni by changing the color from blue, yellow to white, red. After which I have several hide by that particular bus to identify the truth. So, my lord, the petitioner himself took steps to identify the bus number. As a proof, my lord, second last line in the same paragraph. As a proof, I am enclosing a ticket in bus number, validation to your bank, particular number plate, changed vehicle plying on road. So, my lord, the bank had passed a release order, directed the respondent number 5.
You are not absolved. That is the security, the secured asset. You have to return that. It's entirely your liability.
My lord, the police complaint has been filed, FIR has been
Whatever,
registered.
that's your headache, as I told you. Bank cannot have a headache unless it pertains to the head office, but it can have a problem. It is your problem. The bank, after one-time settlement, him having paid all the amount, it's your liability, entirely your responsibility to return the vehicle. If you can't, then he is entitled to huge damages.
My lord, but my lord, the vehicle is different. My lord, the procedure is going on. Kindly see.
You return him his vehicle, there is no problem.
My lord, that is the issue. My lord, the chassis number is different. The vehicle which my learned senior...
Whatever chassis number his vehicle have, you return that vehicle to him. It's your problem.
No, that would then...
That's a secured asset. It's still in your custody till it takes custody.
No, then that, if the chassis number is different, no, there is a doubt with regarding to the vehicle, whether the vehicle which is with the in the possession of the bank is actually that of the petitioner or not. No, that is a question. If
you cannot open up that question after having taken it as a secured asset and gone for a one-time settlement and he having paid the amount.
Milord, the bank has absolutely no difficulty in handing over back the asset. Milord will kindly see page 26. Milord,
then hand it over. Whatever was with you, hand it over.
Milord, once the identification is
Why
complete,
should he run from pillar to post? Your agency. City is your agency, city investigation. So your agent, you are the principal.
Milord, the bank has taken steps. Milord, an FIR has been filed. Milord, the investigation is going on. So, Milord, till the time there is identification of the vehicle, Milord, till that time I am not able to hand over the vehicle. Once that is done, we'll not hand it over. Milord, we'll see page 26.
What was the amount of one-time settlement you paid?
Milord, 1,80,000 rupees. Page 26, third paragraph.
Then I'll direct you to return that entire amount along with costs, along with interest. Along with interest. Return
Milord,
the entire amount and he remains absolved of the debt.
Milord will kindly allow me to
That is
come
by
back.
way of compensation to him.
Milord will kindly allow me to come back with a reply, place all facts on record. Then Milord will pass any orders your lordship sees fit.
I am permitting that only because that will be the first ground in appeal and this order will not serve any purpose. If I don't permit you to file opposition. That's the only reason I am permitting you. And also for ascertaining, you also keep in your mind, if you draft it or settle it, keep in your mind the component of compensation also. That is in my mind. I'll put something in my order to help you with your client, the bank. I'll direct affidavit, short affidavit. I mean, you just disclose these facts only. I'll give you 2 weeks' time. The petitioner has raised a valid question which is arguable and requires to be decided on merits. First up, the petitioner took a loan and mortgaged his vehicle with the respondent number 3 bank.
Well,
3 bank. First up, next para. Subsequently, a one-time settlement was entered into between the bank and the petitioner, which was duly serviced by the petitioner. First up, thereafter, the bank issued a release order of the vehicle of the petitioner with registration number WB05G1666 on March 20, 2021, within bracket annexure P2 at page 21 of the writ petition bracket closed, to the bank's agency, which was in custody of the vehicle. First up, the petitioner subsequently, as per the instruction of the bank, paid the full parking charges of rupees 25,000 to the said agency of the bank. Full stop. However, comma, despite having given several representations thereafter and running from pillar to post, comma, the vehicle has not yet been returned to the petitioner. Full stop. In fact, comma, the petitioner has learned that the entire vehicle has been repainted and the chassis changed and is plying elsewhere, comma, which was also indicated in one of the representations given by the petitioner to the bank. Push up next para. The bank took a stand that they have lodged GD entry and are taking due steps in the matter. Push up, however, comma, the petitioner, comma, it is submitted, comma, cannot suffer for the laches of the bank. Push up next para. Learned counsel for the bank submits that the bank has done its level best in seeking to return the vehicle to the petitioner. Push up, in view of its agency being unable to do so, comma, the bank even lodged a general diary entry with the police authorities. Push up, that apart, comma, learned counsel for the bank contends that since the petitioner now states that the chassis number of the chassis number of the vehicle is altered, comma, it casts a doubt as to whether the vehicle which was handed over to the bank was actually the vehicle belonging to the petitioner. Full stop, next para. Insofar as the identity of the vehicle is concerned, comma, the said chapter cannot be reopened by the bank in view of the bank, comma, being duly satisfied under the banking norms, comma, took the vehicle in question in mortgaged as secured asset and granted a loan to the petitioner. Full stop. Not only that, comma, subsequently the bank also entered into an one-time settlement with the petitioner and taking full advantage of the same on the strength of the said secured asset, comma, also took the entire money in terms of the said settlement from the petitioner. Having done so, comma, the bank is stopped from raising a question as to the identity of the vehicle at this belated stage. Full stop. Insofar as the custody of the vehicle with the bank's agency is concerned, comma, the principles of law regarding principal and agent apply. Full stop. It is the bank which has the liability and responsibility to return the secured asset, that is the vehicle in question, to the petitioner as it is. Full stop. If the bank fails to do so, comma, it is always open to the petitioner to seek appropriate damages. Full stop. However, comma, learned counsel for the bank seeks to use an affidavit in opposition to controvert the allegations of the petitioner and to bring on record and enumerate the exact lines of defense which the bank intends to take in the writ petition. Full stop. It would only be fair to grant the opportunity to the bank. Full stop. Accordingly, the respondents are directed to file their affidavit within bracket S in opposition to the writ petition within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. The matter shall be listed on April 2, 2024 under the same heading for hearing. Full stop. It is made clear that the above observations have been made only at the interim stage and shall not be binding at the final hearing of the writ petition.
Maintainability as well. So, my lord,
why maintainability?
My lord,
Private
because-
bank,
No,
not
my
a
lord.
nationalized bank.
No, my lord, my humble submission would be that there is an alternative remedy available. So, my lord, we'll kindly keep the point of
Before
view.
where?
Lord,
Alternative remedy
my
before
lord,
which
because
forum?
my lord, the suit court, because my lord, my learned friend is seeking damages here.
Very good. It is further clarified that the question of maintainability of the writ petition is kept open since learned counsel for the bank raises a question as to whether a claim of damages is maintainable in the facts of the case before a writ court. Full stop. Such questions shall also be decided at the time of final hearing of the writ petition along with the other issues.
Great, my lord.
Thank you.
19.
For the private respondents.
You're for the
Private respondents.
Private.
Number 6 and
19 I appear for the petitioner, your lordship. I am for the state respondent.
Yes. What is the matter?
My lord, the petitioner before your lordship, my lord, is a licensee.
File your affidavit of service all the same, Missy.
My lord, yes.
Yes. Licensee?
My lord, is a licensee. On 28th of September 2022, there was a live-in license agreement, my lord, for a period of 3 years. It is going to expire, your lordship, on 28th of September 2025. There were two clauses, my lord, in that agreement. One is that I am under an obligation to pay the electricity charges, and there is a lock-in period of 1 year. My lord, on March 2023, after a period of, my lord, 5 months, 6 months and odd, my lord, what happened, my lord? The electricity was disconnected overnight. My lord, I filed a complaint before the police station. I came to know, and my lord, prior to that, there was an NOC provided to me by the licensor in my favor, wherein it is stated that the electricity connection was in the name of a sole proprietorship firm of her husband. So she has no objection to provide me the electricity from that connection or under that meter. My lord, accordingly, my lord, that is annexure P3 at page 73.
The meter was in name of?
The sole proprietorship firm of the husband of the licensor.
But your licensor is 6, Madhubala.
Yes, of her husband. She has given the NOC. Yes. Now, my lord, I came to know that, my lord, the connection was temporarily, my lord, disconnected. The electricity connection. I have filed an FIR. Thereafter, my lord, there was a section there. It has an arbitration clause in it. So, as per section 9, I have gone to the court, asked for, my lord, resumption of my electricity connection. It was directed.
What now?
My lord, now, my lord. Thereafter, my lord, I have applied. I have communicated those orders before the WBSCDCL, the authority. Yes, I have applied for a new connection.
Not given.
Not given.
Why?
My lord, the only point that they have seen is the permission of the landlord. Yes, my lord, but my respectful submission
That
to
has
your
been
lord.
given to you in writing.
Yes, my lord, 211, page 211.
Yes.
That is the, my lord, that is the way leave permission that I have to obtain from the.
Otherwise, they are agreeable, apparently.
Yes. And my lord, according to section 43, your lordship is well aware, my lord, there are judgments to that effects of 3 judges bent of this court as well. That, my lord, settle proposition that if I am an occupier.
WBSCDCL first.
Yes.
Yes. Who is for the WBS? Yes. What is your stand? As he says, you are agreeable if he complies with this way leave.
That is the problem.
I'll come to you last. Yes. Nobin Agarwal, husband. All right. No, he has asked for a new connection now.
The subtenant of
He's a licensee. Worse than a subtenant.
Promoter, that is the petitioner. He is not the actually.
I am the occupier.
I don't understand. Yes.
He gave the objection.
7. 7.
Yes, connection we have disconnected as or no.
Yes. You are not being faulted for that. Now he is wanting a new connection. What is your time? Yes. What is your stand?
My instruction.
Yes.
There is multiple proceedings is running.
Someone, you don't have any stand. You take your seat. Yes. I am asking for his stand.
Yes. They are stating about in March 23, they have used the electricity.
They are entitled to get electricity.
Yes,
How do you object?
but they are using till date from our meter.
No.
It till September, lordship.
They have lodged diary that you have disconnected. They'll take that risk.
They
will come and see that there's
lordship in the same meter number which they have been provided to use. We have the proof till September 23 bill has been raised.
After that, what happened?
Till September, after September 23, we don't have the proof. They are talking about March 23.
Let them get a connection. What is your objection?
They are using, lordship. They are using for our connection.
No.
Existing connection is there. In the name of Mr. House Enterprise.
It's your only objection. That's why they cannot get a new connection.
But they are using already. Already they are using from our connection. They are paying.
That's why they spent so much and paid the fees of Mr. Mondal and his learned junior.
Lordship, kindly, they want contempt pending till date with CPN number 870-2023.
That has no connection with this.
Lordship, the same matter, one title suit is pending before the.
Cannot be same matter. Title suit is pending at whose behest? Who has filed?
This Electromotor Private Limited, he has petitioner here. He has
suit for
paying electricity. In the 6th London 6th Civil Judge Junior Division at Howrah.
Have you got a copy of the plate?
My lord, it has been withdrawn, my lord.
We don't have any such.
Withdrawn order.
So this is your objection. Can I keep this on record?
This is already they have filed.
Can I keep this copy of plaint
No,
on
no,
record? Have you
yes.
got an extra copy?
Yes, we have.
I'll grant them electricity. I'll record your submissions.
But they are using electricity, Lordship.
They have another kind of luxury, fun. As- uh, no. Why should they complain? Yes, obviously, Miss Moitul, obviously. That has become a part of my habit. Even when I ask for a cup of tea in my home, I say after complaints of due formality. Now it has become a habit after taking electricity matters. So I get castigated for that in home. Learned counsel for the petitioner submits that the petitioner is a licensee under the respondent number 6, push up. However, the electricity supply at the premises has been stands in the name of an enterprise of respondent number 7, the husband of the respondent number 6. Push up. One of the terms of the license was that the petitioner would be entitled to use electricity from such connection. Push up. However, it is alleged that the electricity was disconnected, for which the petitioner had to take steps, including lodging a formal complaint before the police authorities. Push up. Next para. As such, the petitioner argues that on the strength of section 43 of the Electricity Act 2003, the petitioner, being in settled possession of the property, is entitled to electricity, but having applied for the same, the CAC Limited is taking a sorry, CAC bole thakle sekhane WBC. The WBACDCL is taking a point that the petitioner has to produce way-leave permission from the private respondents. Pushed up. Next para. It is argued that the same that such insistence is dehoors the law. Pushed up. Next para. Learned counsel for the WBACDCL submits that the meter stands in the name of an enterprise of the respondent number 7, and as such, the petitioner can take connection from the said meter. Push up. However, insofar as an independent connection is concerned, the WBACDCL does not have any objection on principle to give such connection, subject, of course, to compliance of all formalities by the petitioner. Push up. Next para. Learned counsel for the private respondents argues that the petitioner has made incorrect allegations against the private respondents. Push up. In fact, the petitioner is continuing to enjoy electricity supply from the electricity meter of the respondent number 7. Push up. As such, it is argued that there is no cause of action for the present writ petition. Push up. That apart, learned counsel for the private respondent places reliance on the fact that a suit is pending on the self-same cause of action at the behest of the of the petitioner. Push up. Hence, the prayer in the writ petition is opposed by the private respondent. Push up. Next para. Learned counsel for the petitioner, while reiterating his submissions in reply, points out that the suit previously filed by the petitioner has since been withdrawn. Push up. Next para. In the facts of the present case, what cannot be doubted is that the petitioner is admittedly in settled possession of the property insofar as the right to get electricity under section 43 of the 2003 Act is concerned. Push up. Next para. With regard to the continuance of enjoyment of electricity by the petitioner from the connection of the private respondents, the said assertion by the private respondents is dubious, since it is not credible that the petitioner would run from pillar to post, taking out complaints before the police and filing writ petitions and a suit previously for a cause of action which is illusory, despite enjoying electricity from the private respondents. Push up. Next para. In any event, the fact that the petitioner has been filing complaints against the private respondents and instituting suits and lodging and filing writ petition shows that the relationship between the petitioner and the private respondents is strained, which entitles the petitioner in his capacity as an occupant of the property to get an independent electricity connection in his own name. Push up. Next para. insofar as the suit is concerned, comma, the petitioner contends that the same has been withdrawn. Full stop. Even if the suit was pending, comma, the same could not have been a deterrent for assertion of a right of the petitioner against a public authority, that is the WBACDCL, comma, in view of the statutory right under section 43 of the Electricity Act 2003. Full stop. That apart, comma, the constitutional right of life under Article 21 of the Constitution of India, comma, it has been held time and again by several courts, comma, includes the component of a right to have a life of dignity, comma, which includes an electricity connection, comma, being a basic amenity, comma, being given to a person. Full stop. Next para. That apart, comma, the primary relief sought in the suit, which has since been withdrawn, was, comma, in any event, comma, a decree for declaration that the plaintiff is an occupier of the property, and that the agreement dated September 28, 2022 is valid, comma, operative and binding on both parties. Full stop. The declaration regarding electricity connection entitlement was only an ancillary relief and could not interdict the petitioner from taking out the present writ petition in any event. Full stop. Next para. In view of the above observations, comma, the insistence of the WBACDCL for production of a way-live certificate from the licensor is redundant and contrary to section 43, comma, particularly in the facts of the case, which shows that there is strained relationship between the private parties. Full stop. Accordingly, WPA 2202 of 2024 is allowed on contest, comma, thereby directing the WBACDCL to give electricity connection to the petitioner from the give metered electricity connection to the petitioner from the existing meter board position at the concerned premises within a fortnight from the petitioner complying with all due formalities in that regard. Full stop. Next para. If any obstruction is raised in any manner by the private respondents and or their men and agents in the WBACDCL personnel giving such connection, comma, it will be open to the WBACDCL personnel to approach the local police station. If so approached, comma, the inspector in charge, stroke officer in charge, comma, as applicable, comma, of the local police station shall give necessary assistance to the WBACDCL personnel at the cost of the petitioner to ensure that such connection is given to the petitioner. If need be, comma, the police personnel will be at liberty to remove any padlock or other obstruction if put up in the way of the connection being given to the petitioner. The parties shall act on the server copy of this order without insisting upon server copy for the purpose of compliance without insisting upon prior production of a certified copy. No arrest cost.
Your Lordship, only one factual
The copy of the plaint handed over by learned counsel for private respondent today be kept under. Yes, sorry.
My return for the state. One factual correction. There are two petitioners, two licensors, and two applications for electricity.
Separate applications?
Separate applications. P17 and page 190 and 198.
There are three applicants.
No, in page petitioner is 3. Licenses in the name of Electro Steel
and
Electromoto, and one is Sri Balaji Udyog. Yes. Well,
so making those plural will do that the
yes,
license
yes.
agreement.
Yes, your Lordship.
আপনি যেখানে পাবেন plural করে দিন, যেখানে কাটার আমি করে দেব।
Deeply obliged.
Thank you for pointing that
Deeply
out.
obliged.
Yes.
Deeply.
20.
Yes.
20, but I am for the state in this matter, my lord, appearing virtually to the lordship.
Again, you have refused premature release.
Yes, my lord. Grounds is there, my lord. My
Must be-
junior is there to hand up the, my lord, the report, my lord.
Yes. Report.
Yes, ma'am.
My lord, petitioner number 1 is the convict who is incarcerated for 34 years.
Please give a copy of the report to them also.
Grateful, my lord.
Lord, he is in not 34, my lord, 31 years, 1 month. The
30.
last report.
What is the great difference between the two, Mr.
No, that's 2 years, sir.
31
Only
years.
2 years. 2
You
years,
were
lord.
when you were 31 and when you were 34 and still now. So you are in. So there is no difference in that.
No, no difference, no difference.
Again, the same set of objections, sir.
Same mallet, same setup. But the here Milord, the section is 302, 34 and Milord Arms Act. Milord.
How long in custody?
31 as on
20
22.
Mr. Sinha, regarding Arms Act, they may have a good apprehension. You are he's right. Actually, I cracked a joke with him, but 34 years of age, Arms Act. I mean, you are in custody for how long you said?
31 year as on 2022.
Last meeting.
2 years in custody.
Custody, my lord.
What is your age?
My lord.
years, my lord.
56.
2
My
years.
lord, their report from probation officer is also okay.
Let me hear them. Yes.
My
you're
lord,
adding-
I am junior to Mr.
Yes, Mr. Bosumollik
Bosumollik.
says that he is in custody for 31 years something.
My lord, 31 dated 2022. My lord, we are in 2024 today.
So 32, 33.
Yes, my lord.
Yes.
And it's a premeditated, well-planned murder that has happened out there in public.
After 3 decades, he will still premeditate. It will be post-meditation, post-planning and everything post. But 31 years in prison, I mean, what remains? The petitioner has challenged the refusal of the petitioner's prayer for premature release by the State Sentence Review Board, within bracket SS. It is argued that the rejection is improper, without adhering to the National Human Rights Commission guidelines and the guidelines set by several judgments of this court and the Supreme Court. Next parallel, and counsel for the state hands over a report which indicates that the grounds of refusal was the nature of the crime committed by the petitioner, which was an organized act of crime and heinous in nature, committed in broad daylight, as a member of a criminal gang, which creates an apprehension in the mind of the authorities that the possibility of taking retaliation upon the witnesses and their family members is very high, as opined by the police, and future recurrence of the crime cannot be ruled out. That apart, objection from the victim's family members is also there. As such, the Kolkata Police Authority raised a strong objection against the release of the convict, which has been accepted by the board. Next para. I find from the records that the petitioner is in custody for 33 years now. 33 years now. Next para. It is evident that the relevant considerations in case of premature release, as settled by courts of law and guided by the NHRC guidelines, have not been adhered to at all by the SSRB. First, the SSRB relied merely on the apprehension of the police, which is more based on knee-jerk reaction of the law enforcement agencies than being based on practical reality. After being behind the bars as a convict for more than 3 decades, it is not understood by the court as to how the petitioner is the convict, or
petitioner number 1, my lord.
How the petitioner number 1 stroke convict will resume all the loose threads and commit a similar crime as the one for which he was convicted. Moreover, a person behind the bars for more than 3 decades, who seeks premature release would be doubly cautious than any ordinary citizen in recommitting the same crime again, which would put him behind the bar, probably for infinity. Next para. Moreover, the future recurrence of the crime has been based on the apprehension of the police that the petitioner might retaliate upon the witnesses and their family members. I do not find any objective basis whatsoever of the police opining that the crime may recur at the instance of the petitioner, since he has already been in incarceration for more than 32 years. Full stop. That apart, comma, the report of the superintendent of the concerned correctional home where the petitioner was in custody has not been adverted to by the SSRB, comma, nor has the SSRB looked into the report filed by the social welfare officer or equivalent, comma, regarding the conduct of the petitioner during his entire period of incarceration and parole, as well as the chances of uh, reinstating and reintegrating the petitioner in society. Full stop. Next para. The composition of the family and the chances of the petitioner reintegrating in society is utterly overlooked in the SSRB report. Full stop. Hence, comma, this said report is palpably vitiated. Full stop. Accordingly, WPA 2428 of 2024 is disposed of by directing the respondent authorities by setting aside the refusal of the petitioner's request for premature release, which is impugned herein, and directing the respondent authorities to ensure that the SSRB meets at the earliest again to reconsider the application of the petitioner for premature release on the appropriate yardsticks as indicated above, and the National Human Rights Commission's guidelines which govern the field. Full stop. It is expected that such exercise shall be concluded at the earliest, comma, preferably within 6 weeks from this date. Full stop. No rest to concerns.
My lord, copy of the order may be furnished to the petitioner and counsel, my lord. Because, my lord, we will.
Copy of the order means?
Order means whatever
Very
the
good.
decision.
Whatever decision is taken by the SSRB on such application shall be communicated in writing to the petitioner or through his counsel.
Get fullers.
Petitioner number 1 করে দিন।
Get fullers. Get fullers.
Before your lordship's.
Yes, Mr. De.
Item number 35. Malat, I mentioned the matter.
2 p.m. কিছু fixed আছে? Matters are fixed at 2 p.m. After that, if I get time, Mr. De.
Not at 3 p.m. also, Malat, because Malat, tomorrow is the date for Malat the Malat eviction of this my client.
What is your client? Your client is?
Malat, the licensee holder in respect of a shop room, in respect of the shop rooms
Railway.
in the railway premises, and Malat up to 31st March.
Can you give notice to the other side? I'll keep it at the top tomorrow.
Tomorrow is the date, Malat. They are already.
I can keep it at the top tomorrow. Today I don't have time because other matters.
If it is not taken up tomorrow, top Malat tomorrow, Malat.
Not if it is not. Yes, if it is
If
not
it
taken
is not
up today.
taken up tomorrow after
Yes,
the
I'm
2 p.m.
telling
matter,
you. Tomorrow at the top. Give a notice to the other side. What?
Yes, Malat. I have.
আজ না হলে আজ হলে তো দেবে না।
Item 36 fixed at 2 p.m.
36 is concerned, my lord, I appear for the respondents. Your lordship may remember this is a matter, the my lord, virus of the Patent Act has been challenged.
Yes.
Your lordship on the last occasion gave us liberty to file opposition and my lord to serve notice upon the additional solicitor general. Now, so far the opposition is concerned, we have drafted it, we have sent for it for vetting to the Mumbai at head office. I need my lord further 2 weeks time. And secondly, my lord, your lordship last occasion directed additional solicitor general, my lord, this should be my lord attorney general, subject to correction by you.
Oh. Yes, Mr. Sena, he is
My
right.
lord, my
I'll
lord,
grant this 2 weeks time. In the meantime, serve the Attorney General.
my lord, affidavit of service with regard to Solicitor General.
Very well. It was my mistake.
My lord,
Learned counsel for
It
the
was also our duty, my lord, to point.
No, but it is my mistake ultimately. Learned counsel for the respondent numbers 1 and 2 submits that the respondents require further 2 weeks time for having the affidavit in opposition approved and filing the same. Full stop. Moreover, comma, it is rightly pointed out by learned counsel for the respondents that the learned additional solicitor general is required to be served. Learned attorney general is required to be served instead of the solicitor general, since the virus of an act has been challenged. Full stop. Accordingly, the petitioner is directed to serve the attorney general of India, the learned attorney general of India, indicating that the matter shall be listed on April 9, 2024 under the same heading and file an affidavit of service on the next returnable date. Full stop. The time for filing affidavit in opposition is extended for a fortnight. Full stop. Reply shall be filed within a week thereafter.
my lord, supplementary affidavit may kindly be taken on record. I am serving my learned friend.
For what?
My lord, in the last order, my learned friend has pointed in paragraph 3 of the order that my address is of Patna. My lord, I
Very
have,
well.
I
The
have filed the
supplement
relevant
leave
form.
is granted to the petitioner to file a supplementary affidavit, a copy of which is handed over to the learned advocates appearing for the respondents. Full stop. The respondents shall incorporate their answer to the supplemented affidavit in a composite manner in the affidavit in opposition to be filed by them.
Grateful.
Grateful.
37.
Yes, Mr. Nag. You had to argue?
Yes, my learned friend had
ATF. Oof. Yes, finish it today. This is not ATF now, it is ATF. Yes. What is this?
This is a part of liquidation, sir.
Thank God. Yes.
Yes.
Hmm.
The first point, my lord, which was argued, my lord, was that
Mr. Nag, be precise.
Yes.
I'll invite written notes also in this matter because it is being heard for some time.
because these are only matters interpretation of certain clauses.
Right, right.
Nothing else. my
You give the page numbers and your interpretations in
lord.
your
I have prepared a short notes of
Oh,
argument
very
also referring all the clauses
rightly
and
so.
the page numbers.
Rightly so. Thank you. Yes.
Well, the first point which was argued, my lord, that there cannot be equality amongst the unequals. That was the point in which it was argued. Now, why that was argued?
Mr. Nag, take the microphone a bit closer to you. Yes.
The pre-qualification criteria for MS transporters and the pre-qualification criteria for the ATF transporters were different. This was the ground.
In their tender, there was a clause that ATF could be given to them, but there was no counter clause in the ATF.
That's a separate
tender.
point. But the
that's a
other point was that the pre-qualification criteria for both the tenders are different.
Right.
That's why there cannot be any equality amongst the unequal.
Right.
Now, if you let's kindly see the pre-qualification criteria, the pre-qualification criteria from the tender documents, it will appear that in both the cases it's exactly the same.
Should I look into the writ petition itself?
Yes, my lord. And kindly see page 20, my lord.
20.
Page 20 is the pre-qualification criteria for MSHSD transporters.
Them.
Motor spirit transporters.
All right.
clause 1.3.
Right.
Now, the pre-qualification criteria for the ATF transporters, the tender was at page 178. So remember page 180. 180. Now,
yes.
Yeah. If you just kindly compare the both these pre-qualification criteria for motor spirit, clause number 1, the
Mr.
first criteria.
Doc, tell me the differences.
There is
That
no
will be easier.
difference.
Absolutely no difference. Verbatim same.
Yes, my lord.
Oh.
The minimum number of trucks to be offered, all to own. Here also same 3 numbers, minimum 2. Then the age and model, same BS3 age model as per the RTO registration. It has to be BS3 April 2020, cutoff date April 2010. This is also April 2010. Then the valid RTO registration, legible copies of the valid RTO registration to be submitted. Now, the pre-qualification criteria for both the tenders.
Fonts are different. Fonts are different.
Yes.
Yes.
Fonts are different. Now, so it is not the situation that the pre-qualification criteria for both the tenders are completely different.
Right.
Now, it's by relying on a particular clause, the next limb of argument was that there is a provision in the motor spirit tender where the tank trucks can be converted to ATF. A similar provision is not there in ATF tender.
I know what you will say.
No.
I apprehend what you will say. Anyway, let us see whether you say that.
Kindly see, there is a reason for that. Otherwise, all the other clauses are exactly same. There is only one additional clause. Why? Because for ATF
need not convert.
Right.
But they need to convert because that is specialized. This is not.
Yes.
That will be a submission of this.
Because
I
there is no
anticipated this when they made the argument.
Yes, because there is no requirement. This can be used for ATF. The MS tank trucks cannot be used for ATFs. Otherwise, those certain sand blasting and all those things are done. But so far as ATF are concerned, they can be used. That's why that clause was not specifically there. But I was relying upon other clauses whereunder this is permissible in both the tenders. The tank trucks offered in both the tenders can be used for either of the tenders if there is an additional requirement.
Very well.
Now, sister kindly sees. Now, by relying, because I have relied clause 4E. Clause 4E that was there in that was the clause that was relied by me during the interim stage also, and it was appearing in losses the first order.
Yes.
Yes, which is that page? Uh, 37.
Yes.
Page 37, clause 4E. Now, saying this, I will show from the affidavit in opposition, in the affidavit in reply, because I have taken this, I have relied on these clauses in my affidavit in opposition. In reply, in the affidavit in reply, what the case that they were trying to make is that this is not applicable for them.
If I understood them correctly, the petitioner says that this has to apply within the confines of this tender.
Right.
The trucks which have been offered for this tender, among them, additional contractors tank trucks can be. That is there.
Right. Another extra argument which was made from the bar, which is not there in the writ petition, is that if I have to apply this, it has to be through a fresh tender.
Yes.
If I have to apply
Oh,
this,
yeah, all right.
that is not the case made out in the
Probably
reply.
if you have to make a call for a fresh tender, if you have to apply this to others, probably that was their argument.
Yes. No, 4E cannot be applied without a fresh tender.
Not for them. Was that your argument? For you also, it has to be fresh.
Anybody who was not covered under this.
Yes, I suppose that was their argument.
So,
So
are not given any contract.
if you give it intra this tender trucks, then that is not required. Their argument was if you have to give it to outsiders, obviously that has to be a fresh tender, because if the other argument is accepted within this tender, you cannot do it for that reason. So that would be a very high case for them. Among themselves also, it has to be done by a new tender. You only have to show me that this also applies not only within the confines of this tender, but to others also. Without
Now
any.
kindly sees what the clause exactly says. Engage additional contractors stock tank trucks at any time without giving any notice whatsoever to the contractors already appointed against this tender. That means the transporters who were awarded contract under this tender are out of this.
No, Mr. Nagi, there may be a situation where several people qualify for this tender. Among them, suppose 10 qualify. You have given trucks to 5. The other 5, I mean, are the ones which are outside those. I mean, you have to give notice to the.
No, that is not the case of the writ petitioner.
very
My
good.
writ petitioner's case is that he has been awarded with the contract.
Right.
His basic case in the writ petition, I will show that he wants a business. He wants like a maximum business. So his main case is that
has been allocated some tank trucks.
Yes, yes.
Some of his tank trucks have been allocated.
Yes.
Very good.
His case is that he
cannot give it to ATFs.
Yes.
That is the premise of this.
Yes. Because what their case is that, see, we are not getting adequate business.
Right.
We are not getting adequate business, but and without giving us adequate business, you are appointing third parties to for the same job. That is their basic case.
Beyond the case of the tender, that is beyond
Yes.
the terms of the tender.
Yes.
That is it.
Yes. Now, what I am saying, my lord, this clause E, 4E.
You say there is no qualification here.
Yes.
Additional tank trucks means additional contractors.
Tank trucks.
Either within this tender or outside the
Outside
tender, there is no
tenders,
qualification.
no
That is-
qualification. And also, my lord, so far as, because this is written that without giving a notice to the contractors who are engaged in this particular tender.
Now,
when
the
I-
language, Mr. Nag, your argument may be countered by them, because the language is without giving any notice whatsoever. If it was whatsoever without giving any notice to the contractors who are eligible under the tender or who have been found successful under the tender, then that might have applied. Here, to the contractors already appointed under this tender.
Right.
There may be-
They are same. They are appointed under the contract. Under this
No,
tender.
that we are on the logic of this. I mean, it cannot be applicable to ATFs. They say, suppose this tender contemplates certain eligibility criteria. 10 trucks have been selected under this tender. ATF is different tender. Among those 10, 5 are given the job by you, have been appointed. If you have to give work to the other 5 or some of them, then you have to give notice to these, the ones who have been appointed. You have to give notice to them to give it to people. They don't have any objection if you give to other tank trucks within this tender.
No, they have.
No. That is not their argument.
Their argument is they are not getting adequate business. That is
Probably there is some misunderstanding there.
I will show from the writ petition, my lord. They are saying they are not getting adequate business.
For that reason.
For that reason.
Because you are going outside the scope of the tender. That would reduce their chances of getting business. It would be suppose 5, the remaining 5 in my example. But if you give it to ATFs, then it becomes suppose maybe further 20 who qualify under the ATF. So it would expand the field, which would lessen their business. That is their argument. It entirely depends on the interpretation of this. You are right on that.
Because once a tender is closed,
yes.
Once a tender is closed and work orders are issued, then it's complete. Like there can't be the persons who did not get chance.
Achha, there is no such scope.
No.
Achha.
Once
So if you are successful, you have been appointed or given work order.
Yes.
Achha.
There is no persons in queue.
Oh, then this already appointed is synonymous with who have become eligible. So that argument does not, their argument is, so you say it is synonymous with whoever has been qualified under this tender.
Yes.
All right.
Now,
then this shows, then your argument may have some validity.
yes, because after work orders are issued,
All right.
this tender is closed.
Right.
There
So
is
there
no-
may not be any situation, Mr. Nag, that 10 have been chosen under this tender as successful, but they have not yet been allocated work.
No. These work orders are always given to the because these are not on the basis of the work orders. The contracts
among
are
the
not
eligible,
in
yes.
respect of the owners. These are in respect of the tank trucks.
Tank trucks.
So
all have to be given work.
Yes.
All the tank trucks.
Because the number of tank trucks is the requirement.
Yes,
These are
yes, not the
appointment
owner.
of tank trucks.
Right.
So if I have a requirement of 130 tank trucks and I get 130 tank trucks, there may be 2,000 people all similarly situated, all qualified, having 1,000 tank trucks. But I will give 130, and that preference will be given according to the age of the vehicles.
Yes.
The newer vehicles will get the chance.
Right. No, newer vehicles will get the chance for being selected for the tender.
Yes.
For the work.
Yes.
After that process is closed,
yes.
then all have been appointed. All the tank trucks have been appointed or allocated work.
Yes.
So then your argument becomes valid. There would not be any scope of giving notice to them if you had to select among themselves.
There is no such scope.
Very
There is
good.
no
Get your
such
point.
Now, my lord, kindly sees the other.
Yes, third.
So far as this adequate ground, the only ground that they are not getting adequate business.
Yes.
That is their main grievance in the repetition. Now, if you just kindly sees page 19.
Yes.
Yes. Now 19, my lord, the number of tank trucks are given. This is only an estimated numbers. The numbers are given, and now kindly sees the note below. IOCL does not commit any firm assurance for above volume of business. So no confirmation with regard to minimum business has been committed.
So they cannot come on that count that they have not been given
They
sufficient.
don't have a right to say that we are bound to give an adequate business to them. Now, if you kindly sees the other clauses. Now, this is these are the clauses. This 4E is from the tender terms. Now, kindly sees the agreement also. Agreement for both, like for ATF transporters and the agreement for the MS.
Agreement is a subsequent stage for the work order.
Yes.
That is annexed where?
Is in my affidavit in opposition. Of course. And I will first show my clause 2G, page 17 of my affidavit.
Yes.
Now, this is for this is the agreement with the MS transporters, the petitioners. It's part of that agreement. Clause 2G. IOCL shall have the right to assign the tank trucks under contract in any location to any contract in other state, region, location on any route temporarily or permanently, and the decision of IOCL shall be final and binding on the carrier's contractors. In such case, if the TT is assigned to any other contract in any other location, the applicable transportation rate will be existing rate applicable to the carrier at his base location or the L1 rate of the new location, which was his earliest.
Why is this relevant?
Why this is relevant? Even for the petitioner also, I can engage the petitioner to cater transportation job in another contract also.
Yes.
So this based on the similar condition is with the ATF transporters also. The ATF transporters can be assigned to cater job of transportation in respect of other contracts also.
No, show that clause from the ATF.
Yes, my lord.
No, from the ATF tender, you also have to show that.
Yes, that will show. This is the agreement.
But this is on a different. This is the opposite of what they are arguing.
Yes.
They are arguing that others cannot be brought in. This says they can be deputed elsewhere.
Others
That is neither here nor there. They are not arguing on
ATF
this.
on similar provision is there for ATF also. Like
Oh, Acha, you say it very well. That is the complementary clause of this. I mean, it can be catered to them, and they say they can be catered.
Yes, yes.
You mean to say that very well. But this is regarding location. This does not have anything to do with that business.
And it is not about only location for any other contract also, my lord. Any
other contract. All right. Very well. It seems to hinge around location. I mean, right to assign TTs under contract in any location to any contract. All right. Very well.
Now, the similar condition is there for ATF also. Kindly see page 29.
Where? Which
G.
clause?
G. Bottom, G. IOCL shall have the right to assign the TTs after.
Page 29.
Yes, my lord, page 29.
Of the opposition?
Of the opposition, my lord.
No. No, this is page 34 in my copy. Gross discrepancy. Anyway, I have got it. I hope this is the ATF thing.
Yes, yes, ma'am.
Let me see whether Messrs. Orient Logistics is ATF.
Yes, yes. What are the
that agreement
at the top of each and every page of ATF, at the top it will be written road transportation of bulk petroleum product ATF top loading. At the top, ATF top loading.
No, this is not ATF then. This is not ATF then.
কি করে?
Oh yes, page 31 is ATF. I'm sorry. But no, this stops here suddenly. Page 31 in my copy is Annexure B of your opposition.
Yes, Annexure
which at the top says road transportation of bulk petroleum product. There is 1, there is 2, A and B. And then it starts afresh, which is a different agreement.
Yes.
So there is some discrepancy here. Can you tell from the picture of the person? It's annexed at page 33. If that helps you. There is no other distinguishing feature apart from the picture of the agreement holder.
But the clause G is page 76 of the internal page 76 of the tender, my lord.
That is not the important question. The important question is where I find it.
Kindly give me.
Is it there in the writ petition in any way? They won't be annexing that. Or they may be annexing that also. Have you annexed any ATF?
You will not have access to that.
You
My
cannot.
lord, it is there. It is there. It is there.
Where?
Because agreement format are part of the tender documents.
Right.
Yes.
So
So
what
it's
do I
there
find?
at page 250, my lord.
Writ petition?
Yes.
250?
Yes, 250.
All right. Yes.
G, my lord.
G. G both in Hindi and English. Found it. Yes.
IOCL shall have the right to assign the TTs under contract in any location to any contract in other state, office, region, location on any route temporarily or permanently, and the decision of IOCL shall be final and binding on the carrier contractor In such case, if the TT is assigned to any other contract in other location, the applicable transportation rate will be existing rate applicable to the carrier at his base location or the L1 rate of the new location, whichever is earlier. Exactly the same thing in the MS agreement also.
Ajay, this is the continuation of the ATF tender.
Yes, yes, yes.
So where is that clause corresponding with your
Page
page 9?
with Manan, that I'm
No, not page 9. ATF can be used for
Yes.
corresponding to clause 4.
Manan,
probably.
I have to show it from the MS transportation tender, the same clause.
Yes. For ATF. Page 37.
Yes.
That is clause 4 something.
Yes, clause 4.
Clause 4E. That is for them, these persons.
Yes, yes.
You have to show the similar clause in ATF.
Yes.
Because you argued on that.
Yes. My lord, page 193.
Hmm.
4E. Here also 4E.
Right.
The same term which is there in the MS tender.
Yes, yes. Wait.
Now, my lord, the next clause 2I of the agreement
And this is on which issue?
in case of exigencies. On the same thing, the engagement, my lord, which was relied by my learned friends, showing that there is a requirement for conversion.
The conversion you there is no,
Page,
you said there cannot be any conversion clause in ATF because they don't.
Not required. That's why.
So that's all.
Page 84 once, because there also the exigency clause is there, but only that conversion thing is not mentioned. That is not required. That's why it's not mentioned. Page 84I, my lord. I. In case of exigency, wherever required, company may ask the existing carriers to offer their MS HSD TTs which are already under this contract through gate notice to ATF transportation after sandblasting, EPI coating, upgrading as per QC norms at the same rates, terms, conditions finalized through this tender. Now, kindly see the similar clause in ATF, my lord.
Which page?
Page, my lord, 251.
And clause number?
Clause number I.
Same.
No, here there is a little difference because conversion is not required.
No, I understand. But same means corresponding clauses?
Yes.
Number is same. Clause 2I in the other. Here also.
The ICL shall have the right to use the TTs under this contract for transportation of any white oil, petroleum products and biofuels and or blended fuels at the same rate, terms and conditions.
Where is the conversion?
No, conversion is not required.
Oh, this is the ATF.
This is ATF.
No, there also conversion was not required.
Yes, there it says the conversion is required. I at page 84.
Yes. Exigency.
After sand blasting,
Oh,
API
yes, yes.
coating, upgrading.
That upgrading, yes.
Yes.
Oh, acha, these things. Very sorry. Understand, yes.
Now, IOCL shall have the right to use the TTs under this contract. My learned friend was saying that under the ATF contract, there is no provision given in the ATF contract for using their tank trucks for any other contract. So what I'm saying, my lord, under this clause, we can use the ATF tank trucks for any other contracts.
Very.
Now, blend, because here they may say that ATF is not mentioned. MSHSD has not been mentioned. Unlike there ATF has been mentioned.
No, you say basically ATF is a subset of general tank trucks.
Yes, ATF is also
Specialized.
a blended fuel. Motor Spirit, high speed diesel, as well as ATF.
Yes.
All are blended fuels. Here you will also may see that it can be used for blended fuel contracts also.
Yes.
Now, another point which was also I was a similar clause is also there in the ATF in the MS tender also.
Give the clauses in a written notes of arguments.
Yes, I have given that. Now,
Just
now
make it
kindly
concise,
see the next clause is 2K. 2K of the Motor Spirit agreement. Page, my lord. Page 71. '71 too. 71 is not there.
What does
page
it say?
85, my lord. Page 85 of the writ petition.
Yes.
Page 85, top. K.
Right.
Company shall be free to engage one or more additional carriers either to run concurrently or separately for transportation of jobs from the same loading location.
That is there at page 251 also.
And the same clause is there in ATF contract.
251, page
Yes.
251. The very next clause.
Yes.
There J, here K.
Yes, ma'am. Now, page 193 declaration. And not only in 4D, 4E, 4D also there is a right of assignment. In 4E.
Yes.
Assign the offered or accepted tank trucks to any other contract. So
Understood.
similar
Yes.
condition is there in the ATF. So I have a right to assign the ATF tank trucks for any other contracts, including a contract for blending fuels, which is MS and HS contract. These are the clauses on which I want to realize.
So file your written notes on the next date. Yes.
To show that I have a right under both the contracts to use the ATF tractors. Only, my lord, two judgments I will be.
Please
Only
cite.
two.
Yes, yes, absolutely.
$2016. One at 2016 16 SCC 818. What was 16? 16 SCC 818. 2016 16.
Yes. 16.
Oh, well, 818. And paragraph 14, my lord.
Right.
we must reiterate, because here the question is, they are saying, they are giving a different interpretation of the terms.
Your interpretation has to be final. Yes.
Even if it does not sound good.
To the
even if-
court. Yes, court cannot substitute its own interpretation for you. But it has to be, I mean, rational.
Yes.
Witness-bearing principle has to be there.
That is-
Anyway, this is not of such a high nature, you are arguing.
Yes.
Where will this one?
My lord, para 14, 15 and 16, my lord.
Employer or owner having authored the tender document, best person to understand and appreciate the requirements. Very good. Yes. Oh, AFCON. Sorry.
Yes.
I did not look into the. Yes. Need not place the paragraphs. You can cite other judgments.
But these are also on the interpretation, my lord. The requirement under the This is all SILP constructions, my lord.
SILP, yes, follows this line.
Follows the same thing. And these are the only two judgments.
No, since you have brought it, SILP also cite.
Yes.
You have taken pains in photocopying, but don't cite any others. Give me the paragraphs of SILP, Mr. Nag, if you have that with you.
Yes. 19 and 20, my lord.
Thank you.
And on the same thing, NG constructions, my lord. On same.
At the very site.
But NG projects.
Para.
On the NG projects is para 23, my lord.
Very well. Yes, what is your reply? Short, very short reply to their argument.
Not more than 5 minutes, Mr.
Yes.
Let's firstly, my argument that when a specific clause of the agreement covers a particular factual situation, to averse from that contractual obligation to invoke a residuary clause to do something else is not permissible. There is no reply on behalf of the IOCL on that behalf, because I had referred to specific clauses in the contract wherein a factual situation like at hand was addressed, as in a situation where the depot was closed and a recitement occurred. What are the rights that are reserved for IOCL, which included termination or transfer of the present contractors to that location? This what has happened in the present contract. IOCL has done both. Some of the contractors have been transferred to Barauni. Person who did not choose to go to Barauni were assigned to into my tender. Look, this situation was impermissible if the contract is read as a whole. The contract has to be read as a whole.
There is no bar in the contract to do that. It's their choice.
But there has to be a standardization.
If there is a provision clause in the tender document, it's their choice.
My submission.
Court cannot look into that.
My submission before your lordship is, if there is a specific clause covering a particular happening of an event, then that has to be followed. They cannot resort to a residuary provision saying that I can do this, I can do something else as well.
Why do you say this is a residuary provision?
Because
it is equally a part of the contract, tender.
But the factual situation handed, we are applying the contract to the factual situation. The case brought out by the
IOCL document, tender clauses cannot be read in the light of subsequent factual scenario.
But these are clauses
that will be too much.
These are clauses which are there, taking into consideration the hypothetical situations that can arrive in the future.
We cannot read into that. If the tender clause says it can be done, it can be done.
My only submission is that there is a specific clause to that effect in the contract document as to what are the rights of the parties therein.
Yes.
And they have exerted that right by transferring some of them. Just because some were not ready to go there, they have assigned into my tender.
It is entirely on the interpretation of the clause. If they have a right, they can pick and choose. Some can be assigned, some may not be assigned. That is their choice.
My respectful submission is,
you cannot interdict that, or neither can I.
No, certainly not. But what I am saying is that there has to be a standard procedure which has to be followed in terms of interpretation of a clause. If something
subsequent implementation cannot be a determinant of the interpretation of the clause.
No, I'm not saying that. I am saying that something has happened post contract was entered upon. Only one thing can emanate from that. Either I will get damages or the defendant will get damages as per the contract.
For interpreting the contract tender clauses,
Yes,
we
Mr.
cannot look into subsequent events or how things turned out. It has to be interpreted in the light of the date of the tender.
Absolutely. And
It's their choice if they have a choice. If they don't have a choice, they don't.
Their justification in their affidavit in opposition is because the depot was shifted from Howrah to Barauni, there were approximately 10 tank trucks who were selected for ATF transportation. Some of them chose to be shifted to Barauni. And hence we exercised those parts of the contract which included recitement. And because these people were not ready to be shifted to Barauni, we assigned them to the transportation of motor fuel.
If they have a right in the under the tender, they can.
Because my submission is that the specific clause which covers this particular happening of event does not contemplate assignment into my tender. That is my specific submission before you.
It boils down to that. Barauni, Morigram.
I had referred to those clauses probably if
it's in on the interpretation of the clauses.
Yes,
if they have a right, they can.
Those clauses do not cover this right of assignment to other locations.
That is what we have to look into. Only that.
Yes, my lord. Those particular clauses which include or cover the happening of the factual situation like and had. Second submission, my lord, they said that ATF need not be converted into normal truck. Lord, my submission is I had made that submission because in Can 1, the proposed added respondents had made a categorical submission before your lordship that they had to convert. That is at page 9, paragraph 16 of their application. That is the reason I made that submission before your lordship. Lord, kindly have that because that is on affidavit also.
Can is disposed of.
Disposed of. But nevertheless, they had stated that they had to convert. And they had converted their trucks.
The notion of the party who has not been added cannot be looked into at the final hearing of the.
But these are.
I have not added them. The chapter is over.
Neither has IOCL in their affidavit stated that they had to convert or need not convert.
Or have you stated that there is no requirement of converting?
But
so we cannot look into an application which has already been disposed of by not adding the party. If they were added, I might have looked into
very well, that was the reason I had made that submission. My third reply would be, allocation of work. What has happened in totality? I know what is the work that is going to be generated from this particular depot. I know in the NIT that how many tank trucks that they're going to appoint. Based on that calculation and as per their reliance also, they did not give a firm assurance. But in the same breath, the clause before that is there is an assurance in the NIT itself. If your lordship want, I can refer to that part of
the numbers are given.
The numbers are given that this is a basic assurance, but there is no firm assurance. I am a businessman. This tank trucks do not have any other commercial utilization. I cannot utilize it for any other purpose. It is only for IOCL. I went into the tender with the assurance that for this particular location, I know what is the requirement, and they are going to appoint, let's say, 100 tank trucks. And I am going to get 100 divided by 10. That is 10 amount of work in a month. Now they bring in somebody from outside who did not participate in the tender. So if this is allowed to be done, my lord, this can lead to frustration of the object of the contract. And my lord, so far as the other clauses relied by him, which refers to transfer of location or assignment.
Yes.
My lord, my humble submission is these are happenings of event which relate to shifting of location. Lord, let us. I'm just a hypothetical example.
Additional contract is also there. For a separate contract or agreement, it can be.
But Millard,
I pointed out the location part, but Mr. Nag rightly pointed out that there is a clause of contract also.
But Millard, there is something which
or other agreement
which will hinder them. The problem is if they say even after floating a tender and going through the tender process and signing off a contract, I can bring in somebody who is alien to the tender process without a tender process, then there is no reason for having a tender process.
Understand? Well, that will frustrate the purpose of
yes. And lastly, my last submission would be if their submission is you have given us a truck, I can assign it for any other reason, any other contract, for any other purpose, because these are two separate distinct purposes. Motor oil, ATF. Then they can as well say that my tank truck tomorrow will be utilized for transportation of cement in a separate contract. Look, this will lead to absurdity, and a contract cannot be read in a manner which will lead to absurdity. Those are my respects.
So when can you file your written notes?
We have already filed on the last.
You have filed?
Yes.
Hey, Barkura. Yes. Sitting tight over the matter.
And Millard, I just forgot one point, Millard. The preconditions of the tender.
Yes.
I was told that they have argued today that there are no difference, but I had shown a categorical difference that I had to at least give in 9 tank trucks. 8
the number of tank trucks.
Yes, 8 of one particular
category.
category and one of another category wherein they could apply in just one category.
Yes. Please forgive.
And their minimum number was 3, wherein mine was 9.
Arguments of the parties are concluded. Both sides, the written notes of arguments filed by the petitioner be kept on record. Push up. Since the written notes of the written notes filed by the respondent numbers 1 to 3 today be kept on record. Since the written notes of the petitioner is already on record, hearing is concluded and the matter is reserved for judgment. Yes. পরের ঠিক সেটা কো ঠিক দুটো হয়ে গেল আরেকটা ফিক্স করতে তখন
21.
Yes, Mr. Hal.
Hello, time for the CSC.
Lordship, new connection, Lordship, domestic purpose, petitioner is the occupier. Applied for inspection made, Lordship, no connection has been
Private
given.
respondent?
No.
Yes, Mr. Ghosh, what is it?
This petition suffers from a gross suppression of facts. This particular petitioner, my lord, has approached us thrice. One on 12/7/2021, one on 29/9/2021, and lastly on 22/2/2024. My lord, this house pertains to a tally shed hutment where my lord, the petitioner is staying with his brother, having 2 adjacent rooms and 1 common privy. And my lord, time and again, my lord, it's on record. We have informed him that it's a case of splitting of loads, my lord, and we are unable to proceed. And lastly, my lord, we have communicated that this is a duplicate application. Your lordship, may I please? Communications. Your lordship kindly comes to page 4 of my report. I'm sorry, they are marked.
No
Page
copy
4.
has been handed over, Lordship.
No, that's our instruction. Page 4. Page 4. This is the first rejection.
I'll record that they are taking a point of
Page
splitting
9,
of load.
page 9 is the second
Did
rejection.
not go into all that, Mr. Ghosh. You are taking a point of splitting of load. I'll say that. Eta fero dido. Learned counsel for the petitioner submits that despite having applied for electricity, the petitioner has not been supplied the same by the CSC Limited. First of learned counsel for the CSC Limited submits that the petitioner has suppressed that on previous occasions as well, the petitioner was not given connection on similar applications. First of it is submitted that the premises where the electricity connection is sought comprises of 2 rooms and a hut, 2 rooms in a hut and a common privy. Since the brother of the petitioner is already enjoying an electricity connection, the CS Limited apprehends splitting of load if another connection is given.
Both of them are enjoying a connection.
Acha. It is further pointed out that the petitioner is also enjoying electricity connection at the same premises.
My instruction is that, Lordship.
Learned counsel for the petitioner controverts the said allegations. Be that as it may, since an apprehension of splitting of load has been raised, the matter pertains to the domain of the concerned grievance redressal officer. Accordingly, WPA 2891 of 2024 is disposed of by granting liberty to the petitioner to raise the issues in the presented petition before the concerned grievance redressal officer. If so approach, the said grievance redressal officer shall decide the issues upon giving opportunity to all concerned parties in accordance with law at the earliest, positively within 6 weeks from the date of communication, within 4 weeks from the date of communication of this order to the GRO. No rest to cause. Next. Your matter is 34, 35.
35.
No chance.
22.
Yes.
For the state.
Your other side is here, Mr. De. Try to get your other side before 3.
Because what happens, I tried to serve after getting leave, I tried to serve upon the.
You serve a notice and come back tomorrow at the top.
They are not receiving the Union of India or the additional.
Why not receiving?
So I am sending all the things.
Whatever.
Mail.
Yes. Yes, what is your case?
I am for the petitioner.
I am appearing for the respondent number
Some
10.
business, make your arguments.
The petitioner is aggrieved by a blockage. The entrance of his plot of land by the private respondent. What the private
Unauthorized construction on government property.
Yes,
you are for Private respondent,
Private respondent 10.
you deny.
Hmm.
I'll direct a BLRO report to be taken and the usual order.
Only one consideration, my lord. The
Yes.
petitioner is the son of the recorded owner of the property. Recorded owner is Rekharani Vishwas. He made a representation and petition.
No locus standi then.
That is.
Well, there's a 144 order was the landed SDGM.
Yes.
And on that basis, my lord, direction was given to maintain tranquility and peace.
That
and
is
that has
different.
been maintaining till now.
No, Mr. Vishwas, you don't have any
My
locus
lord,
standi.
so for
Your
the
mother-
unauthorized construction is concerned, my lord, anyone can come before lordship, my lord, against the unauthorized construction. But so far this petitioner is concerned, if your lordship kindly turns up, my lord, I have made a amendment to that effect in paragraph 7 that I am the person who is looking after me. I am in the possession, my lord. My mother is the owner. My mother approaches before the landed court below with an application under section 144, but since
Very
it's long away from my lord
The
there,
petitioner alleges that the petitioner's mother gave a representation, but to no avail, comma, in respect of the private respondents having allegedly encroached in an unauthorized manner government property adjacent to the petitioner's property. Who sub next para, learned counsel appearing for the private respondent objects as to the locus standi of the petitioner to prefer the present writ petition, since the representation annexed to the writ petition was made by the petitioner's mother and the petitioner was in no way involved in bringing the matter to the notice of the authorities. Who sub next para, learned counsel for the state submits that there has been an order passed under section 144 of the Code of Criminal Procedure with regard to the property in question. Who sub next para, learned counsel for the petitioner in reply submits that that anybody having interest can come before the court with an allegation as made in the writ petition. Full stop. That apart, comma, in paragraph number 7 of the writ petition, it has been averred that you have checked up para 7.
yes, my lord, I am looking after the
Paragraph number 7 of the writ petition, it has been averred that the petitioner is looking after his mother. Full stop. Next para, the petitioner is justified in contending, comma, insofar as locus standi is concerned, comma, that anybody can bring a perceived irregularity to the notice of the court under Article 226 of the Constitution of India. Full stop. That apart, comma, since the petitioner's mother has preferred the representation and the petitioner represents her estate as well, comma, there is no issue as regards the petitioner preferring the present writ petition. Full stop. Even independently, comma, the petitioner could have made the allegations as made in the writ petition. Full stop. Next para, since no affidavits are invited, it is deemed that none of the allegations made in the writ petition are admitted by the respondents. Full stop. However, comma, since an allegation of unauthorized construction on government property has been made, comma, WPA 3031 of 2024 is disposed of by directing the respondent number 2, that is the district magistrate Murshidabad, to call for a report from the block development officer Nauda. Which one? Yes, block development officer Nauda.
block.
That is respondent number 7. With regard to whether the private respondent numbers 10 to 12 are in unauthorized occupation of any public property, public stroke government property, if so, comma, the respondent number 2 shall immediately initiate proceedings under the appropriate act for removal of such unauthorized occupants. It is made clear that the merits of the allegations and counter allegations between the parties have not been gone into, and it will be open to the appropriate authorities to take appropriate decision in accordance with law without being influenced in any manner by any of the observations made herein.
Well, averment is in
paragraph 5.
7 টা 5 করে দেবেন, paragraph 7 টা 5 করে দেবেন।
Report filed by the respondent number 9 that the office may be kept with that.
Yes, report filed by respondent number 9 today be kept on record.
I'm
No
grateful
rest
to
cause urgent certificate.
Good.
Next.
23.
Yes, Ms. Alda.
Lordship, this is the application for submersible pump, Lordship. Petitioner applied, quotation was made. Petitioner deposited the quotation in the year 2013.
Cultivation, Mr. Rai.
Yes, submersible.
Till now,
Cultivation going on. I mean, why not given?
No.
2013, Lordship. Till now,
Then it has
nothing.
lapsed. Your application has lapsed.
No, quotation has been deposited.
No.
They have taken the quotation money.
Yes, Mr. Rai, why not?
I have annexed the receipt.
On 6th February, it has inspection was made and it has found meter room is not completed
Everything
and not
is
yet
complete.
bored at all.
Everything is completed.
If that be so, yes, tomorrow or day after tomorrow inspection will be followed, and if it is completed, then he will give.
Learned counsel for the
Lordship,
petitioner
another thing-
argues that the petitioner sought electricity connection long back in the year 2013 for operating his submersible pump, which has not yet been given. Push-up, learned counsel for the WBACDCL submits that there is no meter room constructed and other formalities have not been complied with by the petitioner. Push-up, such contention is controverted by learned counsel for the petitioner. Push-up, to ascertain the current picture of the location, comma, the WBACDCL shall hold an inspection on March 7, 2024 at 2 p.m. To ascertain whether the petitioner has by now complied with the required formalities. Push up, in view of the date and time being fixed, comma, no prior notice of such inspection need be given. Push up, the WBACDCL shall file a report in that regard on the next returnable date with an advance copy on the petitioner's advocate. Push up, the matter shall next be listed under the same heading on March 11, 2024.
Lordship, another thing I was submitting, Lordship, till 2013, they have not made any communication to us. After filing of this writ petition, they have made inspection, and thereafter this report came.
You have also not come to court before 2024. You applied in 2013 and waited for 11 years. The writ petition should be rejected on that ground. Delay. 11 years delay, Mr. Halda. What are you saying?
24.
Yes.
I am for the
Petitioner.
petitioner.
Service.
Lordship, I have served, but affidavit of service is not affirmed, Lordship. Lordship, not,
Regular heading.
Lordship, not today, kindly makes it. I will come with the affidavit of service.
On the prayer of the petitioner, the matter is adjourned for the day. Next. Thakbe.
25.
25, Your Lordship, appear for the petitioner.
Yes.
May I file the affidavit of service?
Yes. What is the grievance?
Lordship, the grievance, this is at Annexure P11
Yes.
at page 99.
Electricity.
Electricity, Your Lordship.
What happened?
Lordship,
Disconnected or not given or what?
Lordship,
Which
it has been
category?
disconnected. Earlier, I have preferred a writ petition. Lordship, Your Lordship had considered the grievances, and Lordship had thereafter, Lordship, I was sent back to the grievance cell. The issue was to be decided. Lordship, fortunately or unfortunately, they are deciding on such a issue that I am now being asked to pay the dues of some other person. And the link was only under assumption. My due,
Initially, you were given connection.
initially, I was operating 2022. I was operating. There was a failure to pay the bills for 3 months. I've approached. The dues have accrued to an amount of rupees 5 lakhs and odd. I have made a representation to consider the same. They could not consider. And on 10th November 2023, my connection was disconnected. Lordship, I'm running a hatchery.
It was your own dues.
That was my own dues.
Yes.
Thereafter, to restore the same, I had
Paid
come.
the money.
Lordship, I could not. I had come up before this honorable court, Your Lordship, and Your Lordship, pursuant
With
to
a billing dispute.
with a billing dispute, Your
I delegated you to the GRO.
Lordship,
You
pursuant
went
to
there.
Lordship's
What happened?
order at page 72.
Page 99. Oh.
99. What is 99?
Lordship, page
PRO
ni-
order. Oh, order.
I'm placing Your Lordship's order, page
No,
72.
no, no. So I sent you to the GRO. I know my order. What order?
Lordship, thereafter, Your Lordship,
99. Page 99.
page 99 is
Yes.
the order which has culminated
Yes.
after Lordship may, before considering page 99,
Huh.
may Lordship may very kindly takes page 91.
Yes.
Page 91.
Draft order,
Lordship,
yes.
this is what was considered, Your Lordship, and upon
This has culminated in a final order.
Final order. Page
final order,
99.
page
Let us come to the final order.
99 is the final order.
Right.
Lordship, I have to place the entire order. Lordship, this is the only consideration.
What is your point? What is your ground?
Lordship, today I am being asked to pay the dues of some other consumer.
Show me that relevant portion first, then we'll read the entire if necessary.
Lordship then may only take the submission of the representative of the licensee. Lordship may kindly takes that, which is at page 99, starts from the bottom. Srimati Shunita Shaha, which is the petitioner, is a commercial consumer being such and such under Barwipur Consumer Care Center. During routine inspection, Lordship, it follows from here, page 99 at the bottom. During routine inspection,
Ms. Ghosh, very well, we'll carry on tomorrow. with this matter? Because CPM, I have to take up the order.
One thing subject to lordship kind approval.
Yes.
This is the GRO order. And from that GRO,
Ombudsman
the
appeal lies.
ombudsman appeal lies,
Go
lordship.
before the ombudsman.
They can raise this point
Best
before
I
the
send you to
ombudsman.
the GRO, now I will send you to
Not
the
the
ombudsman.
ombudsman.
Lordship, it is
I'll
the
give you that liberty.
Lordship may kindly hears me tomorrow, your Lordship.
226 we
But
don't have.
liberty, because there is
Lordship, in the event, it is
It's appealable before the ombudsman.
Lordship, it is not appealable. Lordship,
Against ombudsman, you can come up before this court. So you use the forum in the process.
Lordship,
I'll do that. Go to the
Lordship may kindly hears me then, or I shall come back tomorrow.
No, not because of time. Otherwise, also you have to go with the ombudsman.
Lordship, if there is palpable illegality, your Lordship, I may challenge before 226.
But then we will file the affidavit on this issue.
I'll hear you if on the face of it it's palpable, then definitely I'll
But
interfere.
there is no palpability.
There is no scope of any Mohinder Singh Gill prevents you. You cannot justify an order by subsequent affidavit.
Yes, I
Only on these grounds, if you can succeed, you will succeed.
Certainly.
Or if I find that yes, factual inquiry is necessary, then I'll relegate to the
Lordship.
Well, come.
Grateful, my lord.
But tomorrow.
It is just not to record.
Tomorrow my matter.
Yes. But today no order will be passed right now.
Due to paucity of time, the matter cannot be concluded today. Full stop. Accordingly, let the same be adjourned till tomorrow.
Deeply obliged.
Grateful, my
Original side, any mentioning?
Lordship, item number 19, Lordship. They are enjoying the stay, my Lordship. That is ending on 8th March. Kindly hear us.
You are enjoying the stay?
No. They are enjoying the stay. And the stay is still 8th March. Kindly hear us on tomorrow. Kindly.
Why?
Let it appear for extension of notary.
I cannot decide the matter in extension.
No, my lord, they are enjoying the stay, my lord. Kindly hear
They
us.
will enjoy till 8th.
Huh?
You are mentioning for extension. Under the extension.
Since they are
for extension. Very well. It will appear under the extension.
both the matters moved together.
18 and 19.
Which?
18 and 19.
My lord, kindly.
18, 19.
18 is a separate matter, but my lord, in
That also, regarding that also.
regarding the same thing.
No, it expires on 8th.
No, 19th item number 19 expires on 8th.
So why 18 should be placed?
My lord, because 18 and 19 should be taken up together. My lord,
They are
together.
appearing together. 18, 19 together.
Kindly top of the list, my lord. Kindly.
For extension. What are you saying? Next matter. What is the next mention?
Lordship, may I have the liberty to mention a matter which is item number 55 on today's list for non-prosecution.
Most welcome.
My lord,
Please
I
hand
have
over the
responded. If you could withdraw, I have nothing to say.
Mr. Bose, I'll ask you to justify your presence. No, please don't come. Please come. Please don't take that seriously. So it will appear as to be mentioned tomorrow.
Such a contested matter that the client
There's a sense of, disappointment at the end. So can I pass my order right now? I'll take it out of terms since both sides are there. 55 ta, একটা order record. 55 ta board দেখিয়ে দিন. The matter is taken out of turn in view of the submission of learned counsel for the petitioner that the petitioners do not want to proceed further with the matter. Full stop. Accordingly, WPO 1800 of 2023 is dismissed for non-prosecution without any order as to cost. Interim order, if any, stands accordingly vacated. Are the certificate. Thank you. Thank you.
Next. Listed matter. Item number 1 to be mentioned. Ashish Chunjunwala.
Sum up 9 similar for correction.
Yes, Mr. Bordhan, what is the correction?
Page number, there are 2 areas. Page number 2.
Yes.
The third paragraph.
Yes.
Insofar as the first show cause notice concerned, same was not proceeded with apparently because such and such, then it is argued that the initiation of show cause notice, this should be the second show cause notice.
This and
first show cause, second show cause. There should be a second show cause notice.
What else?
And then page number 3, insofar as the second show cause notice was concerned, which was issued by the respondent on the basis of a recorded forensic audit report taken out at the instance of PNB, it should be CBI FIR lodged by the Punjab National Bank.
Not forensic audit report.
No, my lord. CBI FIR lodged by the Punjab National Bank. That is borne by page 279 of my
These
application.
two.
Only, my lord, these two.
Learned counsel for the petitioner rightly points out that two errors crept into the order dated February 28, 2024. Push up in the third paragraph of the second page, comma, in the penultimate line, comma, the expression show cause notice, double inverted, will be preceded by the word within double inverted second. Full stop. In the second paragraph of the third page of the same order, comma, the expression within double inverted forensic audit report taken out at the instance of the Punjab National Bank, double inverted close, shall be read as
CBI FIR lodged by the Punjab National Bank.
No, very well. FIR cannot be lodged by the Punjab National. At the instance of the, it will also be at the instance of the.
Well, can be.
CBI FIR, double inverted মধ্যে যেটা continue করছি, CBI FIR at the instance of the, না, CBI FIR on the complaint of the Punjab National Bank, double inverted close. Full stop.
The language is CBI FIR lodged by the PNB. That's the language of the notice.
ঠিক আছে, তাহলে CBI বলে যেটা বললাম, lodged by the Punjab National Bank. Double inverted close. Let the said two corrections be deemed to stand incorporated in the order dated February 28, 2024.
We never know what these connotations will take.
No, right. You're right.
I'm so grateful.
That they'll be building the argument and ours will.
I'm so grateful.
Court application, item number 1, Octane Electronics LLP. Item number 2, sorry.
Milord, I appear on behalf of the petitioner, Milord.
Yes.
I appear by Mr. Dasgupta, Milord, who is probably appearing, Milord, via.
Milord, I am seeking leave to appear through the virtual mode, my lord.
Yes, yes.
Milord, I appear on behalf of the CS.
Milord, Lordship will recollect this is that passing the buck matter where LIC building got fire and CSC snapped electricity by intervention of this honorable court. Milord, on 20, that matter, Milord, fire safety certificate. The LIC never had that. So now, my lord, things have been regularized, and on 28th of February, in the evening, connection has been eventually restored. So, my lord, the grievance against CSC is taken care of. Only one small thing, my lord, Lordship will recollect, Lordship had injuncted CSC from issuing any bills because since September I am without electricity. They had issued a bill of January when there was no electricity. After restoration, they can again raised a bill of February 2024, including January 2024 bill when they were specifically injuncted from doing so. That bill is there.
I'll hold that. Otherwise, the writ petition has become infructuous in view of the remedy having being obtained by you. But I'll restrain the CSC Limited subject to hearing them from raising bills for the period during which the connection was disconnected.
My lord, my lord. And only one more submission, my lord. One more submission because that I could not have agitated at the ad interim stage. That is, my lord, if your lordship will kindly see the lease deed, there is a clause. Our interpretation is, my lord, that till such time as I am unable to use the rented out premises for no fault on my part, I am not liable to pay the lease rent. That clause, lordship will find at page, my lord.
That Mr. Dasgupta is beyond the scope of the writ court. I'll leave it open for you to agitate before appropriate forum.
I'm grateful. I'm grateful.
What about electricity? That period?
Milord, that period, Milord, we have my instruction is we have already raised the bill, Milord, because we have not received any payment.
No, recalculate for the period during which they did not have electricity. You cannot charge for that period.
That we will not charge, Milord.
I'll restrain you from doing that. But you raise current bills.
Including the
January.
Including, Milord, in the month.
Check up this.
Milord, kindly have a look into these letters.
You have a look into their bills, actual bills. Letters, what will I do with the letters?
Milord, I will be liable for a part of September before 15th September and from February onwards. So my March onwards. So my first bill will come in April.
If at all we're paying, but apart from the mutual rent and the payment.
My instruction, we will adjust this bill, my lord, and apart from the meter rent and the fixed charge, which we generally deduct, we will adjust the bills.
You
They
cannot.
were injuncted from raising.
You cannot charge any electricity charges for the period during which there was no connection. This I'll clarify. Whatever else you do, you do.
My lord.
Learned counsel for the petitioner submits that in the meantime, electricity connection has been restored to the petitioner's residence to the petitioner's
My
property.
lord, it's a rented out office premises.
To the petitioner's property, full stop. Accordingly, the primary relief sought in the writ petition has been resolved. Full stop. However, comma, the CAC Limited, comma, it is alleged, comma, is charging even for the period during which the petitioner did not have electricity in view of the disconnection due to the fire. Full stop. That apart, comma, learned counsel contends that the petitioner is not liable to pay the rent for the period during which there was no electricity as per the lease agreement. Full stop. Next para. Insofar as the last argument made by the petitioner is concerned, comma, it is beyond the scope of the present writ court to deal with the issue, and it will be open to the petitioner to agitate such point before an appropriate forum, comma, if necessary. Full stop. Insofar as the second point urged, comma, it is quite obvious that since the petitioner did not enjoy electricity for the period during which it remained disconnected due to the fire, comma, the CAC Limited cannot charge electricity bills for the said period or include the said period in its current bills. Full stop. Accordingly, if the CAC Limited has included any portion of the said period within the purview of their current bills, comma, the excess amount pertaining to such period shall be adjusted with the next two bills of the CAC Limited. Full stop. Next para. Further, comma, the CAC Limited shall remain restrained from charging any electricity charges during the period throughout which the connection remained disconnected. Full stop. Next para. Since otherwise the writ petition has met its objective, comma, there is no use keeping the writ petition pending further. Full stop. Accordingly, WPO 51 of 2024 is disposed of in the light of the above directions and observations. No address to cause.
Only one line be added since we have not used an opposition.
Since no affidavits have been invited, it is deemed that none of the allegations made in the writ petition are admitted by any of the respondents. Thank you.
Grateful, Mal. Extremely grateful.
Item number 3, court application.
Yes, Mr.
Alvar Max Entertainment.
A small minor correction in the last order. Your Lordship, actually, that was my submission due to my first paragraph, Your Lordship, my Lord, kindly see, my Lord. Fourth line, my Lord, first paragraph, fourth line, my Lord. Herein has been held to be a secured creditor and the shares of the, my Lord, there's what's to be Manthan. The shares of the Manthan, which was not pledged to Alliance, my Lord, but retained by it, have been made a part of the liquidation statement. I have no objection to liquidation statement. What my objection was, it was made as a part of the liquidation state under regulation 21A of the liquidation provisions regulation instead of section 25.
Shares of Manthan.
Which was not.
Which were?
Which were not pledged, which were not pledged with as per liquidator, my Lord. Liquidator is here, my Lord. Which were not pledged with the Alliance, but retained by it, have been made a part of the liquidation estate under regulation 21A instead of section 25 of the IBC, my Lord. This might because when under tribunal directing him to return under section 20, the regulation 21A, my
Sir, Banerjee, I'll make that correction in the previous order. Because his submission, I have to record correctly.
Yeah, that's
Shares of Manthan. It is pointed out by learned counsel for the petitioner that in the order dated February 29, 2024, comma, it was recorded erroneously in the first paragraph that the respondent number 3, that the grievance of the writ petitioner is primarily that Alliance, comma, the respondent number 3 has been held to be a secured creditor and the shares of Alliance which were pledged to Alliance but retained by it have been made a part of the liquidation estate. Full stop. However, comma, it is liquidation estate. Full stop. However, comma, it is pointed out by learned counsel for the petitioner that as per his submission, comma, the shares of Manthan which were not pledged to Alliance.
Yes, my Lord. This is my picture.
But retained by it. Rest remains.
Yes, retained by it, my Lord.
The shares of Manthan which were not pledged to Alliance but retained by it have been made a part of the liquidation estate.
Under regulation 21A instead of section 25.
First step. Next para. Accordingly, let the order dated February 29, 2024 be deemed to stand corrected accordingly by deeming that the allegation of the petitioner is that the respondent number 3 has been held to be a secured creditor and the shares of Manthan, which were not pledged to Alliance but retained by it, have been made a part of the liquidation estate. Next, yes, make your arguments.
Well, 2 minutes today I will take, my lord, 5 minutes, not more than 5 minutes. Your lordship, kindly see, my lord, impugned order at page 77, my lord, which is the impugned order, my lord. On, my lord, that day, my lord, this only 2 applications were listed on that day, my lord. One is the application filed by the ex-directors of the Manthan. This number was IA 334 of 2023.
Yes.
Page 77. And well, second application filed by the liquidator IA 427, well, which the honorable, which the learned tribunal had decided on that date, my lord.
Yes.
So, on this issue of this, which is the relevant, which I'm challenging the impugned actually part, that where this respondent number 3 was directed to return the shares under regulation 21A, my lord. This application, my lord, I don't know whose laches it is. This application belongs to IA 386 of 2021, which is filed by the RP under section 25 of the Insolvency and Bankruptcy Code, which is a duty bound to bring back all the assets of the corporate debtor. But by placing it, but by directing to return it under the regulation 21A of the liquidation process regulation. But how I am hampered in that way, your lordship, because as per section 53 of the Insolvency and Bankruptcy Code, he has been made to place over and above the all other creditors while the distribution of the assets. Whereas as per by the law and as per the application filed by the liquidator, he is supposed to get a 0 rupees from that 9 crore rupees, which are coming through the shares. But
otherwise, you get a precedence in the list of creditors.
Yes, he has been, because he was directed nowhere, even when the case was not listed on that respect. I don't know how the submission started before the learned tribunal that the regulation.
What has been, which portion of the order you are agreeing?
Well, at your lordship.
Oh, they have been held to be a secured creditor with that observation.
Yes, your lordship, I'm coming to my lord, that kindly see, my lord, page 80 first, my lord, page 80. Particular impugned part is page 83, your lordship. Impugned part is page 83.
Yes.
83, last paragraph.
In the present case.
Yes, my lord, in the present.
Yes.
In the present case, the liquidation commencement date is 6/4/2020. Alliance have evidently and admitted failed to its intention to realize a security settlement where its lines comes. It was not a security interest. It's saying it has evidently, but because some submission has been actually started by
what was then? What was it then?
It was the IA 386 was filed to straightway return the assets of the corporate debtor which you are holding illegally. This one liquidator can better say that liquidator is before your lordship, my lord. His application is also pending. So by placing it in this way,
whose application is pending?
IA 386 filed by the liquidator, or to
for them to return those shares.
Yes,
that application is pending.
Yes, my lord.
Yes.
Well, before deciding this case, when the case is not before the actually learned tribunal, it directed that to this is only simple prayer first to decide that this application.
What was the number of that application? IA
386 of 2021, my lord. And my biggest thing is that even the ex-directors of the Manthan has repeatedly told the learned tribunal that you are saying this. So by saying this, you are making the applications infractious, which is also recorded in this order. Though I'm not supporting the ex-directors, but to certain extent, their submission was right to say that if you decide in this way, you are making infractions not only the application, even the civil suits pending before the High Court, where he himself praying for this thing. But this has been made indirectly. The person who is not entitled to get that thing, he has been made indirectly. Though he not succeeded directly, he was.
Let us read on this paragraph, Mr. Dutt.
Yes, my
thereby having
83, my lord.
This obligation under regulation 21A.
The liquidation commencement, my lord.
So this is correct.
83, my
83 you are placing.
Yes,
please continue.
Yes, my in the present case, the liquidation commencement date is 6/4/22. Alliance having evidently and admitted fails to its intention to realize a security in some of this. So here my learned tribunal swayed away from this thing. Well, I don't know how it comes in the mind of the learned tribunal, and thereby having failed to discharge this obligation under regulation 21A cannot be permitted to retain the share held as security. Well, it is not held as security. This application is still pending, IA 386, which is to decide whether it is a security or it is held illegally, my lord. So without the case being listed before the learned tribunal or the learned tribunal actually passed this order, first thing, my lord, this is the he has exercised the residue.
So, according to you, Alliance having evidently and admittedly failed to its intention to realize its security interest.
This
it had
thing
no
also-
security interest.
No security interest, my lord. How they failed, my lord, to realize this?
Nor was it held as security.
Well, because, my lord, even if they want to realize, they could have just followed the regulation 2021. They could have, they have not approached the liquidator that we want to realize. They have not submitted any bill to the liquidator because they
Having
know.
failed to do that,
Yes, my lord.
they are not entitled to be held as, security, have security
Shares,
interest.
this was shares illegally because they are one. Actually, basically, they were one. So at certain point of time, there was pledged.
So since they have not applied before the liquidator and before the resolution professional, so the shares were directed to be returned.
No, but
an application was made for direction on them to return.
Well, two aspects were there. Your lordship, first at the time of CIRP,
Yes.
at the time of CIRP, RP filed the application under section 25, where the only RP entitled to. He filed the application IA.
No,
This is
they
IA3.
didn't file any application staking their claim in that CIRP.
No, they challenged before the High Court, my lord.
They had filed that proceeding.
They filed a CS 54 of 2019 when the liquidator started.
CIRP was initiated by whom? Them.
Respondent number 3 against them. And
So obviously, they stake a claim to those shares.
They have not expected that the RP will get it detected. And when the RP moved against them, they rushed to High Court, my lord.
What did the RP detect?
RP, my lord, detected that. Firstly, he detected they are not. First, they are the related party. They were not allowed.
They
to
filed the CIRP.
Yes, they filed a CIRP against the
CIRP.
Manthan, my lord.
In that proceeding, that culminated in a liquidation process.
Yes, sir. Subsequently completed liquidation process.
When did the resolution professional file the section 25?
Section 25 in January 2021.
I'm not asking for the date. At which stage of the proceeding?
Well, in the beginning of the CIRP
The
itself.
beginning.
Beginning.
That section 25 got decided.
No, but that is not decided.
That is still pending.
This is only my prayer. But that application, you decide this issue in this application. Well, I'm demanding demand on only this thing. When this application is pending, you decide in
In that application, what did the resolution professional ask for? What is the direction sought?
Section 25, my lord, saying that to directly, my lord, which is even recorded in this order itself, my lord.
Where is that application prayer? Have you annexed that application here? No.
My lord, that application is with me, your lordship. Actually, I have not annexed with that, but that application has.
I want to see the exact prayer of that.
Yes, my lord. Please see.
Have you seen it? হ্যাঁ, এটা আছে আছে হাতে করে
Even my lord, recorded in this impeached order also, specifically recorded in the impeached order. It is urged that the RP nor liquidator in the said IA has not paid for adjudication to whether the pledge is subsisting or not. The liquidator stand is that there is no pledge, and hence the physical possession of the said share should be handed back to the liquidator.
Held by the corporate debtor, that is them.
No, he's not corporate debtor. He was
But
he was petitioner in that.
The prayer is hand back the physical custody and possession of the 77,500 shares.
Yes, of the corporate.
Of the respondent company.
Respondent
company was Manthan.
Manthan, my lord.
Held by the corporate debtor. Who is the corporate debtor?
Well, held by the corporate debtor is the Manthan, your lordship. That corporate debtor is the Manthan. It may be typographical error on his part, my lord, but the CD is a Manthan, and he is the petitioner in that who moved against the corporate debtor.
The shares were of Manthan.
Yes, the shares belongs to corporate debtor.
Corporate debtors shares
has been held by
the shares are of Manthan.
Manthan, my lord.
Manthan's shares are held by Alliance.
Yes, my Manthan, at one point of time, Manthan has pledged that shares to the Alliance.
Whose share is held by whom?
No,
You are Alliance.
I'm Alliance. Manthan holds shares.
I'm a judge. The thing is being confused.
Yes, my lord, may I just?
Yes.
My lord, my lord, Manthan holds shares in Alliance. All right. 77,500 shares were held in me. There was an earlier loan taken, and there was a subsequent loan taken of 12 crores, for which Manthan pledged my shares to me.
Oh, yes, you said.
So the 12 crores was never paid. We filed and it's financial creditor. That's why we filed a section 7 application. And we had also earlier instituted a suit saying that the shares are pledged with me. And I will show, my lord. Anyway, let my learned friend finish. In
Let
fact, my lord, I thought I was submitting. My lord, I forgot, my lord.
No, my lord, no.
No, I've forgotten entirely.
My lord, because I thought I'd started making submissions to show, my lord, that application which is made.
My lord, I will take 5 minutes only, your lordship. I will complete
Very well,
my entirely, but I will not go further, my lord.
Yes.
Sorry, my lord. In that aspect,
No,
I
no,
will
Mr.
also
Rathi,
confuse your
very
lordship.
good.
My lord, that liquidator stand. Who is the best judge of this? Whether the actual dues has been paid or not? But that was the liquidator. The liquidator initially RP, my lord, as an RP found that this entire dues has been cleared, and after going through the records, my lord, he found that there is no pledge created over the shares, but you are retaining it illegally. So, my lord, he directed them to return back that shares. So this is the, my lord, the stand of the RP, which is so that application somehow escaped attention of the tribunal, or the RP has not taken any initiative, whatsoever may be the reason, my lord. So that application is still pending, which will adjudicate, and my lord, that my learned senior counsel moved to High Court after filing of this petition before the NCLT, whereas as per section 60, subsection 5, this entire connected issues to be decided by the NCLT itself. And this honorable single judge also returned back this prayer of the learned senior counsel that you approach before the NCLT. Then my learned senior counsel approached before the honorable division bench. The same order of the honorable single bench was upheld, my lord.
No.
So much. This was my injunction. This was the injunction petition against the liquidator. They are moving, my lord. So much. One thing was also there, when in the month of January 2022, Honorable High Court directed that to mandatorily and positively decide all the pending proceedings within 3 months, my lord. How this, my lord, 386 has yet not been decided, but 386 of 2021. Second, your lordship, and only in addition to that, my lord, I will like this only 3 judgments. I already have submitted you to your lordship, my lord. Since my lord has held that the issue of maintainability and this issue of my lord, the merits are still there, my lord, I will file that. My lord, this is the judgments. My lord, I made a copy in
He
this
had
way.
given judgments on the last one.
Last time,
What is this judgment? Which judgment?
This is my settlement, 3 new judgments. My lord, 1 judgment belongs to my lord, and 2 judgments belong to Honorable Supreme Court.
One judgment belongs to me.
1 judgment belongs passed by my lord, on that issue of.
Mr. Dutt, these are over and above the previous judgment.
Yes, my lord. 3 judgment, my very much.
Yes.
Please. Here I am giving to you also.
Very
I am giving one. My lord, first judgment is that where first judgment actually passed by the Honorable Supreme Court, MS Godrej Sara Limited versus Excise Taxation Officer.
This is like a short written notes also.
Yes, I went ready with
not
that.
that.
Only 2 pages, short
written notes. Very well. File that also.
Only 2. I'm grateful. I will hand over to my copy to you.
Give us a copy.
I will give you a copy. Just it was made today itself.
You follow the oral arguments and
yes,
I'll go through the written.
My lord.
Yes.
My lord, here, my lord, is Lordship Justice Dipankar Datta. So, my lord, this is reported in 2021, Indian Supreme Court 19-2. My lord, paragraph number 4, 5, 6, 7, 8. My lord, I'm not wasting my lord's more time, my lord, because it starts from that the High Court must entertain the petition. My lord, it is not that way, but the High Court must entertain the writ petition, my lord. And your lordship, at the last paragraph, I'm reading paragraph 8 as page 8 of the judgment, my lord.
Yes.
Last 5, 6 lines. What follows from the said decisions, my lord, continuously.
What follows? Yes.
What follows from the said decision is that where the controversy is purely legal one and it does not involve disputed question of fact, but only question of law, then it should be decided by the High Court instead of dismissing the writ petition on the ground of alternative remedy being available. So here, my lord, it is a pure question of
the
law.
tests have to be satisfied. Arbitrariness, malafide, unreasonableness, very principle. Those have to be satisfied.
That, my lord,
not any question of law.
No, not my. I'm saying a question of law. First question of law is when that application is not listed before you on that date, before NCLT, my lord.
Any question of law, with utmost respect to this judgment of Justice Dotto, any question of law cannot be looked into by the Article 226 Court. No. There has to be either arbitrariness or Wainsbury principle or malafide or one of those criteria.
Yes, but those
have to be satisfied here.
Yes,
it has to be patently arbitrary or unreasonable. These have to be. Otherwise, decisions cannot be gone into. The decision-making process can be gone into.
Yes, my. Absolutely.
So where is the arbitrariness?
That matter, I'm showing you, lordship, the arbitrariness is my reason has not been cited. How he is a secured creditor, my.
Very well. Out of the blue, this observation.
Out of the blue, So without listing of that application, I
you created this nomenclature. This comes out of the blue, which confers a right on him which he does not have according to you.
Yes, my
And moreover, that application of the RP had to be decided first,
that
because
application
that was for a direction on them to on the corporator to return the shares.
That was the content of that application, which is they're quoting in this application. Irrelevant, extraneous, my lord, erroneous question of law has been decided in this application, my lord.
Right.
So my second judgment, my lord, again I'm placing before the my lord, para 51 of that second judgment, this Kranti Associate versus Mashood Ahmed Khan, paragraph 51, my lord, of that judgment. I'm coming to your lordship. Sir, I will give you this entirely. Just 1 minute, sir. Actually, I could not. That is Kranti Associates, Private Limited versus Mashood Ahmed Khan. Second, my lord, that I attached the flap in a hurry, my lord. It is made today, sorry.
Yes, Kranti Associates.
This is paragraph, my lord, 51, your lordship.
51, yes.
But my lord, I will not read it again. I will not waste the time because this paragraph was quoted by your lordship Justice Banerjee, which I read before your lordship.
All right.
So I'm not wasting your lordship time again reading that, my lord. So my third judgment is before actually belongs to my lord judgment. My next judgment, my lord, where my lord has
each of the judgments quotes the previous judgments. Yeah.
Yes, my lord. That is
and
what
my judgment
my,
is last.
my lord has specifically held that this absence of reason.
The previous judgments must have.
No, that is not a magic quoting. Your lordship kindly see, my lord.
Yes. It's the same thing. I mean, on the same point.
No, it's a my lord judgment at paragraph.
Apart from it being my judgment, otherwise it's same. I mean,
no, but
the
it's my
point
duty to remind my lord, my lord. This is the my lord.
Yes.
Well, paragraph number 33, my lord. It's a very old judgment of 2020, my lord. Axel Pomil Limited versus Union of India, my lord. Paragraph number 33, my lord. It's saying, moreover, unless the reasons to believe for the A to issue the notice under section 8 are communicated to the noticee, the letter would not be in a position to produce the total evidence on which he relies and other relevant information, particularly which right also incorporates within its fold the entitlement to show the reason to believe and the commission of the offense. Well, here, I'm this applying in a different sense, your lordship. Your lordship basically held that when you are not providing the reason, you are actually restricting the person from his defense or making a grounds, my lord. Basically, this was in that way that you are restricting the person from raising his defense. In the absence of reason, the person is not able to make his defense properly, my lord. So here, so my lord has held in that way, my lord. It was in that negative sense where at that time we have not provided the reason. So it.
No, Mr. Bhatt, you have committed the sacrilege of not annexing my judgment.
No, my lord, this is your lord.
Only that is not here. The other judgments are here. So already your half of your case is gone.
No, my lord, I shall do it correctly. My lord, kindly give me. I will. How it can be, my lord? It should not. Please, my lord. Actually, just one.
I am very passionate about this. My judgments being
my lord,
and annexed. Only that judgment you have omitted.
I mean, written on
the sacrilege, Mr. Bhatt.
My lord, I'm sorry, my lord.
After placing the paragraph, I see that the judgment is not here.
I'm highly sorry, your lord.
No, I'll find out from wherever you.
Apologize, my lord. Kindly, your lordship.
So that I'm just joking with you. Please, please hand over your compilation. I'll look into that judgment. The same principle has been reiterated again. No, whatever you handed over to me, hand that back. Yes. So same principle.
Yes, same principle on the reason that the absence of the reason denies the person is
yes, that is what it is.
So my last judgment, my lord, this is the last pages, my lord, from this my second page, my third page from the last, your lordship. This is third page from the last.
Third page from the last, yes.
This is judgment of the Honorable Supreme Court, AR 2009, SC 223.
Salutary requirements. One of the salutary requirements of natural justice.
Here, my Honorable Supreme Court saying
the last sentence, second last sentence, one of the salutary requirements.
Yes, my value of the natural justice is spelling out reason of the order. It starts that it starts when that a failure to give reason amounts to denial of justice. Reasons are live linked by it's saying it means that it's a violation of the principles of natural justice.
Definitely, yes.
So, my violation of the principles of natural justice. This is my lord, my grounds actually before your lordship and my lord only this is.
Why do you say no reasons have been regarding that finding?
Yes, finding a reason, my reason and principles of natural justice has been violated because that application was not listed. You are deciding this against me without placing that application before support. I'm grateful.
Thanks. Yeah. Yes, Mr. Van.
Lord, there's a question of Lord. Lord, first, Lord, I'm quite happy with the direction, my lord, on me to hand over the shares are set aside. In fact, my lord, I've been advocating that.
The direction is there.
Yes, that should be set aside, my lord. I have no difficulty. My lord,
No,
kindly,
he's not praying for that.
I need, my lord, set aside, my lord, that direction, because, my lord, he can't, my lord, have his pick saying that I will affirm this part of the order and I will not affirm this part of the order.
I can have my pick. This part is right, this part is wrong. Whichever goes against him is wrong. Mr. Dutt is challenging only on that security interest and secured creditor observation.
My lord, the
And
difficulty
why
has been
that
this.
section 25 was not decided first. These are the two
My lord,
primary.
the difficulty is this, my lord, this order which has been passed, my lord, is, my lord, in liquidation sale. What had happened, my lord, the sale was, I was showing on the last day, my lord, that sale was advertised. There's a third party, my lord, who's bid for those shares, my shares. And, my lord, my lord, was successful. But then, my lord, the suspended board of directors came and made an application saying that, no, you can't sell it to them. And that was finally decided pursuant to order of the NCLAT, finally decided, my lord, by this order.
What was decided finally?
Saying that the
this
sale,
order.
yes, sale is confirmed. Sale is confirmed in
Mr.
favor
Banerjee,
of.
then you should also have an issue with you that
Yes,
section
I have.
25
I
not
have.
being decided.
Yeah.
And you
No,
could have,
I am resisting it.
yes, exactly. That
Yes.
could have been decided. But that is my
Yes, yes, I am resisting it. And I'll tell you not why also.
Yes.
My
If
lord,
you successfully resisted that, there was an adjudication on that.
it has been
then-
ignored.
Yes.
It has been ignored.
So
why? And I'll tell my
here
lord.
you have a common point, I suppose.
We have a common point, but what I don't have a common point with my learned friend is, my lord, he says, I'm not a secure creditor.
Yes. There is the other aspect.
Yes, that is incorrect.
Why do you say?
Because, my lord, I'm a secure creditor as an accepted position.
Because it was pledged to you.
Yes, not play. It was pledged to me earlier. Part of the loan was returned, and, my lord, a fresh loan was taken. My lord knows under the Contract Act, there is a presumption that, my lord, that security continues. And not only that, my lord, what has the, my lord, again, my lord, I'm not supporting the order because I don't want to support the order. What the NCLT has done is, has, my lord, only said that you have not exercised your right. Now, my lord, I want to show, my lord, 2-3 things. My lord, it's very important. If my lord wants to interfere, my lord, I am very happy. Because, my lord, then it will, my lord, mean, my lord, I don't have to hand over because I don't want to hand over. I filed a suit. So, my lord, this is how it goes, my lord. Manthan, my lord, had taken an advance, or rather, my lord, a loan of, my lord, 10.5 crores. Manthan held shares in me because they had earlier subscribed. And those shares were pledged to me. That's, my lord, what I say. I filed, my lord, a section 7, and Manthan was refusing to recognize that those shares are pledged with me.
Achha. Very well.
That was Manthan's stand. Manthan was saying, no, for the previous loan, yes, part of it which was not paid pledged to you. The rest is not pledged to you. I filed a suit, a civil suit before this court saying that, no, the shares are pledged to me.
This is regarding the second.
Only 77. Yes, regarding the second, correct.
All right.
The 77.
So the contention was that whether those pledged shares were continuing as pledged shares.
Yes, because I say it's pledged.
That was a bone of contention.
I say it's pledged.
Yes, they say no.
They say no.
Right.
The Sony Malad is also Malad come in. Sony Malad claims themselves to be a creditor. The Malad, I say no. I filed an injunction. That was Malad identity injunction. I wanted to stop the sale as well of the shares. So, Malad, injunction was refused. I went up to the division man. Division man, no, this is only ad interim. You go back and have the matter heard out. In the meantime, Malad, the liquidation sale happened. It was challenged before NCLAT also. Malad, no one succeeded. Malad, the sale went through really, Malad, to Malad say. So, the sale has now gone through. I have, in the suit, the liquidators come and said, I've sold it. So, I've said I want to implement the third party because my pledge doesn't go away. If a share, Malad, even if it is sold, the pledge doesn't go away.
Goes with the pledge.
Yes.
All right.
So that is my advantage. I am saying I will recover my money.
Yes. You have implemented the
No, I am not in the process, because just the sale has just happened now.
Right.
Now, against this order, two things are very important. Section 61, has seen of the IBC. It permits any person aggrieved to appeal from that order.
Yes.
That's first. Second, the suspended board has already preferred an appeal before the NCLAT.
That is on the maintainability of this writ petition.
No, from the order, impugned order.
Yes. That is on the maintainability of this writ petition.
Yes, yes.
He could have preferred an appeal.
Yes, yes.
And an appeal has been preferred by
An appeal has been preferred. So, the question is, whether I'll have to come and defend here as well as there, or it's one place, where I am going to defend. And why, I say, and very important, what Sony
Mr. Banerjee, cross-objection principles apply in those appeals also.
Yes. Malad, though, that, Malad, that's
I don't.
No, Malad is, sorry, Malad, I just said yes as an instinctive reaction.
Right.
But Malad is.
May or may not.
Correct, may or may not.
All right.
Though, Malad, I remember that was, Malad, we had filed a cross objection, but that was, Malad, within the period.
So secured creditors, suspended board's appeals does not help him. He has to prefer an appeal. He has that avenue.
Suspended board is preferred from the whole thing because suspended board is saying also aggrieved.
But even then, he cannot canvass his point there.
No, he can prefer an appeal if he wants to.
He can prefer an appeal.
Now, Malad, what is very important, application board. Give me the application. Malad, this is the application which is filed.
Yes.
Malad, this was filed on 8th February 2024. Other side could be done if it doesn't. You have a copy of your application. Malad, kindly see Malad for page 4, notice of motion. This is Malad Sony's application. To recall, rectify the order dated 12 January 2024, wherein Alliance has been directed to return the shares, but inadvertently under Regulation 21A, whereas neither any application was pending. No, same thing, Malad, has been made.
This is the same order. 12
Yes.
January.
Yes.
What happened to this?
This is pending.
Oh. This become your lordship infractious.
No, let me hear him, then I'll come.
Yes.
So that is why, Malad, I came and Malad will recall, Malad, first day I came and said that.
Yes, you said. Right. So this is that application.
Yes. And kindly see, Malad, very important.
Power of recall is there.
Yes, Malad. The law now is, Malad, power of recall is there. Review you can't have.
Recall on what ground?
Malad, recall on the ground that, Malad, either without jurisdiction or, Malad, there was an error apparent on the face of the record, which I would also imagine, Malad, is also a ground why, Malad, you will come in writ as well.
Yes.
Otherwise, Malad, writ is also not, Malad, a remedy, Malad, which is easily available like that. So I was very surprised, Malad. In fact, Malad, that's the first day.
But this is very limited. I mean, the scope of this is very
limited. The same thing, Malad, they complain of.
Yes, but recall scope is very limited.
Alliance has been directed to return the shares. Now I want to show something very important. Kindly come to, Malad, paragraph.
This is like a review. If error apparent on the face of the
Malad, I don't know what, Malad, they want.
Review and appeal are maintainable together.
Malad,
unless that appeal is dismissed.
So, Malad, I am only on the question, Malad, how many forum, Malad, Malad will be
obvious,
there?
Obvious.
Now, Malad,
Forum stopping may be a ground.
Malad, kindly come to paragraph 14. And while show, Malad, even on merits, Malad, why is contention, Malad, is wrong. Page 14, Malad, paragraph particulars of the applicant, Malad, will find 1.
Yes. Right.
Culver Max Entertainment Private Limited, previously known as Sony Pictures Networks India Private Limited, hereinafter referred to as applicant is only secured credit of CD, with admitted claim of rupees 38 crore 43 lakhs and 49,000. Although, very important, Alliance Broadband later on accepted as secured credit to the tune of rupees 26 lakhs. It's his admitted position also that I am a secured creditor. So what is this grievance? I have not understood, Malad, what is this grievance now saying I am not a secured creditor? And that has to be really fought out because in section 53, Malad recalls, Malad, that waterfall mechanism. Now I'll show, Malad, something very more interesting. Malad, kindly see section. I'm sorry, Malad, another page also.
His grievance is that, but that you are trying to jump the queue.
Yes, but he himself admits. And also, I'm not jumping the queue, Malad, I'll show that also. Page 16. Again, Malad, paragraph 2.
Yes.
Applicant throughout contributed on the CRB because the applicant is only secured CD, though one Alliance Broadband later on accepted as secured credit of rupees 26 lakhs only. Unlike some other credits, applicant has performed each of his obligations. That's what he says. Twice, now Malad, kindly see section 53 of Malad, the IBC. 52 first. Malad, he also claims, Malad, Sony says he's secured creditor.
Yes.
Malad, he has a 3-acre land, which he says, Malad, he's mortgaged to him.
That is a total security.
That's his security, Malad, he says. I also am, my lord, part of the land mortgage to me as well for this money. Both shares as well as land.
That land.
That land. No, part of that land. Not. Now, my lord, kindly, very important, kindly look at section 52.
Yes.
Just give me that copy of the judgment, the sections. Never. Secure creditor in the liquidation proceedings may. अरे मेरे को दो ना वो जो mark किया था. May relinquish its security interest to the liquidation estate and receive proceeds from the sale of assets by liquid in a manner specified in section 53, or realize the security in a manner specified in the section. Then, my lord, kindly come to, my lord, 7. Sorry, my lord, 4. Before that, my lord, 52(4).
Yes.
A secured creditor may enforce, realize, settle, compromise, or deal with the secured asset in accordance with such law as applicable to security interest being realized and to the secured creditor, and apply the procedure to recover the debts due to it. Then, my lord, 7, where the enforcement of the security interest under subsection 4 yields an amount by way proceed with excess of debt. Then, my lord, very important, 9. 52(9).
Yes.
Where the proceeds of the realization of the secured assets are not adequate to repay debts owed to the secured creditor, the unpaid debts of such secured creditor shall be paid by the liquidator in the manner specified in clause E of subsection 1 of section 53. My lord, he has not given up his security. He is wanting to sell that 3 acres. So, my lord, he comes under clause E of subsection 1 of section 53. Now, my lord, kindly come to 53. Now, kindly see, my lord, if I am held to be a secured creditor and I have given up my interest, then, my lord, I am 53(1)(b). II.
You have relinquished his security.
That's what's been held in the order.
All right. All right.
Now, let us assume, my lord, I am not a secured creditor. Then, my lord, I come under D.
Yes.
Which is all before E.
Oh, he is E.
Yes. That's, my lord, 52(9). Because admittedly, my lord, he is not given up his security of 3 acres. So, this priority business which he claims is also incorrect.
He has retained his option of.
Yes. And, my lord, I have, my lord, those documents, my lord, to also show, my lord, if my lord wants, my lord, where, my lord, the.
To show what?
My lord, that he has not given up his security.
Unless he opposes, I mean. But put that in your brief written notes of our book.
Yes.
That he has.
So, my lord, so let us, my lord, see now, my lord, the order. I am quite naturally, my lord, holding on to my security.
And you have your suit also.
I have my suit because I am saying the whole thing is with me, and I'm saying you, NCLT, can't decide. Now, quite naturally, my lord, I will soon be hauled up, my lord, in contempt because you have not given.
But I wonder now whether that section 25 can be decided. I mean,
it has not been, my lord. Accidentally, my lord, it's been decided, my lord, with this, because what happened, my lord, the suspended board says, and suspended board, my lord, has always opposed liquidation.
Obviously.
Now, my lord, when the sale is coming, they're again opposing that. Because liquidation means what, my lord? Just to sell the assets now. So, every chance they get, they are opposing sale. First liquidation that went up to the Supreme Court, and then I only opposed. I said, no, I want liquidation. Because if I get liquidation, at least some money will come. I am also not doing it, my lord, altruistically.
This money comes, you don't get an advantage.
Correct.
53 also.
I get nothing. So I have always, my lord, canvassed that yes, there should be liquidation.
But there will be a confusion because unless a suit is decided.
My lord, that's, my lord, what has been, my lord, I have to argue in 53.
Yes.
When the time comes.
Yes.
When the times come for distribution,
very
I'll have two things. I will either, my lord, have to go on, because I'm, even if what happens, my lord, if I'm forced to give up my shares, I don't lose my security.
No.
I will then say it has got transferred to that.
Right.
So today, my lord, we are only on the question, my lord, how does this order, first of all, my lord, whether, my lord, at all, my lord, a writ petition should be entered in from this order or not. And secondly, my lord, how does this order affect, my lord, my learned friend? He himself admits I am a secured creditor. He asked for recalling of that order on that ground. I don't know whether it will be successful, not successful. That's up to the NCLT itself. So his statement I've shown.
What was the ground of his defense? Para 7 probably.
Yes,
inception. You are withholding unlawfully,
yes,
something of that sort.
That will be decided whether I am unlawfully withholding or lawfully holding. But the idea, I don't want any spanner in the works so far as the liquidation is concerned. Because that's what I've been fighting for sale. So that something comes out of it. Right. And that is my interest in the matter, to ensure that is and the orders will find the orders are all there. Because today that's why I am also in a state where I don't know whether we should actually contest this order. Because the moment I contest, that means also liquidation will come to a standstill. Yes. Can you see my predicament also?
On suffer dilemma.
Yeah. If that comes in again standstill, then again no money comes in.
Right. So are you opposing or?
I don't want to give up unless forced to give up my shares. Yes. I quite naturally don't want to give up those shares. But if my right is then transferred, which it should be in law it should be transferred to the sale proceeds of the shares, then perhaps I still have to go and fight that out in 53 distribution.
Yes.
Because now whether the 53 distribution, once it was held by the High Court at the ad interim stage, and no, we can't decide. Which went up to the division bench and came back again to the single bench saying that now you decide whether you can or not. So and if the question is that the NCLT has to decide, then again I have to go and argue that there to say how 53 will. And the applications which were filed on the shares is only for the purpose of returning the shares.
Yes.
Nothing else.
That there cannot be an adjudication on that.
And will find that is what my stand was. The NCLT perhaps has directed me to hand over because we opposed if looks at page 70. Where's that order? Achha, how come this orders? 12 January 2024. Oh, 24. Sorry, sir.
Mr. Banerjee, this section 52(4), this applies to you because of this sale. Otherwise, you were retaining those shares.
I was retaining those shares.
But now, in view of this direction for those to be
yes,
sold,
yes.
Now you come within 52(4),
yes,
and 9 consequentially.
Correct. I'm saying 9. He comes under 9.
I'm sorry, 4.
Yes, he comes under 9. Because that is an admitted position that he's not given up his security of 3 acres of land.
Right.
Or rather, and he's selling it as well. That's the permission is sought for, and the liquidators asked him what has happened to the sale. Well, so if he comes under 52(9), then he goes to 53(1)(e). But I'm saying that is not a decision which has been taken. That is why I am still in my rights to go and say that sorry, I will have to get my money. In this, if looks at page 65, this is the earlier order, 14 February 2023. This is enclave order. Okay, enclave order. Kindly look at page 72.
Yes.
Learned such and such. Council appearing for Alliance Broadband would submit alliances page 72, paragraph 12. Secured financial credit of Manthan, cooperated in view of the short-term loan of 10.20 crore provided to Manthan in 2018, securing the following assets. It says I and II. Then, my lord, it's submitted upon failure of resolution process. COC of Manthan at the COC meeting held on 8 decided liquidate Manthan. Adjudicate directed liquidation of Manthan. Alliance filed its claim with the liquidator in Form D for rupees 14 crore 47. Also indicated Alliance shall not relinquish the security held in respect of pledge shares, Tajpur land. Financial claim of Alliance for rupees 4 together with the security interest is confirmed by record of date default issued by NESL. Then
you also have this 10.08 acre of non-agricultural land.
Not also, that's only part of the land. My lord, he's got 3 and I've got, my lord, 8.
10.0. Yes.
8 or, my lord, 10. Then, my lord, kindly see. Where is that challenge? 26. Then, my lord, kindly come to paragraph 21. We would also note that the present applicants had taken out the company appeal before this is the suspended board.
But if you have 10.08, Mr. Banerjee, how can you come within 52.4 then?
Sorry,
that remains 52. How can you come within 52.4? That land remains. That is also one of the assets.
Yes, that also is not been recognized. Both, my lord, is not recognized. I have, my lord, the land as well as I claim the land as well as the shares.
Then the land remains. So you are not in a better position under 53 than him.
My lord, I'm only on the question, my lord, he's not.
At least on an equal footing.
No, I became an unsecured creditor then, my lord, if nothing is with me.
Oh, even then?
Yes.
Oh, right. Yes.
He comes to E. His position, my lord, will always be 52.9.
No, but as of today, if you have that land as well as the shares have been transferred.
Then, my lord, no difficulty because I'm showing, my lord, his grievance is meaningless. Because if I'm also a secured creditor, I will sell both and get my money. In fact, I will have excess then. Then I'll have to return it.
Creditor part remains.
Yes.
That is what he's agreed with. One of those.
And that secured creditor part, he's only also admitted with regard to the 22 lakhs, which is the remaining of the previous loan.
All right.
I am claiming a higher right.
Yes. On the second loan.
Yes. And I've been told that, no, sorry, you go. Either, my lord, I come under 53(1)(b)(2) or minus everything, I'm still in D. And he will only come under E.
Yes.
Because he is realizing part of his claim from, my lord, a security which he has. And if, my lord, looks at, my lord, now page 75 and 75, my lord, this is when the erstwhile, my lord, the suspended board wanted to settle with me when the CRP was admitted. Then, my lord, kindly look at paragraph 22. The order dated 22nd 10/2019 when challenge met with dismissal. Consequently, COC was constituted by an order dated 16 April 2022. Liquidation of Manthan was ordered by the adjudicating authority. Further challenge against the liquidation order was also stood dismissed by Honorable NCLAT and the Honorable Apex Court. A considerable time has elapsed since liquidation of Manthan was ordered, and presumably it is the directors of the suspended board who had pushed Manthan in liquidation. At this juncture, allowing the directors of the suspended board to intervene or restrain the liquidator from proceeding with the auction would not be fair. Accordingly, we allow e-auction as proposed on 14 February 2023 to be conducted, which shall, however, abide by the result of this application. Consequently, action in regard to auction shall be conducted only with the liberty of this tribunal, and report to that effect shall be submitted by liquid next date of hearing, list IA 334 on 15 March, certified copy. And then, my lord, the impugned order comes, my lord, which is on 12 January 2024 at page 77. And, my lord, sorry, my lord, that 14 February was also challenged by, my lord, the suspended board, and the NCLAT, my lord, by an order that's not on record here, 18th April 2023. My lord, they had withdrawn, and my lord said we will take all the points, my lord, before the NCLA. That's the order, my lord. If my lord wants, my lord, I have the order, my lord. Then, my lord, the impugned order kindly see, my lord, 78. It is some paragraph 3.3.
Yes.
Suspend board said submitted such an attempt for auction sale is in violation of proviso to regulation 32 of the liquidation process, which provides that any asset which is subject to security shall not be sold unless it has been relinquished to the liquidation estate. So that is one of the contention of the suspended board. And in that context, one of the NCLT holds rights have been given up under 21A. Not exercised 21A, therefore Mullet becomes part of the liquidation estate. Alliance having not yet relinquished security interest in favor of liquidation estate, the shares could not have been put up for auction. That Alliance has filed a suit being sunset in Honorable High Court against the corporate debtor liquidator, prevent corporate debtor or liquidator from enforcing any right in respect of the shares. This contested issue between Alliance and liquidators also the subject matter application being IA number 380, IA 386, whereby the resolution, this is all Mullet submission made. Then 3.4. This is where that the sale notice is important. 3.4 Mullet, page 79. That the sale notice is important in terms of the sale is important in terms of the sale notice. Sale notice declares that the title deed and the share certificates are in the custody of Alliance. An application for recovery thereof is pending, and in accordance with the terms of the sale notice, upon receipt of consideration, liquidator is covenanted to make over the title in share certificate and possession of assets to the purchaser. Therefore, it is impossible liquidator to comply with declared obligation sale notice. If the liquidator is comfortable with this position, mean that Alliance associates will purchase the asset, thereby the liquidator to have any difficulty in fulfilling. Mullet, this is what was Mullet submitted. Then Mullet will kindly see Mullet 4.2 Mullet, this is the stand of the liquidator. Then straight away,
this proceeds on the premise that the pledge arrangement is over.
Yes. And then Mullet 81, page 81. Why Mullet this came about? It is further second Mullet line from it. It is further urged that the regulation 21 of the liquidation regulation provides for providing a secure interest by secure creditor. Regulation 21 of the liquidation regulation provides that if the secure creditor not discharge the obligation 90 days from liquidation commencement date, shares will automatically form part of the liquidation estate. So this is very much a submission Mullet made by the liquidator. Liquidation having commenced on 6th April 22, 90 days expired on 6th July 2022. Admittedly, Alliance will not perform its obligation under Regulation 21A2 of the liquidation. Hence, as per Regulation 21.3, said shares have automatically become part of liquidation estate by operation law. Argued further, the sale is being conducted as is various basis. Whatever there is various basis, same is stated categorically in the process document. Copies of all cost papers and details of liquidation uploaded in VDR, to which the auction participant access. That the possession of the shares are not with the categorically stated in bid process document at stage 1. At page 102 of the petition. Process document pertains to an auction which includes several other assets, plant, latent machinery, possession of which is with the liquidator, composite bid process, and such. Then, Mullet, in that context, Mullet, the Mullet paragraph page 83, 82, Mullet, it comes about. Paragraph 9.
Yes.
In that context, Mullet, the regulation 21A comment. And at page 83, Mullet, at the bottom, Mullet will find, in the present case, last paragraph, second last, liquidation commenced 6th April, Alliance having evidently and admittedly failed to intend its intention to realize security interest, thereby having failed to discharge the obligation under Regulation 21A, cannot be permitted to retain the shares held as secure. Having failed to comply, it cannot seek the prior as the operation of law after 30 days from the date of commencement liquidation. Failure as security to intimate to realize the security shall be deemed to have become part of liquidation estate. No provision or authority have been pleaded in record to show timeline and prescribed is not mandatory or regulation will proceed 21A2. We have taken a similar view in such. Therefore, Alliance is directed to hand over. Paragraph 10, this is Mullet against me. Accordingly, prayer fails. Aforesaid backdrop, we discuss the present application, allow the liquidation. Then Mullet, next is paragraph 1, Mullet, is that purchaser Mullet who had purchased the share, leave to intervene. That Mullet is also not necessary because Mullet. So Mullet, two things Mullet. First, Mullet, Regulation 21A Mullet was the argument of the liquidator, which was Mullet accepted by the court and said that no, since no right has been exercised,
yes,
you are right. Therefore, the security goes. So, Mullet, today, so therefore, Mullet, the question is, Mullet, whether I will have to answer here or Mullet, because before the appellate forum, because like I said, my lord, I'm sorry, I'm repeating. I do not want liquidation to stop because then I get nothing. And the other paragraph, my lord, is seen from the time, my lord, when the matter was admitted, suspended mode wanted to pay me off. Then, my lord, they never paid. That's why, my lord, it
Portion of
proceeded.
this order are you agree with?
I'm agree, my lord, with regard to, my lord, handing over. With regard to the handing over.
That application has not been decided here till now.
But here, my lord, they say, because, my lord, 21A.
It will be treated to be a part of the liquidation estate.
Yes.
That stage is over for that.
Yes. My lord, my 20, my lord, the secured creditor, the portion I've been admitted, can't go away.
If you are aggrieved with the handing over, Mr. Banerjee, then why do you claim advantage of 52(4)? And you say you are aggrieved with the handing over.
Because, my lord, if my secured interest goes away, then I'm aggrieved. My lord, it is only a question of, my lord, a transformation. That is why, my lord, I said we are still not, my lord. Yes, yes. We are still not decided because we don't know. I mean, my lord,
you have not yet challenged before.
Yes, I'm not yet challenged only for that purpose. Because I want to protect my interest.
Obvious.
Of my lord, getting the money. No one else, my lord, is interested in anything else. Question is, my lord, whether, my lord, they will get their money, my lord, which was advanced to them or not. He also wants his money, my lord. He is realizing it, my lord, through his 3 acres and then, my lord, whatever, my lord, is there. So quite naturally, my lord, he wants to throw me out as well.
But your right also depends on that suit of yours.
Yes. Whether, my lord, I have that security or not. If I don't, if I fail in that, or, my lord, if the NCLT decides that, no, sorry, we are deciding it.
I was wondering that whether NCLT, how far it can decide.
My lord, we have still not been successful. So far as, my lord, I am concerned, I think, my lord, it is really, my lord, the suit court which should really decide that issue. Then, my lord, perhaps there are ways when NCLT might say you return the money till that is decided or something like that, my lord, may happen.
In the suit court, there must also be a challenge to the maintainability of the suit. I mean,
yes,
must have been taken.
There was a challenge, my lord, to the maintainability. In fact, my lord, there was an application made by the liquidator saying, my lord, the suit is not maintainable.
Should be.
Yes,
Obvious.
correct, correct,
right,
correct. So we are, my lord, arguing that. But here, my lord, that is the question, my lord, whether, my lord, this should be, my lord, permitted, my lord, by at the instance of Sony. My lord, what they have shown, my lord, that it is totally unconnected is really not the situation. And he is not aggrieved. He himself says, my lord, I am a secured creditor. So I don't want, my lord, that portion, my lord, to have, my lord, any, my lord, to that extent. My lord, and the my lord, judgments, my lord, which has been relied upon, my lord, I don't think, my lord, I have any, my lord, justice
propositions.
Doctors, my lord, yes, my lord, if, and in fact, my lord had also, my lord, entertained writ petitions, my lord, before, but my lord, only one thing is, my lord, in, my lord, the Justice Shonji Banerjee's judgment, no, you had shown only. My lord, there, my lord, perhaps, my lord, the totally different, my lord, if my lord looks at, my lord, well, this is, my lord, the Shantanu Ghosh, State Bank of India.
Yes, Shantanu Ghosh.
No, that's not, my lord, an alternative remedy case at all. If my lord looks at paragraph 1.
That was for the reasons part. Reasons are the lifeblood.
Yes, and there, my lord, paragraph 17.
This is for paragraph 12, probably he cited. I don't know.
Yes, but that was, my lord, in a 10F appeal, my lord, Uniworth was decided, my lord, in a section 10F appeal. So that reasons are not there also available, my lord, in an appeal. It's not that, my lord.
Yes, obvious.
And, my lord, I showed, my lord, that argument was there. Regulation 21A was argued. That is a liquidator's case.
Yes.
That's a liquidator's case. It's not that, my lord, it came, my lord, somewhere and, my lord, there was all of a sudden, my lord, the bench, my lord, held. And, my lord, similarly, my lord, even, my lord, that Justice Pasayat and Justice Ganguly's judgment, my lord. So without reason, my lord, is, my lord, no, my lord, without reasons can't stand. But that's, my lord, also a question of an appeal. Whether, my lord, the writ petition, my lord, will be entertained on the ground, my lord, that whether it's without reasons or not, that is, my lord, a question which, my lord, none of these judgments held that. That's why I was showing, my lord, that it's not that, my lord, that a writ petition has been entertained because the order is without reasons.
No, reasons giving of reasons is also a part of the natural justice. It's also a component of national justice.
My lord, but
It has been held in
generally,
certain-
my lord, what I've seen, my lord, and what I've understood, my lord, that's really, my lord, an order without jurisdiction, my lord, or which is a, my lord, not passed, my lord, within the four corners of the statute, really, my lord, is something, my lord, where, my lord, an alternative remedy will be ignored.
Yes.
For, my lord, a writ petition too.
No, then arbitrariness comes in. If there is no reason, then arbitrariness component comes in.
My lord, here, my lord, I showed, my lord, that that was the argument which was made, my lord, by the liquidator.
Yes.
Saying because 90 days has not been, according to the liquidator, within 90 days, my lord, I had not given notice.
But Mr. Dhatt says that argument, the liquidator might have taken the stand, but when it's rendered into a finding by the authority,
My
then
lord, if I do not exercise right within 90 days, then, my lord, that's the
there's a
argument.
law.
Yes. That's what 21A
No,
requires.
he's agreed with your being found to be a secured creditor. On
That
which
one
your,
I already showed.
his application.
Yes. And there's no, the finding is that the secured creditor, my lord, is accepted by all to that extent.
Yes.
But
least
I'm
that
saying,
extent is.
yes.
You are wanting a larger.
Because, my lord, the contract act says so.
But still you are a secured creditor.
If, my lord, the first security is not discharged, and, my lord, there's section 74, 174. If, my lord, the first security, my lord, is not discharged, and, my lord, there's further loan taken, the presumption, my lord, is that, my lord, there's a the security continues. My lord, that's, yes, my lord, that's section 174.
Contracted, yes.
The pawnee shall not, in the absence of a contract to that effect, retain the goods pledged for any date or promise other than the date or promise for which they are pledged. But such contract, in the absence of anything to the contrary, shall be presumed in regard to subsequent advances made by the pawnee. And that's, my lord, our case, my lord, in the suit itself.
Yes.
So, my lord, my submission is, my lord, none of these cases, my lord, help, my lord, when, my lord, it is, my lord, a order which has been passed, my lord, within the scope of, my lord, the IBC, my lord. So, the writ court, my lord, should not, my lord. No, those are, my lord, my submissions.
Well, only 5 minutes, your lordship. But
Mr. Banerjee, I'll request you to file a very short written note of argument, just indicating,
point, my lord, point wise,
jot
yes.
down it may be bullet points also.
Very well, my lord.
Yes.
Yes, only
Mr.
5 minutes, your lordship. Only 5 minutes.
Yes,
The senior counsel has referred that application, that recall application. I'm referring
Yes,
to the
yes.
writ petition. I'm referring to a writ petition, my lord.
Right.
Well, it is not denied, your lordship, that it is not that I'm saying.
That is your recall application.
No, well, I'm referring to the writ petition itself, my lord.
I'm sorry, just for, my lord, just for, my lord, the records, I think, my lord, that on the question of, my lord, division bench, my lord.
Well, paragraph number 3 of the writ petition.
Just look at.
Oh, sorry.
Division bench, my lord, of the Delhi High Court, my lord.
Appeal.
Yes. On the question of, my lord, paragraph 6 onwards.
Para 12 is the.
Yes. 9, my lord.
9 also. Yes. Very. Yes, Mr. Dutt, quick.
Well, kindly see paragraph 3 of the writ petition at page number 3, your lordship.
Yes, sir.
So, last two line, one alas Broadband later on inducted as a secured creditor just to the extent of rupees 26 lakh. So far reading this, I am not saying that I have stated there and I am not stating here.
But still remains a secured creditor then.
Well, kindly see, impugned order, your lordship, kindly see, impugned order. No. To whom my learned friend is a secured creditor as per admitted, not to the shares, my lord. This is page 80, my lord, page 80, paragraph number 4, 451, my lord.
Yes.
So he is saying that per contra, the liquidator would submit as under that this instant IA has been filed seeking stay of the sale of the land and shares on the 14th February 2023, whereas land has not been auctioned on 14th February. The liquidator as such is not dealing with the issue of land, my lord. He had 26 lakh for 10 acres of land which is holding, my lord. So why that? For that reason, he is holding it. He know that the rate is much high and he will get, once bring, he will get only 26 lakh and nothing, zero. And in regard to shares, my lord, he is not a secured creditor. Here I have stated that he is a secured creditor in regard to 26 lakhs. It is not regard to shares. It is regard to land, which is. So why you are holding land? Simply think, my lord, he's asking me.
Actually, my lord, I'm sorry, my lord, factually not correct. It's with regard to the shares, my lord, that's what been.
No, my lord, I'm not stating, my lordship. Here, my lord, the second thing, your lordship, if your lordship kindly see the order, my lord, this impeached order, my lord, from the beginning of this thing, my lord, even the extractors are continuing saying they all are in collusion. Well, he's basically saying they all are in collusion. I am.
Who are in collusion?
This alliance, this liquidator, and this the purchase who has purchased from the liquidator the share as is very basic. He's saying that the valuation has been done by 3 years before, and without inviting the this meeting of the stakeholders, without inviting, he holding the security interest as a fiduciary capacity as per regulation 31A. He is not my boss. He is the fiduciary of the stakeholders, my lord. The liquidation order was passed in, my lord, in the month of April 2022. And now it is, my lord, February 2024. In the month of February 2024, he called the first meeting after selling the shares, my lord. First, still I have not raised the objection because me wants the liquidation. I know that the value of the share may be, as he is saying, it value is nearly 40 crore. But though it has been sold at 9 crore, I said, let it go. Okay, the matter is very much older and I bear this pain, my lord. So I have not challenged anyone. Even not a single meeting, not a single permission being taken from the stakeholder that I'm going to sell it as a sale is basis, my lord, not. Meeting is, my lord, mandatory as per the IBBI regulation and as per the law, my lord. And as per regulation 31A, your lordship, of the liquidation process regulation. Not a single regulation has been followed. I'm not challenging the liquidator because I want the liquidation to be gutted done immediately. So even after passing of, while in this order, I'm also surprised when 334 was filed to set aside the sale, only. Why the liquidator in a clear contradiction to his this IA 386, he started making these submissions, my lord. Why he started making this submission? Your lordship, and the second thing is, my lord,
to apprehend that this observation might help him in the subsequent proceedings under section 50 onwards. I mean 52, 53.
No, this was the collusive, my lord, submission before the learned NCLT to misguide the NCLT, to divert in this attention, to place him as a secured creditor, my lord. This is, your lordship, it is very much clear, my lord.
And how are you affected with that non-disposal of section 25?
Sorry, my lord?
The other point you raised was non-disposal of the section 25 application.
Yes, the section 25.
How that help you?
Here is section 25 application, my lord. Suppose your lordship, my lord, I'm coming on that, my lord. Yes. These assets will be the liquidation estate, even if comes under section 25 or even if comes under regulation 21A. It will be regulation 25. Right. So your lordship, my lord, kindly see, my lord, this regulation 20 of the liquidation process regulation and regulation 21. Well, claims by the other stakeholders. Where my learned friend saying, I am admittedly a secured creditor of 26 lakh in the shares, my lord. What's he saying that? Had he be this admittedly a secured creditor, he could have proceeded under regulation 20. He has not submitted any regulation 20. My lord, I'm reading that, my lord. A person claiming to be a stakeholder other than those under regulation this submit a proof of claim to the liquidator person or the person electronically found out. The existence of the claim of the stakeholder may be proved on the basis of the record. So he has not approached before the liquidator. Even if he has a little bit presumption that he will be succeed to get him claimed as a secured creditor, he could have ever proceeded under regulation 20 and regulation 21, but he has not moved that. So liquidation wants to say to the, actually, so my understanding, well, he tried to actually impress this learned NCLT, though even if you say he's not under the section 25, still the share use, so still the share is supposed to come because he has not moved as per the regulation 20 and regulation 21. So this submission, what? So here the word, even if he's missing in his submissions, my lord, only if he say that, even if we presume that he's a secured creditor, still he has not actually performed his obligation as regulation 20 and 21. So in that regard, so that share is supposed to come under liquidation estate, my lord. But my effective will be that your lordship under the section 25.
Yes.
Section 25 is, my lord, related to the RP, which was filed at the very beginning. My duties of the resolution professional. It shall be the duty of the resolution professional to preserve, protect the assets of the corporator, including the continuing business operations of the corporator. So, this, for the purpose of subsection 1, the resolution professional shall undertake the following action, namely, take immediate custody and control of all the assets of the corporate. It's not saying that the secured assets which are being held as security to take assets, because at that stage he cannot take that demand. So when he had demanded, it is admitted by the liquidator that these are not the secured asset. He holding a responsible position as an officer of the NCLT. He cannot diverge in such stance, and he started saying there may. When application of under section 25 is pending, either he should move before the NCLT and say, I am sorry, I apologize, I mistakenly filed the application. Or he should not make this such a type of submission verbally, which is nowhere in the application, but he's making verbally submission. Though luckily it has been recorded in the order, my lord, by the learned NCLT, because this led to misleading the NCLT to pass this order. Okay, you come under regulation 21A. Well, even up to that stage, he was rightly exercising his duties. So collusion starts thereafter.
If the section 25 is not decided,
yes, my lord,
how are you affected?
Well, section 25, your lordship, actually, second I'm coming to the section 53, but my learned friend saying that I'm not coming under that. Actually, kindly come to that.
One of your contentions was section 25 is not being decided.
Yes, my lord.
That affects you also.
Yes,
that is
that
one of
will
your
affect you, because, my lord, me alone is the secured creditor as a 9 crore rupees something.
He remains secured creditor at least regarding those 26 lakh regarding the land.
Is not
that you have admitted regarding the land.
No, that me saying, me and liquidator saying he's only 26. He is not admitting, my lord, because this will, my stitch on time will save the nine. But I said
I'm not saying that. I'm saying at least regarding that portion, the secured rate, he can be defined as a secured creditor.
My due to land, but 10 acres
due
of
to
land.
that land. Yes.
10 acres of land. But
Yes.
he cannot say that I'm the secured creditor in these shares and I will take 5 crore out
There
of
is
that.
no distinction between secured creditor of a particular land or another
all
asset.
of the shares.
Once secured creditor, he has the tag of a secured creditor.
Secured creditor.
So that has only been observed in the order. He's a secured creditor. The NCLT has not decided his rights over that over the shares.
No, it's a decided right over the shares.
This realizes
But
security
NCLT
interest.
only demanding the shares.
You are saying that the NCLT by this order is vindicating his stand that he has security interest.
Yes, but that he's saying that since he failed to realize his interest over the shares, my lord.
Right.
So the shares he has no right. How can he realize that interest? He's supposed to submit as per this IA 386.
But you have no cause of action regarding those shares.
No, I have a cause of action. Well,
regarding those shares, you have no nexus with those shares.
No,
the shares of Manthan pledged with Alliance. You have no interest in those.
No, I am not interested in shares, but I have this interest in that the sale proceeds of the shares, which is 9 crore something, my lord.
Yes.
So my due is 39 crore and his due is only 26 lakh. And for the 39 crore, I have only 3 acres of land.
Is the section 53 proceeding affected by this observation? Can it be affected?
No, your lordship, kindly, again, my learned senior counsel has read out that regulation 21A of the liquidation process regulation. I am again giving my lord pain, my lord, bit, my lord. So my learned friend saying that no, I am not entitled to the liquidation proceeds because I have exercised my right and I have not relinquished my rights, my lord. Here my learned friend was saying the double words where the NCLT is saying that since you have failed to realize your assets, it automatically becomes a part of liquidation. So similarly, my land also, when I have failed to realize my assets, so my land, this man automatically becomes a part of the liquidation state. I never say he is supposed to make any drum beat or file anything other that my has not come. So it by my land, this by virtue of law, it becomes a liquidation state. So I am at the same position, this at the top when it will be distributed. So it doesn't meet. So, but he was withholding the shares illegally, which he is not supposed to. That entire loan has been cleared. Everything was cleared.
What about the pending suit regarding his entitlement to those shares?
That suit, sorry to say, but that suit, I'm sorry to say, but it should not be maintained. It should have been dismissed at the earliest, at the first stage itself.
That because has been taken.
He himself proceeded in the NCLT, learned NCLT against the month in 2018, my lord. When the liquidator started demanding, he rushed just for the purpose of filing, and it was moved first in 2023, my lord. Why? When he found, my lord. So why it was kept?
When was the suit filed?
May 2019, March 2019.
19. I mean, there 18.
CRP is September 29.
No, petition was filed in CP 2018, you remember, 1634 of 2018, my lord. So why he moved when he started demanding the shares? So much the timing is very much matching, and it was not a match. It was seriously moved also, my lord. Second, your lordship, my learned friend has taken a stand of the recall application. My learned friend saying I've stated, my lord. Your lordship, kindly, I've submitted one note to your lordship, my lord. This is my NCLT rules, my lord. Just, my lord, this is my third page, my lord, third page of that notes, my lord. The judgments were annexed, my lord.
6 to 8 is the NCLT rules.
No, but that judgments, where I have submitted the judgments also, one bunch, my lord, was there. Side stitch bunch was there. Yes, my that there were 2 day judgments, my lord. But this is the written submission, written notes of argument.
In the written notes of argument, you have referred to pages 6 to 8, but the written notes is only of 3 pages.
No, but that your lordship, actually, sorry, my that may be in the hurry, but today I filed it, my lord, just today. Okay, I will get it. Only 2 pages, my lord, I actually cut it short down, my lord.
You have referred to pages 5, 6, and there are several pages after
Oh, my lord,
that.
yes,
but it is only comprised of 3 pages.
No, just 1, 2, 3. I made it small because I know, my lord, actually there's a very peculiar of time before your lordship, my lord.
Mr. Datta, I'll give you some other day, you will file your written notes.
No, only 1, 2, 3. Nothing is there, man. Only 1, 2, 3 pages. I've cut down, but that judgments I've separately submitted before you.
But the index remains regarding the other things. There is an index where you have referred to other.
Actually, regard to judgments. If your lordship say, I will attach with that judgment. Only that judgments were there. I will make it in a good way, my lord, in a spiral binding.
These judgments?
These judgments, that is the index belongs to that, but it was separately indexed. Nothing more is there, my lord.
Well,
it is only 1 to 3 pages.
I'll annex it to it.
Only 1 to 3, your lordship, I shall
say. Get your point. Very well.
Sir, I will give you 2 days, because it is 2 days in a hurry, even the pages one. My lord, kindly see the third page of that NCLT rules, my lord. Page third page, my lord, the rule 51 saying, my lord, power to regulate the procedure. The tribunal may regulate its
What's own look into this?
No, but that bunch, your lordship. That bunch, my third page, your lordship.
This bunch?
Yes, my lord. That's it, just again. 1, 2, 3. My third page over the NCLT rules are there, my lord. This is
yes, 51.
Yes, my regulation 51.
Right.
Regulation 51 saying that tribunal may regulate its own procedure in accordance with the rules of natural justice and equity, my lord. So,
has to be, yes.
So, like a consumer firm, my lord, he is bound to follow this. Even my consumer commission or the district commission are not bound by the rules and statutes. So, kindly see the rule 154 next, my lord, which he has a power to do, my lord. So only rectification of order, any clerical or
that is one of the questions I asked him also.
Yes, but that was, my lord. There, my power is not there, and your lordship, and my lord, it is. This order can't be rectified. Means for the typical only within 1 month.
What did you seek there?
No, I'm saying that application has been seeked, my lord.
And that application is not on a collateral footing with an appeal or a writ petition also.
No, that even appeal is entirely
that I am rather convinced with your argument than
it was not
that cannot be a bar. But appeal, what is your argument on appeal? An appeal is maintained. Why not
appeal is not filed. Appeal is on some another issue. We have not filed. No one filed this application.
No. Why is not an appeal maintainable as an alternative remedy here?
No, your lordship, I've stated that, my lord, because I am not the party. Something decided against me when the case was not listed before the learned judges. The learned judges passing the order. So, my lord, this is beyond jurisdiction, and that order also without stating that how it becomes a security creditor, only for the reason because he failed to exercise his duty under regulation 20, my lord. So only on single ground, this same because he failed to exercise his requirement under
that you are aggrieved with 2 findings actually. You are aggrieved with only 2 findings.
No finding, I'm saying that.
You are aggrieved not with the end result of this order, but
no,
2
I'm
findings.
Saying,
2 findings being
erroneous interpretation of law. Erroneous
actually,
application
your relief lies in a cross objection in connection with the suspended board of directors appeal. Because under cross objection, you can take out a challenge to findings. Principle of order 4122.
Yes, my lord, in that regard.
That is your best remedy, actually.
No, my lord, that regard.
These are findings. You cannot challenge this in appeal.
No, my lord, I'm saying, your lordship, kindly see, my lord. This aspect is supposed to be challenged by the liquidator within a time, but he remained silent, my lord. This is also a thing. This is, my lord, a biggest victory, I should not say, my lord. But no, I came before your lordship, my lord, only on this issue, which hampering me, which I was not a party, and certain application has been decided. Only, my lord, I'm praying that you decide 386 of 2021. So even the Honorable High Court had particular
But
director.
you are asking for a setting aside of this order before.
No, I'm not asking any setting aside. I'm only saying that this aspect, only this aspect.
No, you said that that Section 25 application had to be heard before this order.
Before
if I pass,
declaring him as
if
a
I accept that, then I have to set aside this and say that that has to be decided first, then pass this order.
Well,
So
only
in any event, it has to be set aside.
No, but no entire order. I'm
Which will remain.
No, Your Lordship, I'm only saying that the IA 386, this entire order, I have no problem with that because that is some another.
So you would be happy if I direct IA 386 or whatever Section 25 that to be decided within a limited period.
That to be decided.
And this order will remain.
But this order, this one line may be added that the alliance will called as a security creditor on the basis of that application, which is on the basis.
So you are asking for a modification of that file?
Only that modification, but that is basically tantamounting to review, which they don't have a power, my lord.
File a short, you have filed it.
Yes, I filed this short note, but
it's very well, yes.
And
only 2.5
Just one more important thing, my lord, IA 386 is not a party.
386, you are not a party.
Well, I'm not a party and I'm praying for liberty to intervene in that party. But it is filed by liquidator, my lord. It is filed by the liquidator.
He's not a party.
But you are still not a party, Mr.
Well, he is my agent, my lord. He is my agent.
Who's
liquidator as per regulation, my lord? Regulation, the section 36.
In fact, liquidator doesn't.
So liquidator, he is
unlike a COC, stakeholders committee doesn't have to be consulted.
My lord, he is acting as in a fiduciary capacity. My lord, kindly see the regulation, even for appointing an advocate.
For the secured creditors. For the secured creditor.
So my secured creditor, my stakeholders now. My lord, we
stakeholders.
Yes, stakeholders. We are the stakeholders, and he is acting on behalf of the stakeholders.
So when can you file a written note? Short, very short.
Yes, yes, my lord. By my lord, today is my lord Tuesday.
Friday, I'll keep it.
Yes, yes.
Friday.
My lord, I appear for the liquidator in this one.
What is your contention?
My lord, my contention is very specific, my lord, that there was.
You are colluding with Mr. Banerjee. That's why you are not.
That is what.
That is the allegation made.
That is the allegation, and that is what has come from the bar, my lord. The pleading itself in the application does not bear any whisper whatsoever insofar as any collusion being made.
No, why do you say that being the liquidator, why do you say that he's a secured creditor? Because regarding the shares, there is no, there is still fluidity.
Lord,
And he has
I
argued.
Never said that is exactly the reason, my lord. Perhaps, my lord, certain pleadings which were required, my lord, to be brought on record, wherein it would go on to demonstrate that I have never accepted alliance as a secured creditor during the proceedings. It is, my lord, an alternative argument which was made because, my lord, they have not been able to demonstrate, my lord, security insofar as the loan, whatever was advanced in favor of month. And that is exactly the reason why, my lord, we have said even if they have been, even if they can be assumed, my lord, held to be a secured creditor, in that kind of a scenario, they also have not exercised their right in terms of Regulation 21. And now, my lord, that is exactly.
So that is your stand recorded also. That they have not exercised their right under 21.
It's exactly the reason why, my lord, I say I have proceeded in terms of the liquidation regulations. My lord, I have proceeded by holding. My lord, the suit was prior in time. So naturally, my lord, I am contesting that particular suit. In fact, my lord, the sales memorandum as well in the auction sale, that goes on to record, my lord, that there is a dispute insofar as these 77,500 shares are concerned. So that is exactly the reason why, my lord.
But then why did you take that stand that this should become a part of the liquidation estate? The moment you say that, it becomes it goes within the hotspot of that.
No, that is exactly the reason why, my lord, a specific provision. That is why, my lord, the sale has been made on as is where is whatever there is basis. Because we cannot go into the title, my lord, whether the share has passed on to the pledge, my lord, which was.
Achha, this sale was only regarding the shares.
Yes.
So the damage is limited to the shares.
And he's also
the purchaser will be the sufferer ultimately.
Shifting exactly, my lord, he will be implicated in the suit nonetheless.
He is knowing fully well his purchase.
And he is aware of it because the sales.
Take the risk or the purchase price will be less.
Yes.
So you also put in one or two pages.
My lord, I have to,
why? No, because your stand has to be clarified, which you have done right now. So put that on paper also, because I'm not inviting affidavits to cut short the matter.
No, 26 lakhs, my lord, everyone, including my lord.
26 lakh everyone is.
And on the shares, not on the land. I'm very happy, my lord, if now Sony says it's on the land.
No, 26. Their review application, they.
No, my lord, it's the my lord shares.
They have said in the review application that.
No. In the
only 26
in the review application, they've only said you are a secure.
But we'll get that it is regarding the shares.
My lord, that's one of the stand of the suspended board as well. It was the previous loan, my lord, which was left over, and that is what they are admitting. I'm saying no, sorry, the next loan also comes.
Oh, you said that is the previous loan.
Yes.
Well, that is exactly the bone of contention where we say that the next loan is not secured.
Correct.
But the 26 lakh is regarding the previous loan that you are saying.
That is previous. That is
Yes.
previous.
So I'm saying I'm a secured creditor.
And my lord, in fact, that
There's nothing wrong
26
with that.
lakhs, relates, my lord, to the interest component. And
Yes,
that is
that's
exactly
whatever
the
it is.
reason.
Correct.
Right,
Correct.
right.
That's
What
the
relates to
plan.
the
Well, that 26 lakhs, 10.2 crores
Achha.
was the initial, the interest component was 26.
Although the first loan of 5 crore 31 was never returned
was-
fully.
Yes.
So whatever
But that
interest,
didn't-
yes. While it was pending, my lord, further loan was taken. So we said the security continues for that.
The further loan was given without any without taking any further security.
Without taking any further, because those security was already existing.
Oh,
With us.
then
we never returned the
then you
security.
may have a strong case. If you never returned the
yes.
security, then did not take any further security. Anyway, that will be decided in the
That is right.
suit. Very well. Oral arguments are concluded. Fussa, learned counsel for the petitioner files a brief written notes of arguments and copies of judgments which he cites, which are kept on record. Fussa. The respondents shall file the written notes of arguments on Friday. You can do that. On the next.
My instructions are if it could be on.
I'll keep it on Monday.
Only for the notes.
Notes.
My presence, my lord, is not.
On the next returnable date, Fussa, the matter shall be placed for hearing at the top of the list on March 11, 20. Under the heading to be mentioned for the purpose of filing of written notes of argument.
Well, there's only one more indulgence that I'll be seeking. Well, I have not been made over favored with any of the copy of the judgments or whatever the written notes which has been filed by.
I also have not got a copy.
Seen my learner friend first time actually.
No, I have been there throughout.
My lord, if a written notes copy, my lord, is also given.
Yes, sir, I will give it.
Yes, please exchange all copies and at least give the citations to him.
The citations has been handed over and I will hand over to you.
Liquidate it. So that he can liquidate your claim.
Yes, my lord.
May I be permitted to mention a matter?
This matter is over.
I'm
yes.
great.
Yes.
Lordship, AD 37 of today's list, which was a fixed matter. Lordship, I beg to appear for the respondent. I had filed my written notes, but as Lordship may recall, there were some discrepancies between.
So that matter is appearing for further hearing.
Lordship has reserved the order. We had filed our written notes, but there were some discrepancies between.
Reserved order, why is it appearing then?
Lordship, AD 37.
Appellate side.
Yes, Lordship. Lordship, just the.
Might have dictated the order. I cannot take right now. What is the matter?
Lordship, Shishir Das versus Indian Oil Corporation. The tank trucks matter, Lordship. ATF.
Concluded today?
Yes, Lordship.
Oh, that matter.
Yes, Lordship. The revised written notes may only be taken on record.
ওটা কি পাঠিয়ে দিয়েছো?
Because the page numbers were not matching Lordship with Lordship's brief.
You just write over it, revised written note or something so that I can understand, or latest written note or whatever that I can understand.
Yes, Lordship.
এটা পাঠিয়ে দিও. Good.
Obliged, Lordship.